Good morning, and thank you for joining us for the live stream of the Aurora Theater shooting trial. We are on day 42 now, and I'm Kelly Patterson. As always, we want to thank all of you that join us and chat along as we continue our coverage of the trial here. So if you watched yesterday, maybe you didn't, we're going to recap you a little bit on what happened as we wait for trial to start today. So we heard from Dr. Rose Manguso yesterday. She's with the Colorado Mental Health Institute in Pueblo. She evaluated the shooter several times after the shooting. So she talked a little bit about her thoughts on him and his condition. So we're going to run some sound from her for you in just a little bit. You're also going to hear a little bit from the end of the day yesterday where they rewatched the video. They spent about an hour doing this, watching the video of him after he was arrested, the shooter, with the paper bags on his hands. We should also mention if court does start while we're recapping you from yesterday's sound, we will take you there live. So for now, though, we want to send you out to a recap of yesterday, starting with Dr. Rose Manguso.
And what did you make of that? That he denies experiencing hallucinations, but then something comes up in the test and you ask him about it and he says, "Oh, I did experience auditory hallucinations."
Well, again, to me, and in my clinical impression in working with him, was he was holding back and not talking about some of his symptoms. I mean, he wasn't one of these people who comes in and says, again, let me tell you what's wrong with me, doc. I want to go through my list of problems to be sure you get it down right so you can write it in your report. It was the opposite. He would respond very minimally, and I think was underreporting some of his issues.
Okay. So not necessarily saying all of the symptoms that he may have been experiencing.
That was my clinical impression, just because he was reticent in general.
Now, did you ask him about thought content consistent with a delusion?
We did.
And I think we know what a delusion is now, fixed false belief, is that right?
That's right.
Did you ask him about any delusions that might be contained in the notebook or that happened before July 20th, 2012?
No, we focused on the more recent time frame, from November of 2012 approximately, up into and including the present time.
Did he report any thought content consistent with delusions in your opinion?
Yeah, there were a few things. May I refer to my report?
Yes, ma'am.
Okay, what he told us was this, that before starting treatment with the Risperdal, and again, we're referring to that immediate period right before, he thought that the television was broadcasting special messages meant only for him, although he doesn't recall the content, and that his thoughts were being broadcast outside his head so that others could read his mind. He stated that after starting the medication, he no longer believed those things to be true. He said that both at the time we saw him as well as prior to his time of treatment with risperidone, he did not believe he had special powers or that any entity was trying to plant ideas in his mind against his will. He denied, both previous to the risperidone and when we saw him, that he denied that he thought he was being persecuted or that he had a special mission in life that others did not understand.
Now, I noticed that in your despite the fact that your handwriting, consistent with other doctors, seems to be difficult to read.
I'm sorry.
Do you go through a kind of a form as you ask these? Is that a form that you created to help you?
It's a form actually Dr. Gray created, and we've all modified it over the years. We find it to be a helpful mental status examination form at the hospital.
So these kind of questions, special powers, an entity trying to plant ideas in your mind, are those kind of items that you have on your little form there?
Right, and it's not meant to be like a grocery checklist when you're interviewing someone, because people don't necessarily want to talk about things in order. You have to take the interview where it leads. But where it's very helpful to have a form like that, because you make sure you don't forget something. If you've talked at length about one issue, you can go back and say, oh, I didn't ask him about, any thoughts of being persecuted, and you can go back and make sure you did that. And so that is how that form is typically used.
Thank you. Now, overall, based upon your clinical interview, based upon the testing that you performed and your work with Dr. Gray, what was your overall impressions and conclusions and answers to the question that you were asked to answer?
My conclusions as a neuropsychologist was that he had subtle dysfunction, as I've explained previously. My conclusions as in reviewing Dr. Gray's data along with talking with Dr. Gray and looking at those results was that there was evidence of mental illness.
Okay. Did that evidence of mental illness, in your opinion, include marked depressive symptoms, anxiety, and a proneness to psychoticism?
Yes.
How about obsessive compulsive behaviors?
Yes, though you'll have to ask Dr. Gray about that piece further. I can't remember what those I know he had a history of hair pulling. That might have been it.
Okay.
I can't remember right now.
But the others you recall?
Yes. Couldn't problem solve, pretend he couldn't pay attention when he could. His validity tests were clean. He was giving really reasonable effort, good effort on all my tests. And then that was what those validity tests were limited to, the thinking skills tests.
So those tests have nothing to do with whether or not when he's answering your questions, Dr. Gray's questions, or any of the mental health professional questions in here, if he's being honest, candid, forthright, accurate, none of those things.
Right. Well, in adding to that, there were tests that Dr. Gray gave that had validity indicators that would address that, but mine, not really. I mean, it would just be a general description of how he was doing on thinking skills tests.
And you've already told us that's not none of these things are foolproof tests.
Oh, of course not. No test is foolproof.
I'm going through my stickies here.
Of course.
A couple other things. You ended up speaking with Mr. King about the actual interview that you did with the defendant. Do you recall that?
I do.
There are some observations that you made, and these observations you said were psychologically important to you.
Yes.
One of those things that you touched on was grooming, correct?
Correct.
And it is one of the hallmark signs, although it's not required for everyone, that someone who has a certain type of mental illness, as you said, kind of gives up on themselves, stops caring about their personal hygiene, stops caring about how they look, how they appear, all that stuff, right?
Right, that can absolutely happen.
And that did not happen with the defendant, correct?
Not when we saw him.
And you have no idea whether or not that was consistent from well before you saw him.
I don't.
Also, his speech patterns and his manner of answering, you've talked about that, right?
Right.
And that could tell you some things about potentially some sort of mental illness, potentially, yes?
It could.
And one of those potential mental illnesses that might be implicated by that could be things like schizotypal personality disorder.
Certainly, that could.
Any of the things you referenced in your report, correct?
Could as well.
In fact, in your potential diagnoses, one of the things that you indicated was not just that you thought it could be I think it was schizoaffective or schizophrenia with a major mood disorder, but one of the things you said is, look, this is a bit complicated, because this could be a personality-driven issue, right?
We brought up personality disorders, absolutely.
In fact, one of the other things that's referenced in there is the potential, the whiff of narcissism. Do you remember that?
I do.
And you, to be fair, this is not a criticism, you don't know if the way the defendant answered you and dealt with you was the way he'd been answering and dealing with people for years.
I can't say that I do.
There were some specific questions that you asked him, and one of them was, hey, what are you doing for your free time? Remember that?
I do.
And is that just an icebreaker, or is there some reason to try to find out what he's doing?
No, I want to know what people are doing when I evaluate them, when I test them, if they're going to give a testing performance that is inconsistent with how they're occupying themselves when they're in their downtime.
And he told you that he was watching movies,
Correct?
And reading The Hobbit.
Correct.
Now, one of the things that may have come up, I can't remember with Mr. King, is the movie selection at CMHIP is a bit limited.
Yes, by design, it's quite limited.
Yeah, only G-rated movies, correct?
Right, I think there might have been a PG one in there
Whoa.
too. Whoa, I know, but yeah, they limit those. They certainly don't, go to Redbox and get any old thing. There's certain things that they don't allow.
And you understand from your questioning with him that prior to being incarcerated, he'd pass the time by playing video games.
This is the case of the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Higgs, and Ms. Spengler. And the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Edson, and Ms. Stitch McGuire. And we are outside the presence of the jury. Are the parties ready for the jury?
Yes, Your Honor.
Ms. Brady?
Good morning, Your Honor.
Good morning.
The first witness we're calling this morning, her name is Tara Fournier, Fournier. And that's the witness, Ms. Teach McGuire raised the issue, can't
Yeah.
remember if it was earlier this week or whenever.
It was 2 days ago. She's the trainer/recruiter from Marical.
Correct. And the court ruled that Ms. Fournier could not say that she thought Mr. Holmes was autistic. I was thinking about that issue in preparation for Ms. Fournier, and I feel like I should tell the court, Ms. Fournier has 2 sons who are autistic, and so this is the basis of her knowledge. And then when she was working with Mr. Holmes, she recognized symptoms that she thought looked like things she sees in her son. So I was wondering, A, if we establish that, whether that changes the court's mind, or B, whether she could say, at least say that she has 2 sons who are autistic, and when dealing with Mr. Holmes, it reminded her of dealing with her sons, the sort of vacant look, the non-responsive, non-eye contact, and those type symptoms. So I was wondering if I had any more leeway with that witness than what the court had previously ordered.
Whose witness is it on the prosecution side?
Your Honor, the fact that Ms. Fournier has 2 sons who are autistic doesn't change the fact that this is expert testimony. She's not qualified to render an opinion about whether or not the defendant, is autistic. And so I agree with the court that she could talk about her observations and the fact that he was introspective and shy, perhaps, but she's absolutely not qualified in any way to render an opinion that he's autistic. And also, Your Honor, when I had originally made my objection, I had also stated, that the people object on relevance grounds. And the court limited the people to a period of time where we could go into the defendant's past. This is way outside the scope of what the court limited the people. And so I don't understand the relevance.
Well, the relevance as to the time frame is untimely because there has already been evidence about this without objection. So I'm not sure I understand that objection at this time. The people have not raised any issues at all about this time frame or evidence related to this time frame being brought in. In terms of the other objection, I sustain the people's objection that it would be improper to allow this witness to opine that she thought Mr. Holmes was autistic and that her opinion was based on the fact that she has 2 sons who are autistic. I thought that was improper expert opinion testimony. This is different. This sounds like the defense wants her to testify that she observed some behaviors in Mr. Holmes that are consistent with behaviors that she has observed in her children, and that her children, she has knowledge that her children have been diagnosed as being autistic or with autism. That's as far as she can go, and I take Ms. Brady's request to go into exactly that. I think that's appropriate, but to go beyond that and offer any opinions that therefore she thought the defendant might have been autistic or anything like that, I think would be improper. Does that make sense? She can testify about her observations, and she can say, I observed his behavior, and his behavior was similar to the behavior that I observed in my children, and I'm aware that my children are diagnosed with autism, but she can't go beyond that, all right?
Yes, sir.
Okay, is there anything else before I bring the jury in?
No, sir.
Okay, let's bring the jury in, please. Please be seated, everyone. Good morning, members of the jury. How's everyone doing? Good. Just a scheduling note to start off. On Monday, July 6th, that's next Monday, we're going to start at 9 o'clock. One of you has an appointment, and so we're going to accommodate her schedule. So we'll plan on starting at 9. It's possible that she may be a little late and we may have to start at 9:05 or 9:10, but I think it's best to have you plan to be here by 9. Usually you get here around 8:15, 8:20 or so you can sleep in a little bit. You should still get here before 9, so that we're ready to go at 9 in case the one juror is able to be here by 9, okay? So maybe plan to be here around 8:45 or so, if that's okay with everyone. All right, great, thank you. All right, Ms. Brady, call your next witness, please.
Your Honor, we called Tara Fournier.
Good morning. Good morning. Could I have you raise your right hand so that I can administer an oath?
Yes.
Do you solemnly swear or affirm the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Please be seated.
Thank you.
Please tell us your full name for the record and spell your first, middle, and last names.
My full name is Tara Ann Fournier, spelled T as in Tom, A-R-A, A-N-N-E, F as in Frank, O-U-R-N-I-E-R.
Good morning.
Good morning.
Can you please tell the jury where you worked in late 2010, early 2011?
Sure. I worked for Marical.
And what is Marical?
Marical is a vitamin and nutritional supplement manufacturing company.
Where is it located?
The headquarters are in Orange, California.
Did you have an opportunity to meet James Holmes?
Yes, I did.
And do you recognize him here at the table?
Yes, I do.
Can you explain to the jury how you came to meet Mr. Holmes?
Yes, I was in HR for Marical at the time, and I was doing recruiting and HR generalist work, and Mr. Holmes was coming to work. He was applying for a position, a temporary position.
And how did you very first meet him?
I very first met him when he came in to interview for a position.
Did you do the interview?
Yes, I did.
And did you, tell the jury what your observations were of Mr. Holmes at that time?
Sure. He was dressed very professionally. I remember specifically he was dressed in a button-up shirt and a tie. He was a little bit different, but he was able to answer all the questions and he fit the bill for the position.
And did you hire him?
I did hire him.
And what was his job at Marical?
He was a coding operator.
And what does that entail?
So a coding operator is when the vitamins and the pills were being manufactured, if there was a certain color or a certain texture that the pills needed to be, he was in the department where he was overseeing that process and making sure that the pills were colored according to the customer specifications.
Okay. And did he come in through a temp agency?
Yes,
Did you have any other interactions with Mr. Holmes?
yes.
Can you describe those for the jury, please?
Sure. I interacted with him during his interview process, during his onboarding, so we had to train in order to get him up to speed for the position, and then also with an HR issue that occurred.
How long do you think you spent with Mr. Holmes in the interview process?
Probably about 30 minutes
And
would be a
how-
guess.
Okay. And how long while you're training him and getting him acclimated to the lab?
That would have been probably more like 2 hours.
All right. And then you said you also had some interaction with him during an HR issue?
Yes.
During these interactions, and we'll talk about that issue in a minute, but
Okay.
during all of your interactions with Mr. Holmes, what sort of impression did you have of him? What did you observe about him?
I observed him a little bit different
How so?
than others. It's hard for me to put it into words. I guess he reminded me a lot of my children. He was very just, he seemed like he wasn't all present all the time. I mean, not that he was not intellectual or intelligent, but just that he was in another place.
And why does that remind you of your children?
My children have some special needs.
And what is that special need?
I have two children, and my older son is diagnosed with Asperger's, and my younger son is diagnosed with autism.
And so what sort of things did Mr. Holmes do that reminded you of your children?
He did not make eye contact with people very easily or with me, and he just seemed very socially awkward and just in another, I don't know how to explain, but in another place. Like his mind was not always present.
Did
It
seem
appeared.
did it seem like he was just bored and shy, or did it seem more than that?
No, I wouldn't say bored and shy. I wouldn't say that.
Okay. Did he start up conversations with anyone that you saw?
Not that I observed.
Okay. Did he socialize with other employees?
I don't know. Not to my knowledge.
All right. And if you could just briefly explain what sort of interaction you had with Mr. Holmes during that HR issue, that human relations issue that you mentioned.
Sure. So while he was working in the coding area, it's a small space, and there's usually two people that work in the coding area and then a quality control person that comes in and out. And there was an issue where the quality control person felt that James was working too slowly and was prodding him to work more quickly. And one of the other employees stepped in and told the quality control person to stop, and it created a confrontation with some racial slurs.
Okay. Did the racial slurs have anything to do with Mr. Holmes?
No,
Not
no.
the victim or the perpetrator of the racial slurs, correct?
no, just a witness.
Okay. And so when you, what sort of interaction did you then have to have with Mr. Holmes regarding that issue you were investigating?
Sure. So whenever there's an issue, we would bring in anyone that had knowledge of the incident. So I brought him in and asked him some questions to clarify what had happened that day.
Okay. And the jury has heard from David Maldonado and Jose Sanchez. Were either of those two men involved in this incident you're describing?
No.
All right, so they were two completely different people.
Yes.
All right. What was your observation about the way Mr. Holmes presented when you were talking to him about the incident?
He had very little to say about it.
Okay.
He answered questions very briefly, but really seemed to have no knowledge of what had happened.
Did he give any sort of narration about what happened, or was it just basically answering your questions?
Basically answering my questions. Mhm.
And during that conversation, did he make good eye contact with you?
Not that I recall, no.
Was he ever rude or arrogant that you saw?
No.
Was he polite and nice?
Yes.
If I can have just a moment.
Yes.
Thank you, Ms. Fournier. The prosecution might have some witness
you.
questions for you.
Thanks.
Cross-examination, Ms. Stitch McGuire.
Good morning.
Good morning.
It's true that you had not met the defendant prior to his employment at Miracal prior to 2011. Is that true?
Yes.
And your interactions with the defendant were brief, potentially 3 to 4 hours over his entire term of employment at Miracal. Is that fair to say?
Yes.
And you have not had any interaction with the defendant since his departure in January of 2011.
Yes.
And realizing that your interaction with the defendant in 2011 was a year and a half before the defendant was charged with the murders of 12 individuals and the attempted murders of 70 other individuals.
I'm sorry, say that again?
Your interaction with the defendant last interaction in January of 2011 was over a year and a half before this defendant was charged with the murders of 12 individuals and the attempted murders of 70 more.
Yes.
And your interactions with the defendant consisted of his initial hiring interview.
Mhm.
Are people often nervous?
Hold on. Is that a yes?
Yes.
Go
Sorry.
ahead.
Thank you, Your Honor. Your interactions consisted of his initial hiring interview. Are people often nervous during an initial interview?
Some people are nervous.
And the other issue was an HR investigation.
Yes.
Are people often nervous during an HR investigation?
Again, some people, yes.
And you're not a psychologist,
No.
not a psychiatrist.
No.
And what is your profession currently?
I'm in human resources.
Now, when you interacted with the defendant, did he appear to understand everything you said?
I believe yes.
And you thought the defendant was qualified, if not overqualified, to attain the job at Miracal when you hired him?
I believe he was qualified, yes.
Do you have very many applicants for this type of position with someone who is cum laude graduate of the University of California at Riverside?
Not specifically, no.
And you specifically looked for characteristics in the person you were hiring because you had had some employment issues with other employees at Miracal, so you were specifically looking for someone who would keep their head down and do a good job. Is that fair to say?
Yes.
So in the midst of the drama that was caused in this racial incident, didn't the defendant do exactly what you had hoped that employee in his position would do, which was to keep his head down and to not get involved in any of the drama?
I would say yes, but I also would say that in an investigation, we would expect them to cooperate and provide information relevant to the investigation.
And did he cooperate?
He did.
And in fact, you're not even the HR director of the facility where the defendant was located. Is that fair to say?
Yes, that is correct.
So there was an HR director who would have had more opportunity to interact with the defendant at Vista, which is the facility where he was actually employed.
Actually, there's no HR director in the Vista facility. It was an HR assistant.
But there was an HR assistant there at the Vista facility.
That is correct.
And you were located in the Orange County facility.
That is correct.
I have no further questions. Thank you, Your Honor.
All right, thank you. Is there any redirect?
When, just briefly, Your Honor, when Mr. Holmes was giving you just those short answers during the investigation, did you get the impression he wasn't cooperating, or whether he just, as you had seen before, he just didn't have much to say, he just didn't talk a lot?
He just didn't talk a lot.
Okay.
Yeah.
Thank you. I don't have anything else.
Ms. Teach-McGuire, do you have any recross?
No, thank you, Your Honor.
All right, and the jury does not have any questions for this witness. May this witness be released from her subpoena?
Yes, sir.
Any objection?
No, thank you, Your Honor.
Ms. Fournier, thank you.
Thank you.
Call your next witness, please.
Dr. Robert Hanlon.
Doctor, good morning.
Good morning.
Do you solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, please be seated. Please tell us your full name and spell your first, middle, and last names.
Robert E. Hanlon, Robert, E for Earl, Earle, Hanlon, Hanlon.
Mr. King, you may proceed.
Thank you, Your Honor. Good morning, Doctor.
Good morning.
How are you?
Fine, thank you.
Doctor, how are you employed, sir?
I am employed, I'm employed as a clinical neuropsychologist. I'm employed as a part-time basis as a consultant by Northwestern University Feinberg School of Medicine and Northwestern Memorial Hospital. And I'm also employed in my own practice, which is called Neuropsychological Associates of Chicago.
Okay. Were you present during the testimony of Dr. Rose Manguso yesterday?
Yes.
So you heard her description of what a
neuropsychologist is, fair to say?
Yes,
And she was, I believe, testified that she was a board-certified clinical neuropsychologist, or excuse me, forensic neuropsychologist. No, I'm getting it wrong. She testified that she was a board-certified clinical neuropsychologist and a forensic psychologist. How do your board certifications differ from that? Are you the same as she, a board-certified clinical neuropsychologist?
yes, I'm a board-certified clinical neuropsychologist.
Okay. Are you also a licensed psychologist?
Yes,
And as such, are you authorized to administer both neuropsychological instruments and psychological testing or instruments, like, for example, the type of personality testing that Dr. Gray administered in this case?
yes,
You are not a board-certified forensic psychologist, though, is that correct?
that is correct. I am not a board-certified forensic psychologist.
And why is that, sir?
I have not chosen to pursue that type of board certification. I'm a clinical neuropsychologist, and that is my area of specialization.
Okay. Is that because you've chosen to pursue other areas? It sounds like Dr. Manguso works at the State Forensic Hospital and does a lot of, much of her work with forensic patients, and that was her testimony about why she underwent that board certification. What was your line of thinking? I mean, is it something you could go do if you wanted to do that?
Yes, certainly. I could pursue board certification in forensic psychology if I chose to. I have opted to spend my time and focus my career on conducting forensic research and teaching at a medical school in which now I do teach a course in forensic neuropsychology.
Okay. And is there even a such thing as a board certification in forensic neuropsychology?
No, there is not.
And so if you specialize in neuropsychology, there's no way to get some kind of forensic board certification for that?
Not that I'm aware of.
Okay. So what can you do if you specialize in neuropsychology in order to, you said you teach forensic neuropsychology at the medical school that you work at?
Yes, I teach a graduate course titled Forensic Neuropsychology and Psychology. I teach to graduate students in clinical psychology. The course is also available. Other psychiatry residents can take it. Forensic psychiatry fellows can take it. Neurology residents can take it if they choose to.
Okay. And I want to talk a little bit more about the types of actual clinical work that you've done and the experience that you have a little bit later. But first, can you tell us what other responsibilities do you have in your current capacity at the medical school? And what medical school is it again? Northwestern?
Yes, I'm at Northwestern University Medical Center in Chicago. Currently, I'm a senior neuropsychological consultant with the inpatient neuropsychological consultation service at Northwestern University Medical Center. It's approximately 1,000-bed inpatient medical center, and that my service conducts neuropsychological assessments on inpatients throughout the medical center, primarily inpatients that are referred from the Department of Neurology or Neurosurgery or Psychiatry or Internal Medicine or Geriatrics, et cetera. And I used to be the director of that service for 17 years. A couple of years ago I pulled back, and now I'm on that service about 1 week per month. And so I'm still actively involved in that service. I also periodically conduct neuropsychological evaluations in the forensic division of the Department of Psychiatry at Northwestern University Medical Center. And then the rest of my time is spent in my own practice, either seeing clinical outpatients for neuropsychological evaluations or neuropsychological consultations, or taking referrals from attorneys or the court or insurance companies to do forensic neuropsychological or psychological evaluations.
Okay. In this service that you described at the hospital at Northwestern that you did for a number of years, large number of years, and you pulled back a little bit, did you in that capacity get referrals to do neuropsychological workups from all different types of doctors in that hospital?
Yes, my service would take referrals from any physician within the medical center, and that included a very diverse group of medical specialties and referrals for various reasons. But the lion's share of those referrals came from neurosurgeons, neurologists, psychiatrists, and internal medicine.
Okay. Suffice it to say that there could be a number of different reasons that different doctors might want to have this work done, not just in the context of psychiatry necessarily. Is that fair to say?
Yes.
Can you give us an example of a type of referral that you might get that wouldn't be from a psychiatrist, for example?
Oh, certainly. Referrals from neurosurgery with patients with brain tumors, who are being referred for an evaluation prior to surgery to resect their brain tumor in order to determine what their neuropsychological status is prior to the surgery. Patients with stroke referred by a neurologist, for example. Patients with various types of dementia, Alzheimer's dementia, vascular dementia, frontotemporal dementia, for example, referred by internal medicine docs or various other specializations. Also take referrals from transplant services to determine what the mental status is of an individual that is a candidate for an organ transplant, heart transplant, for example, liver transplant. Those are some examples.
Okay. Did you hear Dr. Manguso's testimony yesterday where she said that when I asked her to compare the work that she did at the Spalding Rehabilitation Hospital and at the Colorado Mental Health Institute at Pueblo, a clinical versus a forensic setting, in terms of applying or administering these neuropsychological tests that you do you agree with her testimony that you basically do it the same way, no matter what discipline the referral comes from? Is that fair to say?
Yes, the tests are. I mean, there's a large number of neuropsychological tests that are available to use, but there is a standard administration protocol that you must adhere to in order to generate a valid test result. And so, yes, in answer to your question, yeah, the tests are administered in the same way, regardless of what condition the patient has or what the reason for the referral is.
And is that because you're basically looking at a pretty isolated issues with regard to their cognition, and that's really it? Fair to say, or?
Right. The objective is to determine objectively what the cognitive status of that individual is at that point in time.
Okay. I want to go through a little bit what kind of education you have to reach this position that you've reached. Do you have an undergraduate degree, and if so, what's that in?
Yes, I have an undergraduate degree from Indiana University in occupational therapy.
And did you then get a PhD?
I did get a PhD. I had 2 master's degrees prior to the PhD. I achieved a PhD in psychology from the City University of New York.
Tell us about the master's degrees, please, sir.
My first master's degree was from Southern Illinois University in rehabilitation counseling, and then my second master's degree was in psychology from the City University of New York, en route to the completion of my PhD.
Why did you then decide to go on and get the PhD?
Because that was part of my academic and professional plan from when I was in high school. So it was just a number of steps along the way in previous degrees in order to prepare me to pursue doctoral level education in neuropsychology.
And what did kind of, how long did that doctoral training take, the PhD, for you to get your PhD?
It took between 4 to 5 years.
And did you do some kind of postdoctoral training, or
Yes.
where did you go from there?
Sorry. Yes, I then completed a postdoctoral fellowship in clinical neuropsychology at UCLA Medical Center at the Neuropsychiatric Institute at UCLA in Los Angeles.
And what kind of employment have you had? You've had a number of different jobs, but can you run through what your various employment has been following your postdoctoral training?
Certainly. After I left UCLA, I took a position as chief neuropsychologist at the Baylor Institute for Rehabilitation at Baylor University Medical Center in Dallas. And I was in that position for approximately 3 years. At that point, then I was offered a position as director of neuropsychology in the Department of Neurology at Washington University Medical School and Washington University Medical Center in St. Louis. And I then moved to St. Louis and worked in that position then for, again, approximately 3 years. And then at that point, I then was offered a position as the director of inpatient neuropsychology at Northwestern University Medical Center and academic appointment at Northwestern University Medical School.
Okay. Were some of those previous appointments also teaching appointments?
Yes.
Where did you teach at?
Yes, I taught a course titled Clinical Neuropsychology at the University of Texas Southwest Medical Center Medical School in Dallas while I was while my clinical position was at Baylor in Dallas. Then I was a assistant professor of neurology and neurologic surgery and psychology at Washington University School of Medicine. And then when I went to Northwestern, initially I was assistant professor of psychiatry and neurology. And then a few years after I was at Northwestern, I was then promoted to associate professor of psychiatry and neurology, and I've remained at that academic level since then.
Okay. Assistant to associate, do you have plan? Is there something higher than that? I don't know.
There is one academic level above that, which is professor, or what's often referred to as full professor. I've not applied to date for that appointment. I will, and I will probably do that within the next couple of years.
Now, in the course of these various positions that you've held at the various institutions, have you also engaged in research as well, and if so, into what areas?
Yes. Earlier in my career, when I was at UCLA and Baylor and also at Washington University, I focused on neuropsychological aspects of what's called in my field focal lesions in adults, and that typically involve stroke and brain tumor, but also I focused on more diffuse brain injuries that at that point the research focused on traumatic brain injuries. And so that was the research focus during the early course of my career when I was at those institutions, and did a number of studies and published many empirical research articles on those topics. Also looking at recovery of cognitive function following these different types of brain damage, and also with kind of a rehabilitation focus. After I went to Northwestern, I continued with my interest in research in traumatic brain injury, but started to focus more on aspects of the neuropsychology of violence, and then that then evolved into my current research agenda, which I am the director of the Forensic Neuropsychology Lab at Northwestern Medical Center, and our focus is, one of our primary research focuses is looking at neuropsychological aspects of violent criminal offenders.
Are there other doctors there that are then part of your program conducting research in those areas and other similar areas?
Yes.
And this jury has heard some because of Mr. Holmes' matriculation into the University of Colorado, has learned some about how that graduate program works with regard to neurology. Do you do a similar kind of thing there, where you would apply for grant money and get the grant, write the grant and get the grant money, and then actually set up a study or something, and then do the study and then publish the findings of the study afterwards? Is that how the process works, generally speaking?
That is the standard process of research in academia, is applying for funding, trying to obtain funding, acquiring funding, and then conducting studies that are based on the application of that funding.
And then the publications that you then issue at the end, are those peer-reviewed publications?
Yes.
And what is a peer-reviewed publication?
A peer-reviewed publication is a publication which the process is as follows. You write a manuscript describing the intent of the study, the methodology of the study, the results of the study, and your interpretation of that study. That then is submitted to a peer-referenced journal. And then that manuscript then is reviewed by at least 2, if not 3, if not more, members of the editorial board of that journal. And they determine whether it's a good fit for that journal, whether it's acceptable, whether it's good research or not. And then they provide feedback and usually criticisms about the study and how the manuscript may need to be changed, or maybe what additional research needs to be conducted to enhance it. And then the authors then typically try to make those revisions and resubmit it, and then it's a back and forth, and eventually, most of the time, the manuscript is eventually accepted for publication in that journal, and then within a few months or a year or so, it is published.
How many? And have you also been published in other journal articles and things that may not necessarily relate to a specific study that you're doing, but may just be an article that you write about a certain topic that you have expertise in? Do you do that as well?
Yes.
Are all of your publications covered in, as well as the rest of your history and your current CV that you provided for us?
Yes.
Have you published any books?
Yes.
What books have you published?
Most recently, I published a book about a family mass murderer. The book is titled "Survived by One: The Life and Mind of a Family Mass Murderer," and it is I think it's a objective analysis of an individual who committed a extremely heinous multiple domestic homicide, family homicide, when he was 18. And it's a detailed analysis of that case and that individual.
Okay. Other books that you published?
Previously, I published a book. It's more of a theoretical book about cognitive processing. Many years ago, it was an edited book. I edited that book.
Okay. You also said that you have a private practice on the side in Chicago there, and you take referrals, you said, from insurance companies and lawyers and courts. Is that right?
Yes.
And what are those referrals to do? What are you asked to do in those referrals? Is there a variety of things? Are there a variety of things?
Yes, there are a variety of things. Some are disability evaluations, similar to what Dr. Manguso was referring to yesterday, what she used to do. And there are often referrals from insurance companies or case managers to determine the presence, extent, severity of disability of a given individual. There are also referrals from attorneys who work in the civil justice system, so personal injury attorneys, workers' compensation attorneys, both from the plaintiff side and from the defense side.
How about criminal cases?
And then also criminal cases, yes.
Have you been retained by defense lawyers then?
Yes.
Have you been retained by any prosecutors before?
I have not. I've testified for the prosecution on one occasion. I was not technically retained by the prosecution.
Okay. Have you been appointed by courts or asked by courts to conduct evaluations?
Yes.
How many times do you think?
I've been appointed by the probate court, judges in probate court in Chicago. I would say approximately 12 times, I believe.
Ever in a criminal case or no?
I've not been court appointed in a criminal case.
Huh? Have you been qualified as an expert in the field of clinical neuropsychology before and testified in that capacity as an expert?
Yes.
And how many times do you think you've testified as an expert, a qualified expert in that area in a court of law?
In a court general and not just criminal? In general, I think approximately maybe 48 times.
Okay. How many in the criminal? Do you have any idea?
In the criminal, I believe I've been qualified 27 times.
Okay. And was one of those times the time that you were called by the prosecution to testify?
Yes.
How many neuropsychological evaluations do you think you've done in your entire career, sir? And just a wild guess. No, not a wild guess. An approximation, an estimate.
I understand. Given the fact that over the course of my career, I've seen a very large number of inpatients, patients that are hospitalized, I would estimate that over a period of 23 to 24 years of seeing inpatients, I've probably either conducted or supervised neuropsychological evaluations of inpatients approximately 6,000 times.
Okay.
With regard to outpatients, again, over the same period of time, I would estimate 3,000 to 4,000 times.
Okay. Have you done neuropsychological evaluations of murder defendants before?
Yes.
How many do you think you've done?
I've done approximately 200.
Have you done neuropsychological evaluations of murder defendants who ended up being diagnosed with schizophrenia? And if so, how many?
Yes, I have. Approximately 30.
Okay. So it sounds like in criminal cases, you have been primarily retained by the defense. Is that fair?
Yes, I'm almost exclusively retained by the defense.
Is that by design, or is that just the way that it's kind of? Do you just take the cases as they come to you and decide if you want to work on it or not?
I do. I do take the cases and decide whether I think I am the best, a good person or the right person for that particular case or that particular attorney to conduct the evaluation. I've certainly offered my services to prosecutors in various jurisdictions, but they've not referred cases to me.
Okay. Now, I want to talk more about your later about your involvement in this case, but suffice it to say, in this case, were you ever asked to assess Mr. Holmes' sanity?
No.
Okay. Have you done that before, though? Have you done sanity evaluations before?
Yes.
And how many times do you think you've assessed someone's sanity?
I would estimate that in the context, the referrals that I get typically involve conducting a neuropsychological evaluation, and then attorneys often will ask, well, would you also assess fitness, or would you also assess sanity in the context of the neuropsychological evaluation you do? So the neuropsychological component is the fundamental reason for the referral to me.
Okay.
Typically, that's at least my perception of it. So in that context, with that preface, I would estimate that if I've conducted sanity assessments, I would estimate in terms of criminal defendants, not just murder defendants, but criminal defendants, probably 100 times.
Okay. How many mass murderers have you done neuropsychological evaluations of?
22 total.
Okay. And how is there does the FBI or someone else define what a mass murder is, or is there a definition of that?
There is a definition. There are two definitions that are used. The definition I think is the most widely used is that comes from the FBI. It's published in the Crime Classification Manual that's authored by John Douglas, who's a former FBI profiler, and that definition requires the murder of 4 or more individuals at a single location at a single point in time. That's how the FBI classifies a mass murder. There's also another definition that is out there and is in the literature. It was originally developed by a forensic psychiatrist named Park Dietz in 1986, I believe, which includes 3 or more victims at a given location at one point in time. So the 22 that I just mentioned includes individuals from both of those definitions.
Okay. I want to run through just once again, maybe a little bit more thoroughly, what are your current licensures, and what are your board certifications? So
Certainly.
that we're clear.
Certainly. I am currently licensed as a clinical psychologist in Illinois and also in Missouri and in Texas. And I am board certified as a clinical neuropsychologist and have been since 1995. I have no other board certifications.
Okay. And have you ever sought to testify in court and have a judge say that you were not qualified to testify as an expert in the area of clinical neuropsychology in the couple hundred times that you've testified?
No.
Judge, what exhibit are we up to at this point, if I may?
Defense exhibit,
Yes, sir.
91, I think. Did you say 91? Did you say 91? Yeah, 91. I remember 90 yesterday. D-TR-91.
I'm marking this D-TR-91, and I'm handing a copy to Mr. Brockler here. If I can approach
You
the
can.
witness, Your Honor. Sir, I'm handing you what I've marked as D-TR-91. Do you identify that?
Yes, it's a copy of my CV.
And is that an accurate copy of your most recent CV as far as you can tell?
Yes.
Does that contain everything you've ever done in your entire career?
No.
No. Is it an overview of your career and the publications and research that you've done?
Yes.
Judge, I'd move the admission of DTR 97.
I think 91. You meant.
91. I'll do 97 later.
All right, Mr. Brocker, do you have any objection to D-TR-91?
No, Your Honor, I do not.
All right, without objection, it is admitted.
And Judge, at this time, I would move to qualify Dr. Hanlon as an expert in the area of clinical neuropsychology under Rule 702 and Shrek.
Is there any objection, Mr. Brockler?
What dear, Your Honor?
You may.
Sorry. I'm gonna dump water on myself here.
Morning, Mr. Brockler.
I want to ask you that.
I apologize for that to the court and to you, sir. I'm sorry.
That's all right.
I want to explore some of the areas that you spoke with Mr. King about that provide the basis for the area of expertise you wish to testify in, okay?
Okay.
First thing I want to reaffirm, though, are a couple things. I can't remember if they were asked. You're not a medical doctor, fair?
That's correct.
And because you're not a medical doctor, you're not a psychiatrist, correct?
Correct.
And I guess that automatically means you must not be a forensic psychiatrist.
That's correct.
You're not a forensic psychologist like Dr. Manguso was, fair?
Correct.
And so that we understand, a forensic psychologist is someone who is applying the science of psychology, and I can't remember if there's medicine in there, to the areas of law that are covered in specific areas of law and questions of law that are covered in court, correct?
That's true.
It's not sufficient to just say, well, I'm testifying about psychology, therefore it's forensic, correct?
True.
Now, when we talk about testimony, Mr. King asked you some questions about for whom you've testified. Do you remember that?
He did.
And I want to make sure that we understand your experience testifying as an expert in clinical neuropsychology, okay?
Okay.
First off, it does not appear that you have been appointed by a court ever in a criminal case to provide your services. Is that fair?
That's true.
Tell us what probate is. You said you've been appointed by probate. What's that?
Okay. Probate is it's often referred to as one of the specialty courts, and it the primary focus of the probate court involves wills, and in terms of the the determination of the existence of a will, who are the heirs that are designated, whether the will is legal or not, and whether or not the individual that produced the will was mentally capable of designating where their assets should go. So in probate, the issues are typically ones of mental competency, and whether or not someone has a guardian or not, and whether they have what's called testamentary capacity, whether they are capable of understanding a will, understanding where their assets should go, et cetera. And those issues can come up when people, not just the elderly, or not people who are just demented, but also people with traumatic brain injuries, people who have intellectual impairment. There's a lot of different types of cases.
Thank you. None of those issues, of course, come into play in what you're going to do for us in this case. Fair?
True.
And to be clear, the issues that a criminal court deals with that you're aware of, at least in the area of mental health, involve competency, sanity, sometimes fitness, those types of issues. Fair?
True.
And you've never been appointed by a court to provide an opinion on those things.
Right.
Let's take a look, though, at you do have some testimonial history here on the criminal side, correct?
I do.
And you think you've testified how many times, sir, as an expert in a criminal case?
27, I believe.
27? Okay. This is what I have going off of the information that we have about you. And if I misstate something, you tell me that, hey, I don't think that sounds right, okay?
Okay.
I have down that you have testified in 2 criminal hearings that had nothing to do with murder, and we'll keep moving. There's more than that. I'm not just saying 2. There's at least 2 of these times you've testified were for hearings on criminal matters that were not related to murder or capital murder. Does that sound about right?
I think there's probably more than that, but that's, there are a small number of those.
When we get through these numbers, if you don't think it adds up, you can go ahead and look through the list you provided, and we'll get there.
Okay.
I have down that you have testified 3 times in criminal trials that don't have anything to do with murder or capital murder. Does that sound right?
Yes.
I have down that you've testified in about 6 criminal hearings on murder or capital murder cases. Fair?
Sounds right.
I have that you've testified 7 times in murder trials. Fair?
Sounds right.
And another 7 times in capital murder trials. Correct?
I believe so.
And capital murder, so that we're clear, is that one that could potentially carry the death penalty?
True.
All right. Now, I don't know what that adds up to, sir, but I've got about 25 or so. If there's a couple missing in there, you let me know. But that sounds about right, correct?
It does.
And it is fair to say that in every single one of those cases, and we'll get to the one you talked about with the prosecution, you have testified exclusively for the criminal defendant accused of the crime.
True.
Now, in the case where you said you testified at once for the prosecution, to be clear, you were not testifying against the defendant about his or her mental health, correct?
That's true.
So, can we be more accurate? And when you say, almost exclusively I testify for criminal defendants, can we drop the almost and make it exclusively?
That's fair.
For criminal defendants? And you said to Mr. King, hey, that just happens. I mean, I'd testify for anybody, but it's really just the criminal defense that's seeking my services. Was it something like that, or?
I think that was the exchange.
Let's talk about why it is that you may have been exclusively retained by defense attorneys. And before I do that, let's drill down a little bit more on that. Almost entirely, in terms of capital murder and murder, you are testifying for the public defender's office. Is that fair?
Yes.
And in fact, you're not new to the public defenders in this case, correct?
True.
You were hired previously by Miss Brady for another criminal case here in Colorado, fair?
Right.
Now let's talk about how it is that you come to be exclusively a criminal defense expert. Now your curriculum vitae that's been admitted into evidence, which I believe is Exhibit 91, correct?
Yes.
Here's what I've done. I've gone through and tried to figure out, and you've put in there the conferences that you've provided presentations at, fair?
Yes.
And in part, let's talk about the CV. You said it doesn't include everything that you do, but to be honest, It includes the things that you think are most important for people like this jury and this court to consider in weighing your expertise. Is that fair?
I think that's fair.
Okay. So along those lines, you've put down the conferences that you have taught at, correct?
Yes, where I've done a presentation, yes.
Lectures, let's
Yes.
say. And so I want to ask you about some of the groups that you've lectured to. Now, what I have down here is, and you really didn't start doing criminal work until about 2003. Is that fair?
I think I had done probably a couple of criminal cases before 2003. Yes, that's about the time frame.
Well, it's 2003 when you started to lecture for criminal defense organizations.
That sounds about right.
Okay, well, let's go through that. Since 2003, what I have down is you have provided 7 separate lectures for the Cook County Public Defender's Office. Does that sound right?
Sure.
5 for the National Legal Aid and Defenders Association, right?
That's correct.
Those are 2 big organizations for you, aren't they, Doctor?
Big organizations. Certainly the Cook County Public Defender's Office is a organization that contacts me and retains me on a regular basis.
A lot. And that relationship is important to you, isn't it?
It is.
And so is your relationship with the National Legal Aid and Defender Association. Would you agree with that?
Is it important? It's not as important. If they ask me to do a presentation, I usually agree to do it.
May I approach the witness, Your Honor?
You may.
Sir, I'm handing you, I'm sorry, Your Honor, may I approach the witness?
You may.
Sir, I'm handing you what's been marked as People's Exhibit 1258. Take a look at that, and if you recognize it, tell us what you think it is.
I believe this is my profile from the Northwestern University Feinberg School of Medicine website.
And you'd agree with me that that's what it looks like as far as you know today, as if I printed that off this morning.
Probably.
Okay, and that's your picture up there in the upper left-hand corner, right?
It is.
There is a space that is revealed called disclosures. Do you see that?
Yes.
And under disclosures, there are 3 areas to list: industry relationships, academic and other professional activities, and external professional relationships. Fair?
Yes.
Judge, may we approach? I have an objection.
Yes. Right, the objection is overruled.
Doctor, do you remember my last question?
The question was, what is this document?
No, sir, we'd gotten past that, and that's okay,
Okay,
because there was a break. My question was, there are 3 areas that are listed under the disclosures that you put on this profile. One is industry relationships, one is academic and other professional activities, and the third is external professional relationships. Do you see that?
Yes.
And that's all accurate, correct?
Yes.
And fair to say then that the, first off, I'm going to move to admit People's Exhibit, is it 1258, Doctor? Forgive me.
1258.
1258 into evidence, Your Honor.
Is there any objection, Mr. King?
So I would object as hearsay.
Mr. Brockler?
Your Honor, he's stated that this is his profile page, and he admits that the information on here is accurate and his.
I'll defer ruling on that. You can proceed with your questions.
Thank you, Judge. Sir, under academic or other professional activities, you list only 2. Is that fair?
Yes.
And those 2 are, go ahead and read them to us.
The 2 that are listed here are Law Office of Public Defender, parentheses, Cook County Government, close parentheses. Second, National Legal Aid and Defender Association, open parentheses, NLADA, close parentheses.
Thank you. So those 2 organizations we've talked about, you've also provided training to the federal public defenders, correct?
Yes.
And you've provided training to the Illinois appellate public defenders, is that correct?
True.
Let's drill down on what some of the training you provided these public defender organizations are. You have provided annual trainings on defending Illinois death penalty cases. You've done that before, correct?
Yes.
You've done it in 2005.
Yes.
You've done it 2 times in 2006.
Yes.
You did it in 2007,
Yes.
2008,
Yes.
2009,
Yes.
2010,
Yes.
and then you stopped teaching for that conference because they stopped having that conference, right?
They stopped having that conference because they no longer have a death penalty.
That's right. Otherwise, you've taught for the Defending Death Penalty Cases Conference 7 of the last possible 7 times you could have taught for, correct?
True.
Now, there's other conferences you've taught at. One is a conference called Everything You Need to Know About Handling a Death Penalty Case, correct?
Can you direct me to where that is?
May I approach the witness, Your Honor?
You may.
Must be old.
Sir, can I take a look at this? I don't wanna-
And for the record, Mr. Brockler, you're looking at his CV, is that correct?
Correct, Your Honor. I'm looking at DTR 91. Here it is. Right there. Thank you. Sorry.
Oh, it's a subtitle. Yes, that is correct.
And you've taught at a conference called Jury Persuasion for Life, a capital case training. 2008, sir. Take a look at that.
That's correct.
And that was a conference about for defense attorneys handling death penalty cases, right?
Yes, Cook County Public Defender.
Yeah. And then you've also taught recently at a conference called, another death penalty conference called Life in the Balance. right?
Yes.
That was also for criminal defense attorneys who handle death penalty cases, correct?
True.
What I did not see anywhere in your curriculum vitae were any conferences that you taught for prosecutors. Did you omit those from your CV?
No.
Because you've never provided training like this for prosecutors?
True.
You mentioned having done neuropsychological testing on 22 mass murderers. Do you recall that?
Yes.
You draw a distinction between mass murderers who commit them domestically, and what I mean by that is familial or people in the household, that sort of thing. There's a difference between that and other kinds of mass murder. You'd agree with that?
Yes.
Of those 22, how many were domestic?
Can I look at my records?
Yes, sir, if that will help you remember. And all you have to do, doctor, if you would, is tell us what you're looking at, and we'll just put it on the record. That's fine.
What I'm looking at is a this is a handwritten list of mass murderers whom I have conducted neuropsychological evaluations of over the years. And from my memory and looking at this list, 10 of the 22 were domestic homicides.
So 12 were not domestic?
Yes.
And give us a sense of what the breakdown is if there's anything else about those 12. We've got domestic for 10. Are the 12 just other, miscellaneous? What do we do with those?
No, I think they are they're classifiable.
Tell us what those classifications are.
2 are gang-related mass murders.
That's not applicable here. Fair?
True.
Okay.
At least 2 are revenge-based mass murders.
Also not present here. Fair?
True. Four, I believe, would be, I'm blanking on the term right now, I'm sorry. They are mass murders that are committed in the course of committing another felony crime, such as robbery, home invasion, that type of thing.
Not present here.
Right. And the others then, there are a couple that are sex-driven crimes.
Couple meaning 2, 3, 1?
Two maximum.
Not applicable here. Fair? That's true, right, doctor? That it's not applicable here?
True, yes, sorry.
Sorry.
Do you have the tally?
That adds up to 10 by my count.
I'm still missing two.
Maybe.
I think probably one of the other ones is also a felony, what's classified as a felony murder, meaning that it was a mass murder committed in the context of another crime, which is a robbery.
Fair to say we can bump that 4 up to a 5 then. That puts us at 11. We got one left.
Exactly. And then the one that remains is a crime that involved the murder of a woman and her 2 children in order to cut a fetus, a 9-month-old fetus, from her because one of the offenders wanted another baby. And I don't really know how to classify that.
Understood. It sounds like, though, between domestic and these other specific motive-related crimes, whether it's gangs, revenge, other felonies, sex, or this last one that you talked about, you have not ever done a neuropsychological evaluation of a mass murderer engaged in a crime like this.
True.
Of those 22 that you've done, how many of them did you do, not 22, let's cut out the domestic ones, of the others that weren't domestic, how many did you do before they were convicted of their crime?
Twelve.
12 of the 12 not domestic? All 12?
Yes, the 12 that are not domestic, correct.
The 10 domestic ones you did after they were convicted?
Most of the domestic were done after they were convicted. I'm sorry, it's hard for me to keep count without writing here.
But let's leave it at this. You have never done a neuropsychological evaluation on a defendant quite like this, accused of the crimes that he's been accused of with this fact pattern. Fair?
True.
May I have a moment, Your Honor?
Yes.
Your Honor, I do not have an objection to this witness being qualified as an expert exclusively in the area of clinical neuropsychology.
All right, without objection then, and pursuant to Rule 702 of the Colorado Rules of Evidence in the decision in People versus Schreck, which is cited at 22 Pacific 3rd, 68, Colorado, 2001, the court will accept Dr. Hanlon as an expert witness in the field of clinical neuropsychology. Members of the jury, that means that he may now render expert opinions in that field. You're not bound by the testimony of a witness who testifies as an expert. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it or none of it. The weight that you give the testimony is entirely your decision. All right, Mr. King, you may proceed for another 5 minutes or so before we take our morning break,
Okay,
unless you want to take it now.
whatever the court prefers.
Let's go ahead and take it now so that I don't interrupt you just 5 minutes from now. Members of the jury, please make sure you keep all my admonitions in mind during the break. All of them apply, all of them are mandatory. Let's take 20 minutes. I'll see you back here at 10:25. Thank you. The jury has exited the courtroom. Please be seated, everyone. Let's take our morning break. I'll see everyone back here at 10:25. The court will be in recess. Thank you.
Please rise.
Good morning. I'm Anika Padilla in the 7 News studio with Phil Tenser and Andrew Altenberg. And we are in our short morning recess. So far this morning, we've spent about the last hour and a half talking about Dr. Robert Hanlon's qualifications. It's been a long, drawn-out process. He's clearly a very educated man. But District Attorney George Brockler has made a point of letting the jury know that he tends to be a defense witness only, has never worked for the prosecution, presumably trying to sow some suspicion that he might be biased towards the defense. We also heard from Tara Fournier. She worked with Holmes. In fact, James Holmes, in fact, she hired him to work at Marical back in California before he moved to Colorado. She was significant in that she has 2 children, one with Asperger's and one with autism. And it seemed the defense may have been trying, and she said that Holmes reminded her of her 2 children. And that sparked a very spirited debate about autism, Asperger's, and the possible link or no link at all to insanity. So why don't we take a minute to go back and listen to Tara Fournier's testimony, and we will rejoin court as soon as the recess is over.
I very first met him when he came in to interview for a position.
Did you do the interview?
Yes, I did.
And did you, tell the jury what your observations were of Mr. Holmes at that time?
Sure. He was dressed very professionally. I remember specifically he was dressed in a button-up shirt and a tie. He was a little bit different, but he was able to answer all the questions, and he fit the bill for the position.
And did you hire him?
I did hire him.
And what was his job at Marical?
He was a coding operator.
And what does that entail?
So a coding operator is when the vitamins and the pills were being manufactured, if there was a certain color or a certain texture that the pills needed to be, he was in the department where he was overseeing that process and making sure that the pills were colored according to the customer specifications.
Okay. And did he come in through a temp agency?
Yes.
Did you have any other interactions with Mr. Holmes?
Yes.
Can you describe those for the jury, please?
Sure. I interacted with him during his interview process, during his onboarding, so we had to train in order to get him up to speed for the position, and then also with an HR issue that occurred.
How long do you think you spent with Mr. Holmes in the interview process?
Probably about 30 minutes
And
would be a
how-
guess.
Okay, and how long while you're training him and getting him acclimated to the lab?
That would have been probably more like 2 hours.
All right, and then you said you also had some interaction with him during an HR issue?
Yes.
During these interactions, and we'll talk about that issue in a minute, but
Okay.
during all of your interactions with Mr. Holmes, what sort of impression did you have of him? What did you observe about him?
I observed him a little bit different
How so?
than others. It's hard for me to put it into words. I guess he reminded me a lot he reminded me a lot of my children. He was very he seemed like he wasn't all present all the time. I mean, not that he was not intellectual or intelligent, but just that he was in another place.
And why does that remind you of your children?
My children have some special needs.
And what is that special need?
I have 2 children, and my older son is diagnosed with Asperger's, and my younger son is diagnosed with autism.
And so what sort of things did Mr. Holmes do that reminded you of your children?
He did not make eye contact with people very easily or with me, and he just seemed very socially awkward and just in another, I don't know how to explain, but in another place. Like his mind was not always present.
Did
It appeared.
Did it seem like he was just bored and shy, or did it seem more than that?
No, I wouldn't say bored and shy. I wouldn't say that.
Okay. Did he start up conversations with anyone that you saw?
Not that I observed.
Okay. Did he socialize with other employees?
I don't know. Not to my knowledge.
All right. And if you could just briefly explain what sort of interaction you had with Mr. Holmes during that HR issue, that human relations issue that you mentioned.
Sure. So while he was working in the coding area, it's a small space, and there's usually 2 people that work in the coding area and then a quality control person that comes in and out. And there was an issue where the quality control person felt that James was working too slowly and was prodding him to work more quickly. And one of the other employees stepped in and told the quality control person to stop, and it created a confrontation with some racial slurs.
Okay. Did the racial slurs have anything to do with Mr. Holmes?
No,
Not
no.
the victim or the perpetrator of the racial slurs, correct?
no, just a witness.
Okay. And so when you, what sort of interaction did you then have to have with Mr. Holmes regarding that issue you were investigating?
Sure. So whenever there's an issue, we would bring in anyone that had knowledge of the incident. So I brought him in and asked him some questions to clarify what had happened that day.
Okay. And the jury has heard from David Maldonado and Jose Sanchez. Were either of those 2 men involved in this incident you're describing?
No.
All right, so there were 2 completely different people.
Yes.
All right. What was your observation about the way Mr. Holmes presented when you were talking to him about the incident?
He had very little to say about it.
Okay.
He answered questions very briefly, but really seemed to have no knowledge of what had happened.
Did he give any sort of narration about what happened, or was it just basically answering your questions?
Basically answering my questions. Mhm.
And during that conversation, did he make good eye contact with you?
Not that I recall, no.
Was he ever rude or arrogant that you saw?
No.
Was he polite and nice?
Yes.
Okay. If I can have just a moment.
Yes.
Thank you, Ms. Fournier. The prosecution might have some witness
you.
questions for you.
Thanks.
Cross-examination, Ms. Stitch McGuire.
Thank you, Your Honor. Good morning.
Good morning.
It's true that you had not met the defendant prior to his employment at Miracal prior to 2011. Is that true?
Yes,
And your interactions with the defendant were brief, potentially 3 to 4 hours over his entire term of employment at Miracal. Is that fair to say?
yes,
And you have not had any interaction with the defendant since his departure in January of 2011.
yes,
And realizing that your interaction with the defendant in 2011 was a year and a half before the defendant was charged with the murders of 12 individuals and the attempted murders of 70 other individuals.
I'm sorry, say that again?
Your interaction with the defendant last interaction in January of 2011 was over a year and a half before this defendant was charged with the murders of 12 individuals and the attempted murders of 70 more.
Yes,
And your interactions with the defendant consisted of his initial hiring interview. Are people often nervous?
Hold on. Is that a yes?
yes,
Go
Sorry.
ahead.
Thank you, Your Honor. Your interactions consisted of his initial hiring interview. Are people often nervous during an initial interview?
some people are nervous.
And the other issue was an HR investigation.
Yes,
Are people often nervous during an HR investigation?
again, some people, yes,
And you're not a psychologist,
no,
not a psychiatrist.
no.
And what is your profession currently?
I'm in human resources.
And when you interacted with the defendant, did he appear to understand everything you said?
I believe yes,
And you thought the defendant was qualified, if not overqualified, to attain the job at Miracal when you hired him?
I believe he was qualified, yes.
Do you have very many applicants for this type of position with someone who is cum laude graduate of the University of California at Riverside?
Not specifically, no.
And you specifically looked for characteristics in the person you were hiring because you had had some employment issues with other employees at Miracal, so you were specifically looking for someone who would keep their head down and do a good job. Is that fair to say?
Yes,
So in the midst of the drama that was caused in this racial incident, didn't the defendant do exactly what you had hoped that employee in his position would do, which was to keep his head down and to not get involved in any of the drama?
I would say yes, but I also would say that in an investigation, we would expect them to cooperate and provide information relevant to the investigation.
And did he cooperate?
He did.
And in fact, you're not even the HR director of the facility where the defendant was located. Is that fair to say?
Yes, that is correct.
So there was an HR director who would have had more opportunity to interact with the defendant at Vista, which is the facility where he was actually employed.
Actually, there's no HR director in the Vista facility. It was an HR assistant.
But there was an HR assistant there at the Vista facility.
That is correct.
And you were located in the Orange County facility.
That is correct.
I have no further questions. Thank you, Your Honor.
All right, thank you. Is there any redirect?
When, just briefly, Your Honor, when Mr. Holmes was giving you just those short answers during the investigation, did you get the impression he wasn't cooperating, or whether he just, as you had seen before, he just didn't have much to say, he just didn't talk a lot?
He just didn't talk a lot.
Okay.
Yeah.
Thank you. I don't have anything else.
Ms. Teach-McGuire, do you have any recross?
No, thank you, Your Honor.
All right, and the jury does not have any questions for this witness. May this witness be released from her subpoena?
Yes, sir.
Any objection?
No, thank you, Your Honor.
Ms. Fournier, thank you.
Thank you.
Call your next witness, please.
Dr. Robert Hanlon.
Were you at the Century 16 movie theater on July 19th, 2012 in Aurora, Colorado?
I was.
Did that go into the early morning of July 20th, 2012?
It did.
Could you please tell the jury about what you remember about the day of July 19th of 2012, prior to going to the movie theater?
Well,
We started off our day a little late, but we were spending time together. I was up here on vacation. We went to the Coors Brewery.
I'm gonna stop you for a second. Who's we?
We, Jessica and myself.
And who's Jessica?
Jessica Gowie is my good friend of almost 10 years.
How'd you know Jessica?
I met her in high school back in fall of 2002, and so it began. We covered a lot of ground in that time, and great friendship. We dated for a while.
Interject an objection under 403 and 401.
The objection's overruled, but ask your next question, please.
What, were you visiting Jessica from another state?
I'm from Texas.
Right. So when had you arrived to visit Jessica?
I arrived, I believe it was the 17th of July.
Of 2012?
Of 2012, yes.
What do you recall doing with Miss Gowie that day?
That day, as I said, we went to the Coors Brewery. We went on a tour, hung out, and we went back to her residence, and we just played catch up. We hung out by the pool. We just talked like we hadn't got to talk in a while. She had moved up here the year prior, and
An objection 403.
Sustained.
Did you and Miss Gowie decide to go to the movie theater that day?
we did. After much persuasion, she twisted my arm, essentially. She's like, I never thought I'd have to twist a guy's arm to go see Batman. But any which way, we decided to go see the midnight release, and turns out they were sold out of tickets as soon as we tried to buy them. She checked again, and turns out there was a 12:05 showing. So we bought the tickets and eventually made our way to the theater later on that evening.
Do you recall approximately what time you got to the theater that night?
I'm going to go out on approximately, it was probably about 11:40, 11:45.
What'd you do when you got to the movie theater?
We went through the motions. We got our tickets. She had this obsession with this weird popcorn salt stuff, so she got her fix there. We made our way into the theater, and we just sat down and watched the previews. We were walking in as the auditorium was darkening for the previews.
Were you able to tell how full the movie theater was at that time?
It was packed. It was the midnight release, or the premiere night, so it was a very, very full theater.
Where did you find your seats that night?
It was the 12th row, offset to the right of the auditorium, probably 6 to 8 seats in.
So if you're facing the movie theater screen and this is the movie theater screen, were you closer to the right side of the theater or the left side?
Closer to the right side.
What do you recall of doing prior to the movie starting?
We were watching the previews. I remember there was that new Superman movie that was supposed to be coming out. I remember one of the gentlemen in the audience was wearing a Superman shirt, and he struck his little pose, and we all laughed. We were just, cutting up and having a good time, just getting ready for the movie, getting geared up. And, yeah.
What happened during the movie?
We're probably guesstimating 20, 30 minutes in. And I remember hearing a hissing noise coming from the front right of the theater by the emergency exit. And it drew my attention over there, but being that it was dark, I couldn't see anything. Shortly thereafter, I saw what was making the hissing noise being hurled across the theater, and it was going up theater, probably somewhere a row or so in front of us, but off to the opposite side, to the left side of the theater. And I remember there was this brief pause as soon as it hit the area of people, and then this surreal effect happened. It's like a drop of water hitting, and this wave of people just erupted away from where the object had been thrown. And I was kind of puzzled at first, and then the first shot rang out, and I was like, oh, this is actually happening.
What do you recall after that first shot rang out?
Of course, mass panic, chaos, people screaming. We stood up and we started to make our way to the right to exit our row. We got about 1 seat length down the way, and I realized that people aren't moving out of the way fast enough, and I pushed us to the ground.
When you say us,
Jessica and myself.
all right, what happened when you pushed her to the ground?
It was to get cover. The whole time she was saying, call 911, call 911. She was in a kind of a laying down position for cover. I was kind of in a low profile crawling position.
And could you describe for the jury how your bodies were at that point?
She was laying prone, which is stomach down, just flat on her stomach basically, taking cover, saying call 911. Myself, I was kind of in a curled up ball, but like in a crawling type position.
Were your heads closer to the right aisle or closer to the left aisle?
We're both facing the right exit. So, so at that point, I started to feel the spray of popcorn and soda just all around. I noticed her tone changed entirely, transitioned from call 911 to screaming, and I looked down to see that she'd been shot in her right leg. I believe it was right above the knee. As an EMT, I just finished my course, my training, and my first step from there was just to control the bleeding, so I applied pressure to her gunshot wound. Again, there was a continued spray of popcorn and soda or whatever was going on. I felt, I tried to reach for my phone in my pocket, and given my position, I wasn't able to do that, so I straightened out my leg. I kneeled up a little bit to gain access to my pocket to get my phone, and that was when I sustained a shot to my left buttocks.
Are you hearing anything in the background while all this is going on?
Shots continued to ring out. My perception of time was adrenaline slowed things down a lot, but I do recall shots being fired.
Now, describe for the jury the shots that you heard in the theater that night.
Well, as soon as the first shot rang out, it was just a loud bang, and then a pause, and then a bang, and it just continued. As soon as I saw that Jessie had been shot, my focus transitioned to taking care of her. So the shots continued, and I at that point had gotten out my phone, and I fumbled around to call 911 as soon as I could, as quick as I could, but I got some weird busy message on my phone. And so I stuck it back in my pocket. I had noticed at this point that the screaming had stopped, and Jessie had sustained a shot to the head, in which case brain matter was exposed. It was at that point I crawled a little closer to her, and I prayed over her.
I move to strike 403.
Overruled.
You can continue, Mr. Lowe.
I didn't really know what to do. It just felt right. I just gave her the best send-off I could. And at that point, my medical technician the training had kicked in, and we would count a patient like that in the EMS world as a black tag triage, which means they have injuries that are incompatible with life. At that point, I felt that my own survival was my next priority, and I made my way all the way across the aisle that I was in to the small section of seating that was right above the entrance tunnel to the right of the theater. My strategy was that if the shooter had come back, actually, I skipped a part. While I was laying there with Jessie, I looked up theater, the upper rows, and I saw someone stand up and run out. and I heard no shots fired out. So I figured at that point.
12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, and the prosecutors are present as well. You guys ready for the jury?
Yes, sir. Sure.
Okay, let's bring him in, please. Please be seated, everyone. Dr. Hanlon, I remind you that you're still under oath, okay?
Yes, sir.
All right. Mr. King, you may proceed with your direct examination.
Thank you, Your Honor. Doctor, before I move on, I just want to talk briefly about a couple things that Mr. Brockler brought up. First of all, were you previously qualified as an expert in this case, in a previous hearing to testify in this case as an expert?
Yes.
Did the fact that you are invited to do lectures by a public defender organization or some organization affect in any way the way you administer neuropsychological tests?
No.
Now, and I want to talk a little bit more about this later, but are neuropsychological testing such that you have to administer the test correctly and the subject answers the questions of the test, and the results of the test are the results of the test? Do you create the results of the test, or do the results speak for themselves?
Well, the results, the responses to questions or the task that is being requested or elicited are it's based on the examinee's response, and I don't change that.
Does Mr. Brockler asked you about the different types of cases you've been retained on, and who's retained you, and whether they took place before a conviction or after a conviction, or whether they were related to homicide or not to homicide, or to death penalty cases or to not death penalty cases. Did any of those considerations have anything to do with the way that you administer, score, or report the results of your psychological testing?
No.
Now, to be fair, I asked you some question about how many mass murder defendants that you had done neuropsychological evaluations of. And you recall that exchange that we had, yes?
Yes.
And Mr. Brockler asked you a series of questions where he had you break down the categories of the 27 different mass murderers that you have conducted neuropsychological evaluations of. And they were broken down into different categories by the motive that was related to the crime. Do you remember that series of questions?
Yes.
That some of them were domestic violence situations or in the family homes situations. You remember that?
That's correct.
That some were motivated by murders committed in the act of committing another crime, and that was the motivation. You remember that?
Yes.
And some were crimes that were, you said the cutting out of the baby case that was motivated to have another baby or something like that. Is that right?
Yes.
And basically all of the cases, Mr. Brockler had you categorize them in the category of what the motive was, and said, well, none of those apply to this case. Do you remember that line of questioning?
Yes.
Let me ask you this. How rare is a mass murder case like this, where there is no motive for the crime?
Sustained. You can rephrase the question.
How rare is a mass murder like this that won't fit into one of those categories that Mr. Brockler had you put your cases into?
From my review of criminologic literature and crime analyses of mass murders, it's extremely rare.
Has anyone that you're aware of done a neuropsychological evaluation of a defendant in a case like this?
Not that I'm aware of.
So you haven't done it, and neither has anyone else.
As far as I know.
I want to talk to you a little bit about your involvement in this case, if I may, sir. And how did you come to be involved in this case? Did you contact us, or did we contact you, or how did that work?
You contacted me.
Before you were asked to conduct, or before you conducted your neuropsychological examination of Mr. Holmes, were you given some information by my office to review at your request?
Yes.
What information were you provided?
I was provided with the jail records from the Arapahoe County Detention Center. I was provided with some educational records. Some records regarding family history.
How about academic records of Mr. Holmes, like his transcript from the University of California, Riverside, or from CU?
Yes, I was provided with those educational records.
How about the records of Dr. Fenton and Dr. Feinstein and Margaret Roth at the treatment he received at Anschutz?
Yes, I received those records.
How about did you say the jail records from the detention facility?
Yes.
How about the records from the doctors, the psychiatrists that treated Mr. Holmes at the Denver Health Medical Center in November of 2012?
Yes, I received those.
Did you get his school records from middle school, high school?
I did.
Is it important to you, like school records, because it has some reflection of cognitive ability, how somebody does in school?
Yes, they're very important.
Were you provided or not provided with like police reports in the case?
I don't know if the police reports were in the original document set that I received, but I did eventually receive some police reports.
And was it necessary for you to review all of the police reports and all of the information in the case in order for you to conduct the neuropsychological testing that you did?
No.
And are you did you review all of it?
No.
Now, was your understanding of what you were tasked to do, and when was this that you were contacted and conducted your neuropsychological examination?
I conducted my original neuropsychological evaluation of Mr. Holmes in April of 2013, I believe, over the course of 3 days, April 18th, 19th, and 20th of 2013. When I was contacted, I believe, maybe it was either very late in 2012 or January of 2013.
Okay. And what was the understanding of what you were tasked to do?
What I was asked to do very specifically was to conduct a neuropsychological evaluation of Mr. Holmes that would be specifically a thorough, detailed assessment of his intellectual functions and his cognitive functions.
Were you asked to diagnose what his medical condition, mental health condition was?
No.
Were you asked to render opinions about whether he was sane or not at the time of the offense?
No.
Were you asked to determine when and if he was psychotic and how?
No.
Were you, in that regard, did you review his writings, for example? Were you given the copy of his notebook to read?
No.
Were you given emails, exchanges between him and his friends or his family to review, or computer searches that he'd done on his computer, or text messages that he had sent? Do you remember?
No, not at that point.
Is in your opinion, your expert opinion, is any of that information important or relevant to the what you were tasked with doing, the limited task that you had?
No, not at the time of my original evaluation. Those documents, that information, certainly was not imperative for me to review.
Now, you said earlier on this morning that you're qualified. You're a psychologist, right? And your specialty is neuropsychology. Fair to say?
Yes.
So you're certainly qualified to administer the type of personality inventories or psychological testing. For example, like Dr. Gray did in this case, MMPI, PAI, those types of tests. Is that right?
Yes.
And what's the difference between neuropsychological tests and those kind of psychological personality tests? What are they meant to learn? Are they meant to learn different things about a person?
Yes, they're designed and intended to assess different mental functions and make determinations about different aspects of mental status. Neuropsychological evaluations are, in the purest sense, intended to objectively assess cognitive functions and intellectual functions, and sometimes motor, sensory motor functions as well. But fundamentally they are designed to assess mental abilities, whereas psychological testing, similar to what Dr. Gray did, those are what are called psychodiagnostic types of tests. They are designed to assess personality features, personality traits. They're designed to assess psychopathology or mental illness. So, for example, depression or anxiety or psychosis.
So in that regard, and you said you listened to Dr. Manguso's testimony yesterday, in that regard, was your role in this case kind of identical to the role of Dr. Rose Manguso in that it was limited in that way?
Yes, it was very circumscribed, it was very focused, and it was made, and it was very clear to me what my role was.
Have you had a chance to, have you exchanged data and information with Dr. Manguso and discussed the findings that both of you had between each other?
Yes.
Is that normal for psychologists and psychiatrists to do, to confer between each other and discuss the issues?
It's very common in clinical, with clinical patients. It's a very common interchange. It's not as common in criminal forensic cases, but it did happen in this case.
Okay. Did you conduct a clinical interview as part of your testing in this case?
Yes.
Or in conjunction with it?
Yes.
And why? Was it your suggestion that needed to happen?
Yes, it was.
Was that a requirement that you put on the conditions of you conducting the neuropsychological testing?
Yes.
And why is that?
Because it is an important part of a neuropsychological evaluation. Sometimes doctors who refer patients for neuropsychological evaluations, and sometimes lawyers who refer defendants or plaintiffs for neuropsychological evaluations, sometimes think or want just testing to be done and nothing, and they seem to think that someone like me is going to do nothing else. But it is important, and I think any neuropsychologist would agree that it is imperative to conduct a clinical interview in order to obtain information that needs to be factored into the interpretation of the neuropsychological test results, such as developmental histories, social history, educational history, medical history, etc.
Does that also include issues that may surround the testing itself, like whether the person is ill at the time or tired or medicated, or do you have to ask those kind of questions in order to take those things into consideration?
Absolutely.
And the clinical interview that you conducted, was it limited in scope?
It was limited to the information that I believed was necessary for me to know in order to complete a good, thorough neuropsychological evaluation of him.
Okay. And again, you heard about the clinical interview that Drs. Manguso and Gray did together, right?
Yes.
Was your clinical interview even more narrow than theirs was in ways?
Yes.
So they covered areas that you didn't even go into?
That's true.
Did you ask any questions about the crime, for example?
No.
Did you ask any questions about the events leading up to July 20th, 2012, or what Mr. Holmes was thinking during that period of time?
No.
Were you concerned at all about about those issues surrounding that period of time, or is that just not important for your consideration, given the limited scope of your role?
There was not information that was necessary for me to acquire from Mr. Holmes in order to conduct the evaluation that I was charged with conducting.
Okay. Did I indicate to you what I wanted the results to look like, or did I direct how things should come out in any kind of way for you, or did I just say, were you just instructed to do your testing and let us know what the results were?
You gave me no instruction, you gave me no expectations. You quite bluntly asked me to conduct a neuropsychological evaluation of the defendant, and I told you what I planned and what I was going to do in terms of completing that evaluation, and that was in essence the extent of our exchange.
Okay. And if you didn't feel like that it was an appropriate way to proceed, would you have either said no or told me what needed to be different, like you did with the clinical interview?
Yes, I would have told you what I required, and if you didn't agree to that, I would not have conducted the evaluation.
And is that because as a professional you need to make sure that your results are accurate and that you do things appropriately?
Yes.
And well, let me ask you this. Did you prepare some slides for us to help aid in your discussion today of the examination you did of Mr. Holmes?
Yes.
May I have slide number 2, please? Your Honor, may I publish some of the demonstrative slides with your permission?
Yes.
Sir, what kind of, you heard Dr. Manguso's description of what a neuropsychological examination is and what some of the tests were yesterday. Is there anything that you wanted to add or you thought was important? I don't want to rehash all the same stuff. Is there anything you want to add or think is important about how the tests are administered or scored, or whether the objective nature of the testing? Or do you think she covered it pretty well?
I think Dr. Manguso did a fine professional description of what constitutes a neuropsychological evaluation. I think she outlined the different domains as they are outlined in this slide. Maybe the one domain that I don't recall Dr. Manguso mentioning was social cognition, and that's not always a component of a neuropsychological evaluation, but more and more frequently it is becoming a component of a neuropsychological evaluation.
In this slide that we're looking at here, are those the various domains of cognitive functioning that you set out to test Mr. Holmes for?
Yes.
How do those relate to, do those all relate to the way people think?
Yes.
How does social cognition fit in there? You just brought that up.
Social cognition is an area of mental ability that involves how people think in social interactions. And for example, it involves the perception of facial expression and being able to perceive or differentiate an angry facial expression from a happy facial expression or a sad facial expression. Those are just some examples. That's one example of social cognition. Also involves things like tone of speech, being able to differentiate sarcasm, for example, from just honest, straightforward, direct response to a question.
The instruments that you chose to administer, and I want to go through them a little bit, but who chose the test? Did you choose the test, or did we tell you what test that you needed to do?
I chose the tests.
Did you choose the exact same test that Dr. Manguso did?
No.
Okay. Were they similar? Can you tell us what the difference was or what the similarities were?
They are similar tests in that they're both tests. They're both tests that constitute different what's called a neuropsychological battery of tests. And as Dr. Manguso stated yesterday, she was somewhat constrained by the fact that the defendant had already undergone a neuropsychological evaluation 4 months before she evaluated him. So she didn't want to use some of the same tests that I had used because he had previous exposure to them and would remember them. So, for example, Dr. Manguso did not assess intelligence in Mr. Holmes. She did not do testing to produce an IQ. But she did do memory testing. She did testing of attention, concentration. She did testing of language, perception. She did some testing of constructional abilities. She certainly did executive functions, and she did some of the same tests of executive functioning that I had done previously. She did assess reasoning. She didn't really, I don't recall, assess any aspects of social cognition. And like me, she is very rigorously assessed symptom performance and validity.
Thank you. Can I have slide 3, please? When did you do the examination of Mr. Holmes, and where and when did you do them?
I did the first neuropsychological evaluation of Mr. Holmes in April of 2013 in 3 consecutive days. They were conducted at the Arapahoe County Detention Center next door. And so over a period of 3 days, I spent 13 and a half hours primarily testing him. It was maybe an hour to an hour and a half what constituted the clinical interview.
And then you did a second neuropsychological evaluation?
Yes, and there was a second neuropsychological evaluation done in January of 2015 in 2 consecutive days, January 5th and January 6th. Also done at the Arapahoe County Detention Center next door.
And Dr. Manguso testified some about this, but is it a good idea to do, over time, to do testing again at a later period?
It is. It's a common practice. There are many psychiatric and neurologic disorders which serial or series of neuropsychological evaluations are required to objectively assess change over time. I mean, it's commonly done in the dementias, Alzheimer's disease, vascular dementia, et cetera. It's also done in traumatic brain injury. It's also done in conditions, in psychiatric disorders, particularly when there's treatment intervention.
You heard Dr. Manguso's testimony yesterday where she said that in her testing there was some very slight cognitive impairment in some of the testing that she did. Do you remember that?
Yes.
And Mr. Brockler made a point to bring out that it was slight impairment and not a dramatic impairment. Fair to say?
He did.
Is that something that you noticed when you got the results of her examination?
I did. When I received Dr. Manguso's report, I was very clearly aware that she had determined that Mr. Holmes, in the testing that she did, showed evidence of very mild, subtle neuropsychological deficits or cognitive deficits, which was different than my original evaluation, in which he showed no evidence of any neuropsychological or cognitive impairment. So that was a difference. There was really only 4 months in between those two, my first evaluation and then Dr. Manguso's evaluation. And so there appeared to be, again, slight, minor, subtle change.
Is that one of the reasons why you thought it might be a good idea to do another evaluation?
Sustained?
Was that or was that not one of the reasons why you thought it was a good idea to do another evaluation?
Yes, that was definitely one of the reasons that a second evaluation was considered, in that he had shown some evidence that there were differences between the original evaluation that I did and the second evaluation, or the evaluation that Dr. Manguso did.
And that second evaluation took place earlier this year, is that right?
That's correct.
Why was that one shorter? By 2 hours, 2.5 hours, I guess.
It is a little shorter because there were a couple of areas that I really did not think it was necessary to retest him on. I did not, for example, do any reassessment of social cognition.
Okay. So let's go through some of the testing that you did do, and I want to start out with validity testing, if I could do that. Could I have slide 4, please? Now, what is validity testing, and why is it important, sir?
Validity testing, as shown on that slide, for just to be blunt about it, is our testing done with the attempt to rule out or determine if an individual is exaggerating symptoms, if they're feigning symptoms, or if they're just flat out malingering. These are crucial tests that need to be included in any neuropsychological evaluation, whether it be for a forensic or the criminal defendant or even a clinical patient. It is imperative. It is extremely important for a neuropsychologist to be able to conclude that the test data are valid, they're representative of the status of this individual at this time. And so that's why these kinds of tests are administered.
Okay. And on this graphic, can we call out, ma'am, the first part, the performance validity part, including the dates, if that's possible? Including the dates, if that's possible. Now, in this graphic, thank you, ma'am. In this graphic, 413, is that your first set of testing?
Yes.
813, is that Rose Manguso, Dr. Rose Manguso's testing?
Yes.
And 115, is that your second set of testing?
Yes.
And 714, what does that represent?
That represents the second evaluation that Dr. Gray did. Dr. Manguso, my understanding, did not do any further neuropsychological evaluation at that time. It was only Dr. Gray.
And is that why that's blank? Because there was no neuropsychological evaluation done at that time?
Right.
So it looks like you only have two tests that Dr. Manguso administered in August. Did she administer more tests? Are those just the ones that overlap with yours? Of symptom validity, I mean? Or do you not recall?
Those are
in other words, she didn't administer the word memory test, the Victoria symptom validity test, the B test, the reliable digit span, or the California verbal learning test, did she?
Actually, thank you for asking that, Doctor, and I apologize. I've omitted a score from Dr. Manguso.
Okay.
She, in fact, did administer the B test, and that score should be there. That would be another 1. So as she testified yesterday, she did in fact administer 3 different performance validity tests: the test of memory malingering, the validity indicator profile, and the B test.
Did you just call me doctor?
I'm sorry, did I? No offense.
I'm getting used to that. Does tell us about the validity testing that you did, sir. What you did did you do the TOMS like she did?
I did.
And what was the result of that?
The Tom was he performed, I believe, perfectly. I think he did 100% accuracy. I can check and
Feel free to check if
I
you
can
want.
easily check and see.
Are you looking at your report?
I'm looking at the addendum to my report, which is a data sheet.
Thanks, sir.
Yes, in the April 2013 evaluation, he scored at the 90 on the first trial there are 3 different trials, and this is looking at different pictures and being told to remember them. He scored at the 94th percentile, or 94% accuracy on the first trial, 100% accuracy on the second trial, and 100% accuracy on the retention trial.
Now, the fact that one was 94, what's the significance of that?
It was the first trial. There is no significance. It's still well above any cutoff to suggest that it's anything but sufficient effort.
How about the Green's word memory test, the first one up there then?
The Green's word memory test, he also scored at a very high level, demonstrating no evidence of symptom exaggeration or feigning of memory.
Validity indicator profile test?
Same thing as he had done with Dr. Manguso, and the scores were almost identical between my first evaluation and Dr. Manguso's evaluation. His score was valid and compliant.
And anything significant about the remaining tests that we should need to talk about?
The one significant point about those last 2, that are the reliable digit span and the California verbal learning test, those are embedded. They're what they're called embedded performance measures, meaning that they're not separate tests that are designed to assess for effort or faking. They're subtests within other neuropsychological tests that are used to determine if the individual is putting forth sufficient effort or faking in the context of that particular neuropsychological test.
So I don't understand you have 40 subtests over there on the right, in the right margin. What's that mean?
That means that collectively, from all these different, the separate neuropsychological evaluations that Mr. Holmes underwent, he consistently, there were 40 different subtests that assessed his effort, his whether or not he was putting forth optimal effort, or whether or not he was exaggerating anything. He passed them all 100%, 40 out of 40.
And that includes your testing and Dr. Manguso's testing?
Correct.
And do you have an opinion then about whether Mr. Holmes put forth solid effort and was not feigning or malingering any of his cognitive deficits or anything like that?
I believe that he consistently put forth optimal effort, and he showed no evidence whatsoever of feigning or faking or malingering on any of the neuropsychological evaluations that were completed.
Okay, thank you. And if we could now call out the bottom part, if ma'am. Now, I want to be clear, because I don't want to, the MMPI-2 and the PAI, you didn't do those, did you?
I did not.
And that's why the columns where your testing is blank, is that right?
That's right.
Is that testing that was done by Dr. Gray, and Dr. Manguso told us about some of that yesterday. Is that right, the results of that testing?
Yes, she did.
And what's the SIRS there? It looks like you gave the SIRS on the 15th of January. What's the SIRS?
The SIRS is a structured interview that is, it's a very good test. It's a very sensitive test, and it's used to evaluate whether a examinee is exaggerating psychiatric symptoms, particularly psychotic symptoms.
How's that different from the other test you gave up above, the performance validity tests?
The performance validity tests are all designed exclusively to assess for performance on cognitive tests, and whether somebody's putting forth effort or not. The symptom validity tests they're different in that they're really not looking at cognition or mental abilities. They're looking at whether somebody is over-endorsing or exaggerating psychiatric symptoms, and in the case of the SIRS, particularly psychotic symptoms.
So to put it in lay terms, is the difference between faking not being able to think right and faking being psychotic or having a mental illness?
Yes.
And what was his performance on the SIRS? How did he perform on that test to evaluate whether he was malingering psychiatric symptoms?
Well, during the testing by me in January 15, as well as in the testing by Dr. Gray in July 14th, he passed all of the scales on the SIRS and showed no evidence of psychiatric symptom exaggeration or malingering, and he wasn't even close.
So based upon your testing that you did and your information that you have an opinion about whether Mr. Holmes is faking a psychiatric illness? Based on what you know.
Based on the testing that I've done, based on the testing that Dr. Gray did, Dr. Manguso did, he consistently shows no evidence of just even exaggerating symptoms, let alone malingering.
Thank you. Let's talk a little bit more about some of the other, and you can take that down, thank you. Some of the other neuropsychological testing that you did. Did you do tests that related to attention?
Yes.
The Connors Continual Performance Test, what's that?
The Connors Continuous Performance Test, second edition, is a test that I administered to Mr. Holmes on both occasions, both of my evaluations. It's a test of attention, and also includes reaction time. It's a computerized test, and he consistently scored within the average range, even above average range on that test. His reaction times were quite good. Actually, his reaction times were faster the second time that I administered that test to him.
Okay. So consistency between the two sets of tests?
Oh, very consistent.
How about the trail making test? I think that Dr. Manguso did that one too, did she not?
She did.
And what was the result on that?
The trail making test is a test that consists of two parts, and there is the first part, and I think Dr. Manguso testified about the part A yesterday, which is a very simple, basic, straightforward test of speed of information processing. It's basically a connect the dots type of a paradigm, and with me, he scored in the average range. The first time I evaluated him, he scored in the average range when she evaluated him, and he scored again in the average range when I evaluated him the second time.
Pretty consistent.
Yes.
Did you do any? What was your general conclusions then about attention?
His attention as assessed on those types of tests that you just questioned me about, he showed no evidence of any attentional disturbance or dysfunction.
Okay, so he's got no problems with his memory.
He has no problems with his attention and his concentration. In
Concentration, okay. How about language? Did you do any neuropsychological testing that related to language?
Yes.
Is that the NAB naming test that helped with that, or no?
Yes.
How did you do on that?
He scored in the average range.
Okay. How about the verbal fluency test?
The verbal fluency test is a test, again, Dr. Manguso mentioned this yesterday, it's a language-based test, but it also does assess a specific aspect of executive functioning, as I believe she mentioned, mental fluency of thought. And he scored in the average range when I evaluated him first time, and actually did a little bit better on that test the second time I evaluated him.
So fairly consistent there?
Yes.
And the wide range achievement test, was that similar, or?
The wide range achievement test is a test of reading, and well, there are several parts to it. The parts that I assessed with Mr. Holmes involved his reading accuracy, meaning his ability to just look at a word and read it, so break it down in terms of the sounds that the word is based on, and then also reading comprehension. And he scored in the high average range in both of those aspects of reading.
So fairly consistent?
Yes.
Fairly intact?
Intact.
And what, by intact, what do we mean in your parlance, in your line of work?
Intact is that's a good question.
I'm a doctor, that's why I ask such good questions.
Intact often is interpreted by neuropsychologists that if someone is performing or scores in the average range or high average range or superior range or very superior range, typically that function is going to be interpreted as intact. That doesn't mean that it may have declined from a previous higher level of functioning, but it's not impaired. It is still intact, and you can also talk about some scoring within normal limits, but that's generally what intact refers to.
Okay. I think we finished up with language then. Generally intact. How about visuoperceptual and constructional abilities?
Yes.
Judgment and line orientation test, does that relate to that domain?
It does.
And how did he perform on that, sir?
On the judgment of line orientation test, that's a test where he has to look at lines that are presented at different angles and determine the spatial position and orientation of those lines. He scored in the average range the first time I saw him. Then later during the second evaluation, he had declined a bit and scored in the low average range.
Okay. The first, so would you describe it as intact at the first testing and not so intact the second testing, or how would you describe it in your expert opinion?
Yes, I think it was intact when I evaluated him in April of 2013. In January of 2015, he's still scoring within normal limits, but his performance had declined. And so it didn't represent an impairment, but it did represent a change in his performance and ostensibly his functioning in that domain of cognition.
Just so that we're clear, is it your opinion that he was still functioning basically normally in that domain, but slightly poorer than he had when you tested him the first time.
That's fair.
Am I saying it correctly?
That's fair.
Let's talk now about executive functioning. You heard Dr. Manguso describe the prefrontal cortex yesterday and the executive functioning. Did she do a good job describing what executive functioning is and how it works?
Yes, I think she did. Executive functions are typically and clinically associated with the frontal lobes, the frontal cortex, particularly the prefrontal cortex. That doesn't mean that lesions and or damage in other parts of the brain cannot produce executive deficits. That can certainly happen. The brain is a system, and there are connections. The different areas of the brain are all connected. So there you can see a lesion in another part of the brain that may produce an executive function. But classically, executive functions such as problem solving, decision making, reasoning, controlling impulses, are your mental flexibility. Those are to a large degree controlled and processed by the frontal cortex, particularly the prefrontal cortex.
And suffice it to say, are the lower areas of the brain, the brain stem and the lower portions of the brain, the more kind of primitive reptilian part of the brain, and then the high upper layers and the frontal layers are the more developed layers, if you will?
Yes, they are. Interesting that you use the term reptilian. That is certainly a model that many people believe. But yes, the brainstem is considered to be a very old part of the central nervous system of humans. Yes, it is involved in heart rate and breathing and basically survival processes.
How about like fight or flight in reflexes or something like that? Where would that come from?
You get to a little higher level when you get to those kinds of functions. You get into an area called the diencephalon, which involves structures like the thalamus and the hypothalamus and the amygdala and structures like that.
Okay. Can I have slide 15, ma'am? Can you talk to us a little bit about your testing results with regard to executive functioning, sir? And I don't need to walk down through all the tests with you unless you want me to, but can you just give us a brief discussion of this?
Sure. As you can see here, there are tests that were administered by both Dr. Manguso and myself, particularly, first of all, as Mr. Brockler questioned Dr. Manguso yesterday about the Wisconsin card sorting test.
Is that the one she said was her favorite test or something like that?
I think Mr. Brockler may have alluded to that might have been her favorite test, but I think she agreed to that. Or it's one of the most widely used tests of executive function by neuropsychologists in the world.
Okay.
And it is probably the most researched test of executive functioning on the planet.
Okay.
So it's a very, very good test. It's a very sensitive test. And Mr. Holmes scored very well on it every time it was administered to him. He scored in the average range at the first time that I administered it to him. When Dr. Manguso administered it to him, he actually scored a little bit higher, primarily, I think, as she said yesterday, and certainly I would agree with her, due to practice effects that he had previously been exposed to this test and had experience with it.
Let's talk very briefly about that. What is a practice effect?
A practice effect is a phenomenon that occurs when an individual has a test has been administered to someone, and then at a later point in time, that same test is administered again. And it is widely accepted and generally known by neuropsychologists and psychologists that when you do that, there is a high probability that the examinee is going to likely score a little bit better the second time, just because they've had experience with this test, particularly on a test like the Wisconsin card sorting test, where there are really just a few different concepts that solve the test. And so once you know what those concepts are, then taking it the next time is a breeze.
Now, isn't this the test where it changes constantly, though? Like, then the person has to change their ability to explain the test to us.
There is, yeah. I don't want to be too specific because I'm bound by ethics in terms of disclosing, the paradigm of a given test. But yeah, there is a change. The rules change, but the individual is able to figure that out by the feedback that they get about whether they are right or wrong. So there's nothing unfair about it, and it's it's the kind of thing that we all deal with in daily life, where we're confronted with problems and that we try to solve that problem, and we find out that our solution isn't going to solve it, and so we have to come up with a new solution, and then we find out whether that solution works or not. So that's kind of what the Wisconsin card sorting test is how it's structured.
Okay. And does that mean this practice effect, does that mean somehow invalidate the second set of tests or the third set of tests? Or is that just something you have to take into consideration when looking at the test results and scoring it?
It doesn't, in my opinion, doesn't invalidate these kinds of tests. You just need to take that into consideration and realize, particularly if you know that he performed in the average range and demonstrated essentially intact executive functioning, at least as assessed by the Wisconsin card sorting test, then you'd expect him to do better. That kind of expectation is being confirmed through his higher scores the second time.
Okay. How about the rest of the tests of executive function?
The category test is another widely used, very good test. I did not administer it the first time I saw him. Dr. Manguso did when she saw him. I then re-administered it. Like the Wisconsin card sorting test, Mr. Holmes showed a very robust practice effect the second time, or when I administered to him after he'd already been exposed to it, which was no surprise. Trail making B is actually a complex test that is speeded. You have to do it fast. And he scored actually in the low average range when I evaluated him originally. He then did better when Dr. Manguso evaluated him. And then he dropped back down to his original level of performance when I evaluated him the second time.
Okay. And the other tests there?
That's true. All these other tests they're different ways of assessing different aspects of executive functioning. Mr. Holmes consistently is scoring in the average to high average range on all these tests. These are not tests that Dr. Manguso gave. These are tests that I gave to him, and he's demonstrating intact executive functioning on all these tests.
Okay, so consistency over time on these
Yes.
domain, and generally intact?
Yes.
And what does that mean about his cognition?
Well, it means that in these various aspects of executive functioning, and I think it's important to keep in mind that executive functions are a very broad range of higher order mental abilities, as Dr. Manguso described yesterday, that Mr. Holmes is demonstrating consistently that these abilities are preserved in him, and that he is he possesses these kinds of functions, and they're generally intact.
Okay. Next, I'd like to talk about intelligence testing, and this was the type of testing that Dr. Manguso didn't do because you'd already done it, I think, is what she testified. Do you remember that testimony?
That's correct.
Can I have slide 5, please, ma'am? Now, what's this slide about? Is this kind of how we rate people based on their IQ?
Yes, this is the distribution of intelligence, of intelligence as it is assessed by psychologists, and as how it's been conceptualized or defined by psychologists, particularly in North America. And it is, if you look at the center where it says 90 to 109 is the average range.
Okay, so is it like 100 the average, basically?
Yes, 100 is the average full scale IQ for Americans.
And below 70 there, would that be what was commonly called, developmentally delayed or mentally retarded, something along those lines? Somebody who's to that degree?
A score below 69, or score 69 and below, historically would be an IQ that would be in the range of mental retardation. That's not a term that's used any longer. It's the current contemporary term is intellectually impaired, and there are other criteria that are required to render that diagnosis of intellectually impaired, but the IQ is 69 or below.
Okay. Now, some of us may not want to know where we fall on this scale, but where's I'm looking for where's Mr. Brockler's category genius? Isn't there a genius category? I mean, I've heard of that.
It's not a clinical term, genius. But for the purposes of Mensa and organizations like that, it's my understanding that typically involves IQs in the range of 140 to 160.
140 to 160.
Yes.
Okay. Can I have slide number 6, please, ma'am? Did you? What's the Wechsler Adult Intelligence Scale 4? The WACE 4.
The Wechsler Adult Intelligence Scale 4 is the most widely used intelligence test to assess intellectual functions in the English-speaking world, I believe. Certainly the most widely used test to assess intelligence in North America.
And Mr. Holmes' score was a 123 in April?
Yes, Mr. Holmes achieved a full-scale IQ of 123, which is at the 94th percentile, meaning that compared to other, at that time I believe he was 25, so comparing him to other 25-year-old males, he was, at least based on a test like the WACE 4, he would score higher than, he would score at or above 94 out of 100 people.
Okay. And what's a full-scale IQ?
The full-scale IQ is the total score, the grand score that represents total intellectual function. And I think it's important, however, as Dr. Manguso mentioned yesterday, intelligence doesn't comprise all mental abilities. It's actually a relatively limited set of cognitive functions that constitute intelligence as defined by psychologists in our culture. There are other functions that are, other mental functions that are not part of intelligence, but it certainly has been demonstrated over many, many studies and many, many years that intelligence is highly predictive of certain aspects of performance in our culture.
Okay, thank you for that. Is the full scale IQ the combination of the verbal IQ and the nonverbal IQ, or the mean of the two?
It is, and there are also other factors, other IQs or indices that also are factored into the full-scale IQ in addition to the two that you just mentioned.
Okay, and are those factored in by the WACE itself, by the test itself, and the scoring of the test?
By the scoring of the test, yes.
Okay. May I have slide 8, please? Now, what does this slide reflect?
This slide reflects the comparison between the first evaluation that was conducted of Mr. Holmes in April of 2013, where he achieved a full-scale IQ of 123, and that is then compared to the second evaluation that I did in January of 2015, where his IQ declined from the superior range with a score of 123 at the 94th percentile down to the full-scale IQ of 116, which is at the 86th percentile and is in the high average range.
Now, I want to just talk generally about that. The 123, that's obviously got some ways to go before we reach a genius level, of what you described as a 140, or is that correct?
Yes.
Nevertheless, a 123, that's an intelligent person. That's a high IQ. Fair to say?
That is superior intelligence.
Okay. And that means that 93% of the people in his particular group that are his age with his education have a lower IQ than that. Fair to say?
True.
Now, in January of 2015, he got a 116. That's still smart, isn't it?
It is.
That doesn't mean he can't think, right?
Of course not.
But it bumped him down into the high average range. Can you tell us a little bit about that? What's the significance of this?
Well, the significance is that it is a significant decline or a significant change in a negative direction, and it is an unusual and abnormal change to see in an individual between the ages of 25 and 27, so it warrants interpretation. Somebody like me has to determine what is the reason for this change.
Okay. What's a standard deviation?
What is a standard deviation? Well, technically, a standard deviation is the square root of the variance, but I'm sure that's not what you want to hear.
I can hear it, but I don't understand.
A standard deviation is a psychometric property that shows the amount of dispersion or the amount of variability of scores around the average score. And standard deviations then are used to mark how far a given score is from the average score, either going down or going up.
Okay, thank you. May I have slide 9, please? What do we have here? It looks like it's broken down, the IQ, is that right?
Yes, this goes back to a question you asked a few moments ago about the different scores that go together to produce the full-scale IQ. And this lists his full-scale IQ in April of 2013, which was 123. And these four scores below, the perceptual index, the verbal index, it's a working memory index and a processing speed index. Those four scores they go together they are calculated together to determine what the full-scale IQ is. And in this case...
I'm sorry, I don't mean to interrupt you. Were you done?
Go ahead.
I use the terms verbal IQ and nonverbal IQ. Are those kind of represented by the perceptual index and the verbal index?
Yes, the perceptual index would be what could be called the nonverbal IQ, and the verbal index is commonly referred to as the verbal IQ.
Thank you. Slide 10, please. And is this the second set of testing with the same breakdown?
Yes.
And what was the distinction here?
The distinction here is then to demonstrate that actually, with the exception of the verbal index, Mr. Holmes showed some evidence of decline in all of the other indexes. The primary one where he showed quite significant decline was the perceptual index, which decreased from a score of 127 in April of 2013 down to a 113 in January of 2015. That is certainly a major change, a significant change. There were also declines in some of the other factors, but they weren't as nearly as strong or as robust as the decline in the perceptual index.
Well, slide 11, please. Does this show those breakdowns? Are these acronyms for those same terms on the left here? The FSIQ, full scale IQ, the PRI, the nonverbal, the verbal, the third one. Is that right?
Yes.
And does this show that what you were just testifying about, that change?
Right. This shows the same numbers and then the amount of change and the direction of the. So it was a decrease of 7 points, a decrease of 14 points. As I said before, he actually increased a little bit on his verbal intelligence in that interim, and then some small decreases then in the other two indexes.
Let me ask you a question, and answer this if you can. Because if Mr. Holmes were to spend a lot of his time in the jail reading, might that be a factor in why his verbal IQ maintained the level and even increased 2 points? Would that be a factor or not?
I think that's a reasonable factor. Mr. Holmes is a voracious reader, and reading a lot can increase vocabulary, and it can increase the amount of semantic information that you have available to you. And I think that's likely why that score is increased.
Can I have slide 12, please? Now, to be fair, this has some overlap with the last slide. A lot of overlap with the last slide. What's different is that you put the percentiles in there. Is that right?
Yes.
Now, that nonverbal IQ from the 96th percentile to the 81st percentile, is that a full standard deviation from the mean?
Well, it's almost a full standard deviation. The standard deviation for the full-scale IQ and the index scores is 15. So he had a decline of 14 IQ points, which that almost then is a full standard deviation of decline.
Is that something that's unexpected in a man who's otherwise healthy physically in his early 20s?
That is unexpected. It's very unusual outside. It's certainly very unusual in it's abnormal. It's not something that would be expected in a normal person. It is strongly suggestive of some kind of pathologic process.
Now, you've indicated that you've done neuropsychological evaluations of individuals who have later been diagnosed with schizophrenia. Can schizophrenia cause a decline in cognitive function or IQ based
Yes.
on your experience?
Yes.
How does that happen? Or how can that happen?
Well, schizophrenia and the schizophrenia spectrum disorders in general are characterized by progressive changes in the brain. And in some individuals with schizophrenia spectrum disorders who over time will show decline in some cognitive functions, intellectual functions. Some people with schizophrenia spectrum disorders show global cognitive dysfunction. And in fact, many people with schizophrenia specifically, show global cognitive dysfunction, up to 1.5 standard deviations below their peers.
Now, we certainly don't have that here, do we?
We do not.
Okay. Nevertheless, is this significant in that regard?
It is, the declines that he showed with regard to his nonverbal IQ in particular is abnormal and significant.
And I want to be perfectly clear what we're saying here. Are you saying that because these tests declined, that he has a specific diagnosis of schizophrenia or a schizophrenia spectrum disorder? Can we say that, or is that just not realistic?
No, I'm not saying that at all.
Okay, you're not saying he has schizophrenia, or you know what his diagnosis is, fair to say?
That I know what other doctors have diagnosed him with, but these test data do not diagnose him with anything.
Could be consistent with schizophrenia, could be consistent with other things as well, fair to say?
True.
Can I have the slide 13 now, please? What's this, what are we showing here, sir?
This is a lot of data. This is showing the subtests from the Wechsler Adult Intelligence Scale, 4th edition.
Okay.
And they're just laid out. They're not, they're not specified in terms of which index they go to. I can tell you the vocabulary, information, and similarities. Those are the 3 subtests that comprise the verbal intelligence index. Block design, matrix.
That was the one where he actually increased by 1 point, is that right? Because he had a +1, +1, and a -1.
That's right. His vocabulary increased by 1 point, and his information, which was his knowledge base, increased by 1 point.
Okay, and the next 3?
Then
or the next group?
Block design, matrix reasoning, and visual puzzles are all subtests that comprise the perceptual reasoning index, or the nonverbal intelligence.
And that was the larger drop there, the 14-point drop?
Right.
And then below that?
Below that, arithmetic and, actually, arithmetic and digit span are the 2 subtests that constitute the working memory index. And then the symbol search and the coding subtests constitute the processing speed index.
Now, you can take that down, ma'am, thank you. Have you seen circumstances where you've done neuropsychological testing that showed some deficits or decline, and doctors have subsequently ordered some kind of a brain picture to be taken? Can that brain picture reflect perhaps, or can that brain picture show things that are congruent with such a decline in neuropsychological testing?
Yes.
Can I have slide 14, please? This is a different domain memory?
Yes.
And was this also, this looks like the same name, Wetschler up there. Is this different than the waste, though?
Yes,
Is that the guy that came up with the tests?
it is.
And what's this test about?
This test is a very widely used test of memory function that's been around for 70 years and various versions. This is the most recent version, the fourth edition of this test. It's very widely used, again, in the English-speaking world. And it consists of primarily two domains of memory that are assessed: verbal memory, so your memory for information that comes in word form, whether it's a story, for example, or whether it's a list of words that the examinee is asked to remember. And then the other side, the other domain of memory involves nonverbal memory. So it's memory for different patterns and spatial locations.
Okay. And how did he perform on the two different occasions that you tested him in the domain of memory?
His verbal memory, the first time I evaluated him was, although within normal limits, the two on the top where it says logmem1, logmem2, that stands for logical memory 1, logical memory 2. That involves hearing a story and trying to remember it, and then being asked to recall that story at a later point in time. Excuse me. And he scored in the low average range when I evaluated him in 2013. When I reevaluated him in 2015, he had improved a bit. Part of that is clearly due to practice effect, because these are tests that are extremely vulnerable to the effects of having previous exposure to them. So he showed some increase there. Then if you look down below where it says designs 1, and then there's content 1, spatial 1, and designs 2, content 2, spatial 2. Those are tests and sub-tests of nonverbal memory. As I said before, the kind of visual patterns and spatial location. And he did show some significant decline in that aspect of memory, which again is unusual and abnormal. Again, for someone in the range of 25 to 27 years old, you should either stay the same or go up a little bit due to practice effect. But this consistent decline was unusual.
And let's talk just very briefly about practice effect and the results of this testing. If I'm understanding correctly, because he took the tests before, the second time he took the tests, the practice effect should make the score higher to some degree. Is that right?
It should. It may be a slight increase, or it may be a significant increase.
But his score went down. His intelligence went down.
That's correct.
Shouldn't we adjust it down more for the practice effect, or is that not fair? You know what I'm saying? If it should have gone up 2 points and it went down 14 points, shouldn't we account for the 2 points it shouldn't have gone up?
That is the standard practice in assessing the significance of that kind of change in scores, is to take into consideration the practice effect. So, yeah, that is usually done in the clinical interpretation of such scores.
Okay, and did you take that into effect?
I did.
And what's your opinion about the practice effect? Does that change anything?
The practice effect would estimate that his scores on again, back on the intelligence testing would be a little bit higher the second time than the first time. Again, he's functioning at a very high level to begin with. So he can only go so much higher, but he can go a little bit higher. So for example, he had a full skill IQ of 123, and that given that, you would expect that his full scale IQ the next time he takes that test is going to be a few points higher.
Like 125?
Or maybe even higher than that, maybe 127, 128.
Does that make the decline even more significant then?
It does.
Overall, sir, based upon your testing that you did in April of 2013 and in January of 2015, and the testing that Dr. Rose Manguso did 4 months later in 2013 after your testing in April, what are your general impressions or conclusions about the neuropsychological state of Mr. Holmes?
My general impression is that in many domains of mental function, mental ability, and again, all I'm referring to are cognitive functions and intellectual functions, that he remains stable in many domains, such as executive functions, language functions, most attentional abilities, but he shows an unusual and abnormal decline in nonverbal intelligence specifically, and that involves nonverbal perceptual or spatial types of abilities, constructional abilities, being able to perceive things, be able to do things and process information quickly, which is a classic feature of schizophrenia spectrum disorders. So in my overall opinion, his neuropsychological profile and the difference between the two times, particularly also factoring in that Dr. Manguso saw some subtle deficits even 4 months after I saw him. That kind of trend, that type of decline that he's showing is, again, not diagnostic of schizophrenia spectrum disorders, but it is consistent with what we know about the changes that occur in some individuals with schizophrenia spectrum disorder.
Okay, and to be clear, there's nothing about the testing that you did that suggests that in 2012, Mr. Holmes was incapable of driving, going through normal life, going to a store and buying weapons, for example, and going into a theater and shooting people. Fair to say?
He clearly was capable of doing those things.
No indication that he was mentally incapable of doing those things, is there?
There is not.
Does your neuropsychological testing, though, tell us anything about whether or not he was psychotic or suffering from a psychiatric disorder during that period of time?
No.
If I may have one moment, Your Honor.
You may.
Now that decline in IQ, can that be attributed to the fact that Mr. Holmes is sitting in jail and not doing anything other than reading books? Does that account for that big of a drop in IQ?
No, that is not going to account for that big of a drop in IQ, particularly in light of the fact that he doesn't show decline in most other areas of cognitive functioning.
Okay. Was Mr. Holmes on medication when you performed your testing, both in 2013 and in 2015?
Yes.
And what medication was he on? Do you know?
Yes.
Tell me.
He was on Risperdal, also known as risperidone.
Is that an antipsychotic?
That is an atypical antipsychotic.
And to be fair, you're not a medical doctor, are you?
I am not.
You can't prescribe medication, can you?
I cannot.
Do you have to have some knowledge of what these medicines do in order to be able to accurately conduct your testing, though? Is that part
Good.
of your expertise?
Better.
What else was he on? What was the second thing?
So in addition to Risperdal, the antipsychotic, he's also on a drug called Lexapro, or also called escitalopram, which is a antidepressant. He's also on a anticholinergic drug called Cogentin, which is commonly prescribed in collaboration with an antipsychotic medication to prevent some of the what are called extrapyramidal effects that occur with some antipsychotic drugs. They're things like motor abnormalities, tremors, and motor rigidity, those kinds of problems. So that's an important drug to administer. And then the second time those were the three drugs that he was on. The first time I evaluated him, and on the second time I evaluated him, he was on one additional drug called Vistaril, which is also called hydroxyzine. That's an antihistamine.
Let's talk about the three that he was on both times. Could those have affected the testing?
In my opinion, that's not. There's no reason to expect why those drugs would have affected his test performance. The Risperdal has been demonstrated repeatedly to actually have a beneficial effect on.
Sustained, and he already answered the question anyway, so ask your next question, please.
How about Vistaril, the drug that was on the second time? Is that something that you have to be aware of in administering these tests, the effects of Vistaril possibly?
I think you certainly need to be aware of it. It is an antihistamine drug. It has many different effects, but it does have, as an antihistamine, it does have a sedative effect at certain doses.
All right, next question, please.
May we approach, Judge?
Yes.
Thank you. With regard 13, does that have any effect upon the result?
it is possible, even though in reviewing all the test data, because I was certainly concerned about that, I don't think it did, but it certainly needed to be examined and considered.
Okay, so,
True.
okay, with that,
No.
thank you, I don't have any other questions.
All right, thank you. All right, members of the jury, it's a little bit after 12, so let's go ahead and take our lunch break. Please keep in mind all my admonishments during the break, they all apply. Let's take an hour only. There are some witnesses who have to testify today, and so I want to make sure that we don't run out of time, and that if at all possible, I don't keep you here late. So if it's okay with everyone, let's have you back in 1 hour, okay? All right, thank you. The record should reflect that the jury has exited the courtroom. Let's take our lunch break, and I'll see everyone back here in 1 hour. Thank you. The court will be in recess.
Lunch break at day 42 of the Aurora Theater shooting trial, 12:05. Only a 1 hour lunch today. We'll be back at 1:05. Marshall Zellinger here for that lunch hour. We heard a lot of testimony this morning from this Dr. Hanlon, who conducted many exams and tests on the defendant multiple times, twice. But different kind of cognitive exams, more like reaction, it seemed, and Anika, what's a better word? Maybe just cognitive, I guess. Just the type, brain function. Basically, things that shows you if you're smart and if you're aware and if you're not faking. And we heard multiple times that this doctor does not think that the defendant was faking at all in any of his analysis of when he met with him. Andy, were you ready with 7 News legal analyst joining us during the lunch hour? And I can't, is it Rick today? I forgot already. Rick Hornfeld joining us. Rick, I wanted to ask, from a doubt standpoint, well, I guess I should preface this question with this other question first. I had heard from Dr. Hanlon, he said, I did not conduct the same tests both times when I met with the defendant, that I didn't redo the social test, or however he phrased that. If I'm a juror, don't I want to hear apples to apples comparisons? Am I allowed to have doubt on a defense case versus just reasonable doubt on the prosecution case?
Well, I think that's a great question. Don't forget that the defense bears absolutely zero burden of proving anything. That said, in this case, they are putting on a case, and therefore their evidence is subject to cross-examination and subject to credibility determinations by the jury, just like the prosecution is. So while the burden of proof remains with the prosecution, I think your question gets to the practical matter that, do you create problems for yourself potentially as a defense team if you put on a case and if, in fact, the jury doesn't buy it? If the jury doesn't buy it at the end of the day and the jury at the same time believes the government has met its burden of proving each and every element beyond a reasonable doubt, then you win. But you win if you're the prosecution. In this case, though, there wasn't much risk to the defense putting on a case, because if the defense doesn't put on a case, what the jury would have been left with is several experts that said James Holmes was sane at the time of the shootings. But getting back directly to your question, there is always a risk that the people you put up are not going to be as believable as the government's side. At the same time, the defense looks at things, I think, differently than the prosecution. The prosecution has to go from point A to point B and prove each and every element beyond a reasonable doubt. If the defense, on the other hand, is essentially creating some confusion or some doubt or going back to this instruction of hesitancy, of the jury hesitating because it can't decide between the experts, then in that instance the jury has really done its job. And if there is a hesitancy by a juror and the juror follows his or her sworn oath to apply the law, again, one of the jury instructions about reasonable doubt talks about this hesitancy, then the jury is, that particular juror is going to have to return a verdict of, in favor of the defense. So there's a lot going on here, but at bare minimum, I think the defense absolutely has to put on its best case. They are putting on the witnesses that are available to it, and even if those witnesses aren't perfect, again, these are the witnesses that you've got.
As a defense attorney, do you have any right to tell the person that you essentially have hired, or in other cases, the people that are staffed where the defendant is being housed, do you have any right to say, if you're going to do whatever you do, make sure yours is duplicate as to the other person, or if you're going to do it again, make sure you do the exact same thing twice, because I need to show the jury that we hid nothing, that this is what you did this time, this is what you did the other time. Because as I'm listening to this, my thought is, okay, why didn't you redo that other test? So as an attorney, do you have any right to intervene and tell them what you want them to do?
Well, you do absolutely have that right, but I look at it not as sort of a top-down chain of command. I look at it when I'm dealing with experts in their field as a collaborative effort. So I would have a discussion, hey, look, this is what the other side did. I would like you to do the same thing because it's apples to apples. And if the person says, well, no, I'm not going to do the same thing and this is why, I want to understand why, because ultimately I'm going to be explaining that on have the witness explain that on the witness stand. So, yeah, you have a right, but at the same time, you really need to defer to that expert's professional competence. And so if, for instance, as in some of what we heard this morning, there are good reasons, you don't do the same test twice because the person might start to figure out the test or whatever the reasons are, you better be prepared to explain that, and you better hope that the jury respects the credibility and the professional experience of the witness that you are putting on. At the end of the day, a good lawyer, first of all, a good professional is not going to do anything he or she is not comfortable with doing. And so a good lawyer is going to have enough smarts to, again, work collaboratively and to decide tactically whether what the expert witness is telling you makes sense, whether you can live with that or you can't live with that.
Let's go to your prosecution experience. From what I'm listening to when I hear the district attorney cross-examine the experts prior to them being declared experts, what's the line that you might draw in terms of, in front of a jury, how aggressive you are in trying to discount who they are versus just trying to put your best case forward? Because at times I just wonder if the demeanor is overpowering the questions being asked.
I think that's a great question. There are two ways to be aggressive. One is from a demeanor standpoint, and the other is through good, persistent, kind of staccato, short, leading questions. Those two things are not synonymous. As a cross-examiner, I don't care whether you're a prosecutor or a defense lawyer, but as a cross-examiner, you are taught to control the witness. And so you can do that, and you can do that aggressively through your question techniques. From a demeanor standpoint, I was taught, and I teach my trial practice students, to treat people with respect to treat professionals and all people professionally, and to only get aggressive from a demeanor standpoint if the witness starts to bob and weave, or if the witness begins to get snarky or whatever. You have a way and you have the skill set to put them in their place. I think over-aggression and disrespect can really accrue to the detriment of the cross-examiner if a jury believes that cross-examiner from a demeanor standpoint is being overly aggressive or, more importantly, disrespectful. So, I think you got to be darn careful about how you treat people and very tactical about the method with which you question, or by which you question them.
As I continue to watch what's going on, and this question actually comes from Scribble, and it's an interesting thing that I actually thought about as I hear some of these questions from the defense. As the defense asks questions of new doctors, but they relate them to similar occurrences from previous doctors, it seems that we're bordering on cumulative, even though we have a new witness. Can you explain, and we haven't heard objections necessarily by the prosecution about cumulative, where's that line drawn in terms of we have a new witness, so this is new information from that person, but it sounds like the same information we've already heard?
Well, there's two things going on, and this has to be viewed through the prism of expert witnesses. So there's two things going on. The first is there is a record of each and everything that, expert witness one considered in coming to his or her expert opinion. Expert witness one may very well have considered the written report or the oral testimony or whatever form of evidence that was generated by expert two. So you might be hearing about expert two in the context of expert one explaining the basis of his or her expert opinion, what they took into account, why they accepted certain things or discounted certain things that was brought to their attention. So again, this is unique to the world of experts. Your normal witness is only there to talk about what he saw, what he did, what he observed, what was said to him, what he said to other people. So that's part of it. The second part of the question, is it cumulative to put on 2 or 3 experts that are essentially saying the same thing? Absolutely. I mean, it may as a practical matter be cumulative, but from a tactical matter, if you've got 2 or 3 witnesses saying the same thing, and the heart of the case is Mr. Holmes's mental state, then putting on 3 people that have, that are credentialed, that are expert, that essentially agree with each other is a way to bolster your presentation, and a way to bolster the opinions of the fellow experts, and it is not cumulative for 3 experts, as an example, I'm making up the number here, to be put on to essentially say they independently came to the same expert opinion. So they're kind of 2 different issues, but they're both really, really good questions, and they both really pertain to experts. You probably could not put 3 police officers up to say, I recovered a bullet casing from the sidewalk outside the murder scene, because who cares? Once you've established that, if it's not really an important point, you've made your point. But here, obviously, mental state is extremely important. It's the whole, it's the whole case.
And to the mental state, this final question also comes from Scribble, Rick, and we're maybe taking a step backwards here. We know that the prosecution has the burden of proof in all cases, but when a defendant pleads not guilty by reason of insanity, why is it still that the prosecution has to prove sane versus the defense proving insane?
Because that's what the Colorado legislature said should happen. So Colorado is one of 11 states where once you've successfully raised the defendant's mental state by virtue of pleading guilty by reason, not guilty by reason of insanity, the Colorado legislature has written the law in a manner that adds the burden to the prosecution. I was having this discussion with several lawyers, friends the other night, and from my perspective, as a former prosecutor, as a defense lawyer, and as a citizen, I laud the state of Colorado for doing it that way, because traditionally it is the government, it is the sovereign that has the burden all the time. It is their job to prove each and every element beyond a reasonable doubt. And so I think the Colorado legislature's pronouncement in this area is absolutely consistent with 200 and whatever it is, 30 or 40 years of American legal history, and I'm very proud as a native Coloradan that that's the way it is. It is the government's burden. It should always be the government's burden, and good prosecutors accept their burdens, as these prosecutors are doing. They accept their burden, and that is their job, and they do their very best to meet their burden. Sometimes they meet it, sometimes they don't. But the law in the state of Colorado and 10 other states is consistent with this country's judicial and criminal justice history, and that's my pre-4th of July flag waving explanation for it. But it, as I said, I think it's the way that it should be.
Joining us at the lunch hour on day 42. Thanks for joining us, Rick. We'll check back in with you if court ends at the appropriate time this afternoon. It is 12:20 right now, about 45 more minutes worth of lunch to go through because they're taking only an hour lunch today. And for those of you that, if we hadn't mentioned it, tomorrow is an off day in court, and if my memory serves, there will basically only be 2, possibly 3 more days of witnesses called by the defense. We know Dr. Gurr will be called, likely one of the last witnesses, and we were talking with our legal analysts over the last couple weeks that it's still possible that the defendant's parents could be called, particularly because evidence has been included in this trial as it relates to email to the parents so that they could then come in and speak to those pieces of evidence, which is why they might be allowed to take the stand. What we're going to do right now is play back some of the testimony from earlier today. You saw a former employee of Marical, or a former coworker, I should say, of the defendant from Marical to talk about an HR issue with the defendant, but this went back, I think she was testifying from the time frame of 2010 to 2011, and that caused an objection by the prosecution. And Anika, we'd been talking about this yesterday in terms of, objecting to something you didn't object to something earlier on, so now you can't object to it now. Well, we finally saw another instance of that where the judge told the prosecution, you haven't had a problem with this line of questioning from other witnesses until now. It's untimely because you missed the boat on your chance to object. So that's why she was allowed to take the stand. And then we're going to play back for you some of Dr. Hanlon's long testimony from this morning, comparing his and Dr. Manguso's tests that they conducted on the defendant over the course of the last, between the first time they met them, I think sometime late, I think it was 2013 was the first I heard, to one exam that took place, I want to say January of this year. So we'll get you back on the other side, probably interrupt this testimony to take you back into live court around 1:05. Beach ball. We've got the beach ball. We will let it play out, and I think yesterday the Mac took about 14.3 seconds to get rid of the beach ball.
How did you very first meet him?
I very first met him when he came in to interview for a position.
Did you do the interview?
Yes, I did.
And did you, tell the jury what your observations were of Mr. Holmes at that time?
Sure. He was dressed very professionally. I remember specifically he was dressed in a button-up shirt and a tie. He was a little bit different, but he was able to answer all the questions, and he fit the bill for the position.
And did you hire him?
I did hire him.
And what was his job at Marical?
He was a coding operator.
And what does that entail?
So a coding operator is when the vitamins and the pills were being manufactured, if there was a certain color or a certain texture that the pills needed to be, he was in the department where he was overseeing that process and making sure that the pills were colored according to the customer specifications.
Okay. And did he come in through a temp agency?
Yes.
Did you have any other interactions with Mr. Holmes?
Yes.
Can you describe those for the jury, please?
Sure. I interacted with him during his interview process, during his onboarding, so we had to train in order to get him up to speed for the position, and then also with an HR issue that occurred.
How long do you think you spent with Mr. Holmes in the interview process?
Probably about 30 minutes
And
would be a
how-
guess.
Okay, and how long in, while you're training him and getting him acclimated to the lab?
That would have been probably more like 2 hours.
All right, and then you said you also had some interaction with him during an HR issue?
Yes.
During these interactions, and we'll talk about that issue in a minute, but
Okay.
during all of your interactions with Mr. Holmes, what sort of impression did you have of him? What did you observe about him?
I observed him a little bit different
How so?
than others. It's hard for me to put it into words. I guess he reminded me a lot he reminded me a lot of my children. He was very he seemed like he wasn't all present all the time. I mean, not that he was not intellectual or intelligent, but just that he was in another place.
And why does that remind you of your children?
My children have some special needs.
And what is that special need?
I have 2 children, and my older son is diagnosed with Asperger's, and my younger son is diagnosed with autism.
And so what sort of things did Mr. Holmes do that reminded you of your children?
He did not make eye contact with people very easily or with me, and he just seemed very socially awkward and just in another, I don't know how to explain, but in another place. Like his mind was not always present.
Did it
appeared.
seem like he was just bored and shy, or did it seem more than that?
No, I wouldn't say bored and shy. I wouldn't say that.
Okay. Did he start up conversations with anyone that you saw?
Not that I observed.
Okay. Did he socialize with other employees?
I don't know. Not to my knowledge.
All right. And if you could just briefly explain what sort of interaction you had with Mr. Holmes during that HR issue, that human relations issue that you mentioned.
Sure. So while he was working in the coding area, it's a small space, and there's usually 2 people that work in the coding area and then a quality control person that comes in and out. And there was an issue where the quality control person felt that James was working too slowly and was prodding him to work more quickly. And one of the other employees stepped in and told the quality control person to stop, and it created a confrontation with some racial slurs.
Okay. Did the racial slurs have anything to do with Mr. Holmes?
No.
Not
No.
the victim or the perpetrator of the racial slurs, correct?
No, just a witness.
Okay. And so when you, what sort of interaction did you then have to have with Mr. Holmes regarding that issue you were investigating?
Sure. So whenever there's an issue, we would bring in anyone that had knowledge of the incident. So I brought him in and asked him some questions to clarify what had happened that day.
Okay. And the jury has heard from David Maldonado and Jose Sanchez. Were either of those 2 men involved in this incident you're describing?
No.
All right, so they were 2 completely different people.
Yes.
All right. What was your observation about the way Mr. Holmes presented when you were talking to him about the incident?
He had very little to say about it.
Okay.
He answered questions very briefly, but really seemed to have no knowledge of what had happened.
Did he give any sort of narration about what happened, or was it just basically answering your questions?
Basically answering my questions.
Okay. And during that conversation, did he make good eye contact with you?
Not that I recall, no.
Was he ever rude or arrogant that you saw?
No.
Was he polite and nice?
Yes.
Okay. If I can have just a moment.
Yes.
Thank you, Ms. Fournier. The prosecution might have some witness
Thank
questions for you.
Thanks.
Cross-examination, Ms. Stitch McGuire.
Thank you, Your Honor. Good morning.
Good morning.
It's true that you had not met the defendant prior to his employment at Miracal prior to 2011. Is that true?
Yes,
And your interactions with the defendant were brief, potentially 3 to 4 hours over his entire term of employment at Miracal. Is that fair to say?
yes,
And you have not had any interaction with the defendant since his departure in January of 2011.
yes,
And realizing that your interaction with the defendant in 2011 was a year and a half before the defendant was charged with the murders of 12 individuals and the attempted murders of 70 other individuals.
I'm sorry, say that again?
Your interaction with the defendant last interaction in January of 2011 was over a year and a half before this defendant was charged with the murders of 12 individuals and the attempted murders of 70 more.
Yes,
And your interactions with the defendant consisted of his initial hiring interview. Are people often nervous?
Hold on. Is that a yes?
yes,
Go ahead.
Thank you, Your Honor. Your interactions consisted of his initial hiring interview. Are people often nervous during an initial interview?
some people are nervous.
And the other issue was an HR investigation.
Yes,
Are people often nervous during an HR investigation?
again, some people, yes,
And you're not a psychologist,
no,
not a psychiatrist.
no.
And what is your profession currently?
I'm in human resources.
And when you interacted with the defendant, did he appear to understand everything you said?
I believe yes.
And you thought the defendant was qualified, if not overqualified, to attain the job at Miracal when you hired him?
I believe he was qualified, yes.
Do you have very many applicants for this type of position with someone who is cum laude graduate of the University of California at Riverside?
Not specifically, no.
And you specifically looked for characteristics in the person you were hiring because you had had some employment issues with other employees at Miracal. So you were specifically looking for someone who would keep their head down and do a good job. Is that fair to say?
Yes.
So in the midst of the drama that was caused in this racial incident, didn't the defendant do exactly what you had hoped that employee in his position would do, which was to keep his head down and to not get involved in any of the drama?
I would say yes, but I also would say that in an investigation, we would expect them to cooperate and provide information relevant to the investigation.
And did he cooperate?
He did.
And in fact, you're not even the HR director of the facility where the defendant was located. Is that fair to say?
Yes, that is correct.
So there was an HR director who would have had more opportunity to interact with the defendant at Vista, which is the facility where he was actually employed.
Actually, there's no HR director in the Vista facility. It was an HR assistant.
But there was an HR assistant there at the Vista facility.
That is correct.
And you were located in the Orange County facility.
That is correct.
I have no further questions. Thank you, Your Honor.
All right, thank you. Is there any redirect?
When, just briefly, Your Honor, when Mr. Holmes was giving you just those short answers during the investigation, did you get the impression he wasn't cooperating, or whether he just, as you had seen before, he just didn't have much to say, he just didn't talk a lot?
He just didn't talk a lot.
Okay.
Yeah.
Thank you. I don't have anything else.
Ms. Tisch-McGuire, do you have any recross?
No, thank you, Your Honor.
All right, and the jury does not have any questions for this witness. May this witness be released from her subpoena?
Yes, sir.
Any objection?
No, thank you, Your Honor.
Ms. Fournier, thank you.
Thank you.
Call your next witness, please.
Dr. Robert Hanlon.
Heard Dr. Manguso's testimony yesterday where she said that in her testing there was some very slight cognitive impairment in some of the testing that she did. Do you remember that?
Yes.
And Mr. Brockler made a point to bring out that it was slight impairment and not a dramatic impairment. Fair to say?
He did.
Is that something that you noticed when you got the results of her examination?
I did. When I received Dr. Manguso's report, I was very clearly aware that she had determined that Mr. Holmes, in the testing that she did, showed evidence of very mild, subtle neuropsychological deficits or cognitive deficits, which was different than my original evaluation, in which he showed no evidence of any neuropsychological or cognitive impairment. So that was a difference. There was really only 4 months in between those two, my first evaluation and then Dr. Manguso's evaluation. And so there appeared to be, again, slight, minor, subtle change.
Is that one of the reasons why you thought it might be a good idea to do another evaluation?
Sustained?
Was that or was that not one of the reasons why you thought it was a good idea to do another evaluation?
Yes, that was definitely one of the reasons that a second evaluation was considered, in that he had shown some evidence that there were differences between the original evaluation that I did and the second evaluation, or the evaluation that Dr. Manguso did.
And that second evaluation took place earlier this year, is that right?
That's correct.
Why was that one shorter? By 2 hours, 2.5 hours, I guess.
It is a little shorter because there were a couple of areas that I really did not think it was necessary to retest him on. I did not, for example, do any reassessment of social cognition.
Okay. So let's go through some of the testing that you did do, and I want to start out with validity testing, if I could do that. Could I have slide 4, please? Now, what is validity testing, and why is it important, sir?
Validity testing, as shown on that slide, for just to be blunt about it, is our testing done with the attempt to rule out or determine if an individual is exaggerating symptoms, if they're feigning symptoms, or if they're just flat out malingering. These are crucial tests that need to be included in any neuropsychological evaluation, whether it be for a forensic or the criminal defendant or even a clinical patient. It is imperative. It is extremely important for a neuropsychologist to be able to conclude that the test data are valid, they're representative of the status of this individual at this time. And so that's why these kinds of tests are administered.
Okay. And on this graphic, can we call out, ma'am, the first part, the performance validity part, including the dates, if that's possible? Including the dates, if that's possible. Now, in this graphic, thank you, ma'am. In this graphic, 413, is that your first set of testing?
Yes.
813, is that Rose Manguso, Dr. Rose Manguso's testing?
Yes.
And 115, is that your second set of testing?
Yes.
And 714, what does that represent?
That represents the second evaluation that Dr. Gray did. Dr. Manguso, my understanding, did not do any further neuropsychological evaluation at that time. It was only Dr. Gray.
And is that why that's blank? Because there was no neuropsychological evaluation done at that time?
Right.
So it looks like you only have two tests that Dr. Manguso administered in August. Did she administer more tests? Are those just the ones that overlap with yours? Of symptom validity, I mean? Or do you not recall?
Those are
in other words, she didn't administer the word memory test, the Victoria symptom validity test, the B test, the reliable digit span, or the California verbal learning test, did she?
Actually, thank you for asking that, Doctor, and I apologize. I've omitted a score from Dr. Manguso.
Okay.
She, in fact, did administer the B test, and that score should be there. That would be another 1. So, as she testified yesterday, she did, in fact, administer 3 different performance validity tests: the test of memory malingering, the validity indicator profile, and the B test.
Did you just call me doctor?
I'm sorry, did I? No offense.
I'm getting used to that. Does, tell us about the validity testing that you did, sir. What you did did you do the TOMS like she did?
I did.
And what was the result of that?
The Tom was, he performed, I believe, perfectly. I think he had 100% accuracy. I can check and, well,
Feel free to check if
I
you
can
want
easily
to.
check and see.
Are you looking at your report?
I'm looking at the addendum to my report, which is the data sheet.
Thanks, sir. Yeah.
I chose the tests.
Did you choose the exact same test that Dr. Manguso did?
No.
Okay. Were they similar? Can you tell us what the difference was or what the similarities were?
They are similar tests in that they're both tests. They're both tests that constitute different what's called a neuropsychological battery of tests. And as Dr. Manguso stated yesterday, she was somewhat constrained by the fact that the defendant had already undergone a neuropsychological evaluation 4 months before she evaluated him. So she didn't want to use some of the same tests that I had used because he had previous exposure to them and would remember them. So, for example, Dr. Manguso did not assess intelligence in Mr. Holmes. She did not do testing to produce an IQ. But she did do memory testing. She did testing of attention, concentration. She did testing of language, perception. She did some testing of constructional abilities. She certainly did executive functions, and she did some of the same tests of executive functioning that I had done previously. She did assess reasoning. She didn't really, I don't recall, assess any aspects of social cognition. And like me, she is very rigorously assessed symptom performance and validity.
Thank you. Can I have slide 3, please? When did you do the examinations of Mr. Holmes, and where and when did you do them?
I did the first neuropsychological evaluation of Mr. Holmes in April of 2013 in 3 consecutive days. They were conducted at the Arapahoe County Detention Center next door. And so over a period of 3 days, I spent 13 and a half hours primarily testing him. It was maybe an hour to an hour and a half what constituted the clinical interview.
And then you did a second neuropsychological evaluation?
Yes, and there was a second neuropsychological evaluation done in January of 2015 in 2 consecutive days, January 5th and January 6th. Also done at the Arapahoe County Detention Center next door.
And Dr. Manguso testified some about this, but is it a good idea to do, over time, to do testing again at a later period?
It is. It's a common practice. There are many psychiatric and neurologic disorders which serial or series of neuropsychological evaluations are required to objectively assess change over time. I mean, it's commonly done in the dementias, Alzheimer's disease, vascular dementia, et cetera. It's also done in traumatic brain injury. It's also done in conditions, in psychiatric disorders, particularly when there's treatment intervention.
You heard Dr. Manguso's testimony yesterday where she said that in her testing there was some very slight cognitive impairment in some of the testing that she did. Do you remember that?
Yes.
And Mr. Brockler made a point to bring out that it was slight impairment and not a dramatic impairment. Fair to say?
He did.
Is that something that you noticed when you got the results of her examination?
I did. When I received Dr. Manguso's report, I was very clearly aware that she had determined that Mr. Holmes, in the testing that she did, showed evidence of very mild, subtle neuropsychological deficits or cognitive deficits, which was different than my original evaluation, in which he showed no evidence of any neuropsychological or cognitive impairment. So that was a difference. There was really only 4 months in between those two, my first evaluation and then Dr. Manguso's evaluation. And so there appeared to be, again, slight, minor, subtle change.
Is that one of the reasons why you thought it might be a good idea to do another evaluation?
Sustained?
Was that or was that not one of the reasons why you thought it was a good idea to do another evaluation?
Yes, that was definitely one of the reasons that a second evaluation was considered, in that he had shown some evidence that there were differences between the original evaluation that I did and the second evaluation, or the evaluation that Dr. Manguso did.
And that second evaluation took place earlier this year, is that right?
That's correct.
Why was that one shorter? By 2 hours, 2.5 hours, I guess.
It is a little shorter because there were a couple of areas that I really did not think it was necessary to retest him on. I did not, for example, do any reassessment of social cognition.
Okay. So let's go through some of the testing that you did do, and I want to start out with validity testing, if I could do that. Could I have slide 4, please? Now, what is validity testing, and why is it important, sir?
Validity testing, as shown on that slide, for just to be blunt about it, is our testing done with the attempt to rule out or determine if an individual is exaggerating symptoms, if they're feigning symptoms, or if they're just flat out malingering. These are crucial tests that need to be included in any neuropsychological evaluation, whether it be for a forensic or the criminal defendant or even a clinical patient. It is imperative. It is extremely important for a neuropsychologist to be able to conclude that the test data are valid, they're representative of the status of this individual at this time. And so that's why these kinds of tests are administered.
Okay. And on this graphic, can we call out, ma'am, the first part, the performance validity part, including the dates, if that's possible? Including the dates, if that's possible. Now, in this graphic, thank you, ma'am. In this graphic, 413, is that your first set of testing?
Yes.
813, is that Rose Manguso, Dr. Rose Manguso's testing?
Yes.
And 115, is that your second set of testing?
Yes.
And 714, what does that represent?
That represents the second evaluation that Dr. Gray did. Dr. Manguso, my understanding, did not do any further neuropsychological evaluation at that time. It was only Dr. Gray.
And is that why that's blank? Because there was no neuropsychological evaluation done at that time?
Right.
So it looks like you only have two tests that Dr. Manguso administered in August. Did she administer more tests? Are those just the ones that overlap with yours? Of symptom validity, I mean? Or do you not recall?
Those are
in other words, she didn't administer the word memory test, the Victoria symptom validity test, the B test, the reliable digit span, or the California verbal learning test, did she?
Actually, thank you for asking that, Doctor, and I apologize. I've omitted a score from Dr. Manguso.
Okay.
She, in fact, did administer the B test, and that score should be there. That would be another 1. So, as she testified yesterday, she did, in fact, administer 3 different performance validity tests: the test of memory malingering, the validity indicator profile, and the B test.
Did you just call me doctor?
I'm sorry, did I? No offense.
I'm getting used to that. Does tell us about the validity testing that you did, sir. What you did did you do the TOMS like she did?
I did.
And what was the result of that?
The Tom was, he performed, I believe, perfectly. I think he had 100% accuracy. I can check and, well,
Feel free to check if
I
you
can
want
easily
to.
check and see.
Are you looking at your report?
I'm looking at the addendum to my report, which is the data sheet.
Thanks, sir.
And if you could please show the jury where you were seated and point out your seat and then the seats of your friends.
Sure. Okay, so I was seated somewhere around here. Petra was sitting in between us because Ethan was sitting right there.
Right, please tell the jury about what you witnessed in the theater that night.
Well, we got there probably around 11:30, like in the theater itself. So we sat there and talked. It was a pretty normal night at the movies. And then the previews came on, and I remember, during the previews, I remember distinctly seeing, people who were very excited to see these movies. And I remember seeing a very large gentleman sitting maybe 3 seats in front of us during the Superman preview in particular. This stands out in my mind, and him getting up and just being so excited to be there. But then the movie started, and about 20 minutes into the movie itself, I would say, I remember seeing an object basically pass through my line of sight when I was looking at the screen, and it made this like hissing noise, and I had no idea what it was, but it landed somewhere around here, and as soon as it landed, I remember seeing up here by the emergency exit this flashing light and this very loud noise, like a booming noise, and it sounded to me like fireworks. And so I'm seeing this light. I think it's a prank. I don't really know what's going on. I was very disoriented. But shortly after that, maybe 2 seconds afterwards, I noticed that people were screaming, were getting out of their seats. The room was starting to fill with smoke. And about that same time, I just instinctively held my hands in front of my face. And in that same moment, I felt this immense pressure on my chest and basically my whole upper body. And I fell forward in front of my seat.
Could you describe for the jury how your body was positioned when you fell forward in your seats?
So I just, fell into I guess you'd call it a row in front of the seats. And I think I fell on my knees, but I think I then sat backwards, so I was just sitting in front of my seat.
Right? What do you recall happening after that?
Well, the first thing I remember is that I couldn't feel my left arm at all. It was suddenly completely numb, and I actually thought that it had been blown off or something, and I actually had to look at it to confirm that it was still attached to my body. And the other thing I remember more than anything was that my neck was just swelling with blood, and it was bleeding very profusely. And I knew that I had been shot, but I really didn't know the extent of my injuries. I just knew that there was something in my neck. And I mean, I was scared to death because I thought, you know, what if my artery has been hit, or, you know, my neck was severely injured. So I mean, I just remember sitting there and thinking, this could be it. This might be the end.
What's the next thing you remember happening in the theater?
So while I was sitting there and I guess taking stock of my own injuries, I remember next to me Petra screaming at the top of her lungs, and I remember on her right side Ethan calling 911. He was on the phone. He had the presence of mind to do that right away. And all along there was just that booming noise. It kept going, and it was, to me, it was almost like one every second. It sounded methodical to me. And so that was continuing. I was sitting in my own blood, and Petra was screaming. Ethan was screaming as well. And
What do you recall after Petra screaming and hearing all those gunshots?
so at some point the gunshots stopped, and I don't know why they stopped. I didn't know. And in that same moment I saw light coming from this area of the theater. And I looked to my left, and I didn't realize beforehand that there was an emergency exit there, and people were rushing out of it. And I didn't really think about it. I just got up and went out the exit.
All right, I don't have any further questions for you up at this model. If you could retake your seat on the witness stand. Thank you very much, Mr. Barton. Please tell a jury about what you recall happening after you went through that exit door.
So after I went out that exit, there's a stairway that leads into the lobby. And I remember going down that stairway with a lot of other people, many of whom were covered with blood. And in the lobby, I remember hearing a couple more gunshots and wondering if there was another shooter. But I was just, you know, moving with this whole group of people out into the parking lot.
You didn't see another shooter in the lobby.
No.
What happened after that?
Well, once I got out into the parking lot, there were, I don't know, maybe 100 people out in the parking lot, sort of confused, milling about.
403, cumulative.
Sustained.
Were you transported for medical treatment?
I was. I was transported first to a triage area in the parking lot, and then to the medical center of Aurora.
How were you transported to the medical center of Aurora?
In the back of a police car.
Was there anyone else in the police car with you?
There was.
Relevance 403.
Overruled?
You may answer the question, Mr. Barton.
Yes, there was someone else in the police car with me. He had a...
All right, hold on. Next question.
Did you observe any injuries on the person in the police car?
Objection. Relevance 403.
Sustained.
What injuries did you sustain as a result of the shooting?
And just for the record, sustained under Rule 403, cumulative.
Thank you, Your Honor.
I received multiple shotgun wounds. So, do you want me to describe that in further detail?
Please do.
So I had 4 pellets in my face, at least 3 in my neck. Three in my chest, 3 in my right shoulder, 3 in my forearm, 1 in my right hand, and 1 in my left hand.
Your Honor, if I may approach Mr. Barton with what's been marked as People's Exhibits 4874, 2022, 2023, 4875.
You may.
Thank you, Your Honor.
No objection to these exhibits.
All right. Are you moving their admission, Ms. Teach-McGuire?
Please, Your Honor.
All right, without objection, they're all admitted and they may be published.
If I could please have 2021.
Did you say 2021? I think you indicated that you were approaching with 2022 and 2023, but not 2021.
I apologize, Your Honor. If I could have 2022. Great, Mr. Barton, please describe for the jury what we see in this photograph.
So this is my right shoulder, and you can see pieces of gauze that are covering the entry wounds for the shotgun pellets.
If I could have 2023. Please describe for the jury what we see in this photograph.
So you can see my right eye. That's where one of the shotgun pellets entered my head. There's also a spot by my mouth, which is where another shotgun pellet entered and actually fractured my molar and embedded in my right cheek.
All right, if I could please have 4874. Describe for the jury what we're seeing in this photograph.
So the big wound you see is where a shotgun pellet entered my cheek and exited. You can see also the exit wound.
Right, and what is underneath the gauze that we see in that photograph?
So that is from the emergency surgery I had that night at the Medical Center of Aurora to remove some pellets.
Where did they remove those pellets from?
From my neck. So they made 2 large incisions.
If I could please have 4875. And then what else can we see in this photograph?
Once again, there's gauze covering, the small pieces of gauze that are covering the entry wounds. There's also an uncovered one on my left chest, and also the gauze from my neck surgery. And you can also see my chin where another shotgun pellet entered.
Where were they able to remove pellets from your body, Mr. Barton?
Well, that night, just from my neck.
All right, did you subsequently have other pellets removed from your body?
I did.
Please
Yes.
tell the jury about where those were removed.
Those were removed from my left hand, the palm of my hand, my right forearm, and my face. And there was also, I forgot, the one on my shoulder that was removed.
How many pellets still remain in your body, Mr. Barton?
8.
Where do those remain?
There are 3 in my chest, 2 in the muscle, and 1 basically in my sternum. And there are 2 in my neck still.
Did you also have to have oral surgery for the molar that was fractured?
Yes, I did. It was replaced with an implant.
Do you have any lasting injuries as a result of the shooting?
I do. If you remember, I said my left arm went numb that night. That was because of nerve injury to the left side of my torso. And so that is still very weak, and it causes me discomfort pretty much when I'm doing anything, at least some discomfort. And my neck is still very sore and becomes very sore at the end of the day.
I have no further questions for this witness. Thank you, Your Honor.
All right.
All right, could you please tell the jury where you were seated and where Miss Davies was seated?
Sorry. Okay. I was sitting right here in the aisle seat, and she was to my right.
All right, please tell the jury about what you recall happening in the theater that night.
About 15 or 20 minutes into the movie, I heard a loud noise that sounded like either someone like kicking in a door or just like a louder like metal bang. And I looked to my far right corner because there's an exit down there, and I saw the door open and someone walk in that kind of looked like he came from Call of Duty.
What is Call of Duty?
It's a video
I'm
game.
going to object to the characterization.
Hold on. And there's an objection.
403.
Sustained.
Right, could you please just describe what that figure looked like for the jury?
Just all black with a mask and maybe some like body armor.
Anything else that you could see about that figure at that time?
Just it was really dark in that corner, so it just looked like a big black metaled blob.
What do you recall happening after you saw the figure come into the theater?
Just kind of stood there for a little bit, so I wasn't really sure if it was someone like leaving or coming in. And then I saw a canister kind of fly behind me a couple rows, so I ducked a little bit because I heard like a weird hissing noise coming out of it.
What do you remember happening after the canister?
I remember hearing some people not really screaming, but just kind of like shuffling or like talking just in my back where it landed. So I turned up and looked over my left shoulder to see like what it was or what people were doing behind me. And then I just heard a really loud noise and I blacked out.
What's the next thing you remember after you blacked out?
I woke up and there were people running on top of me. And my friend, because I had fallen into the aisle seat, and I tried to push myself back to like the seat area.
I'm going to interrupt you for a second. I apologize. Could you show the jury on here where you had landed?
Yeah, I just fell like right into this aisle seat, like next to my seat. And then I tried to crawl to like where underneath the seats, like where your feet would be. And my friend was able to help me get underneath there.
What happened after you were able to get back into the aisle and avoid being trampled?
She tried to get me to stand up, and I realized that I couldn't. My entire like right side of my body just wasn't responding. And then I realized that I couldn't breathe. So I just kind of laid there and tried to find a position that I could breathe.
Why were you not able to breathe at the time?
I had been shot in my neck and also in my lung, so I was pretty like choking and drowning on my own blood.
What do you recall while you were down on the ground?
I just remember Stephanie calling 911 when she realized that I couldn't stand up. And then when she saw, I just, like I said, tried to find a position that I could breathe. And then when she turned her attention to me and saw what had happened, she came over and put her hand on my neck because she saw I was bleeding so much.
What do you remember after that?
We just laid there for a couple minutes. I just remember telling myself that I had to keep trying to breathe. Stephanie's hand was just on my neck and she was just staying with me. And then after a while, the lights came on and she just told me that I had to stay there and be quiet.
Could you hear anything in the theater while you were down on the ground?
I kept hearing a lot of noises, but it was really hard because the movie was playing, so it sounded like distant gunfire, but then also the occasional like really close, loud gunfire, but it was a little bit hard to distinguish between the two.
What were you thinking while you were down on the ground?
Objection to relevance.
I was just thinking that I had to breathe because it was just such a struggle.
How are you able to get out of the theater?
After a couple of minutes of just lying on the ground, and after the lights came on, a couple of police officers came through the exit right next to us, and they were just telling everyone that we had to get out. So I still couldn't stand, so I kind of had to crawl over to the aisle to this railing to help lift myself up, and then kind of hobble out of the theater through this exit.
What happened when you left through this exit?
We got out to like the lobby area in the theater, and there were just more cops telling us, like ushering us to get out of the theater. So I just kind of had to lean on Stephanie and hobble out to the exit.
All right, at this time I'm going to ask you to retake your seat at the witness stand. Thank you.
Approximately 20 or so minutes into it, there was a scene that included some gunfire and some shooting, and we heard some extra noise, so some louder noises in the theater, which we recognized were not part of the movie. At first we thought they were firecrackers or fireworks, and at that point we realized something was not right in the movie theater.
What do you remember happening after that?
Shortly after we heard the fireworks, or what we later learned were gunshots, I felt my face get hit on the right side, and immediately my hands cupped under my face like this, and one of my bottom teeth was in my hands, as well as a great amount of blood.
Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Are the parties ready for the jury?
Yes, sir.
Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect the jury's back in the courtroom. Welcome back, folks. I hope you had a good lunch. All right. Right before the break, Mr. King finished his direct examination of Dr. Hanlon. Doctor, I remind you that you're still under oath. And Mr. Brockler, you may proceed with your cross-examination.
Thank you, Your Honor. Doctor, I want to talk to you a lot about what Mr. King was able to elicit from you, but before I do that, I really want us to focus on the purpose that you are hired to serve as well as the scope of your opinion. Can we do that?
Certainly.
Now, you were asked to do a neuropsychological evaluation of the defendant in April 2013. Is that fair?
Yes.
And that is some 8 months or so after the shooting at the theater and the bombs in the apartment and all that stuff. Fair? It could be 9 months.
Yeah, a little longer than that.
Okay, is that right that you did that?
Yes, that is right.
And then you were asked to do another neuropsychological evaluation, not completely different from the one you did in April of 2013, in January of 2015. Fair?
Yes.
You have provided no opinion on sanity, correct?
True.
And that's not just true for July 19th or 20th. You didn't offer up an opinion for sanity for any time period. Fair?
That's right.
And your opinions are based upon just those snapshots of testing, in large part, that you've taken from April of 2013 and January of 2015, and then some information you reviewed in between. Is that fair?
Yes.
You did not go back and review the conduct of the defendant as it existed leading up to July 19th and 20th.
True.
Now, one of the and so that I'm clear, you're not here to tell this jury that you can give them an opinion about this man's capacity to form the intent to murder after deliberation on July 19th and 20th, 2012.
I am not.
And you're not here to provide them any information on the defendant's capacity to know right from wrong based on societal standards of morality back on July 19th or 20th, 2012, correct?
I am not.
And you can't provide them, and you don't provide them, with an opinion on even his capacity to have done those two things as of January of 2015.
True.
Really, it's limited to an exploration of what potentially could be a mental illness that exists between April of 2013 and January of 2015. Is that fair?
Yes.
Now, one of the things that Mr. King started off by asking you was, hey, look, weren't you largely and completely independent in the way in which you were able to conduct this neuropsychological evaluation? Do you remember that?
Yes.
And that there were no limitations imposed upon you in terms of how you went about that neuropsychological evaluation?
Objection, Judge. That misstates the testimony.
Overruled.
Well, I guess I'll ask you an open-ended question. Were limitations placed on your neuropsychological evaluation of the defendant in April 2013?
There were no limitations placed on me by any other sources. I was asked to conduct a neuropsychological evaluation. I defined what that neuropsychological evaluation would consist of, and that's how I proceeded.
And if there were any additional documents, records, or information you believed you needed to be thorough in this investigation, heck, you'd have asked for them, wouldn't you?
I would have.
And if they hadn't provided them to you, as you said to us in direct, I would not have conducted the evaluation and you said you to Mr. King, had you limited me. Is that fair?
True.
The reason I ask is, and I want to ask about this, is look, the person that hires you and pays you, they tell you what they want to accomplish, right? And I mean by neuropsychological evaluation. I'm not talking outcome. I'm saying neuropsychological evaluation. They tell you what they want, right?
Right, he told me he wanted a neuropsychological evaluation.
You routinely write reports whenever you do a neuropsychological evaluation.
Yes.
There really aren't any good reasons to not write reports after you do a neuropsychological evaluation, right?
Well, let me qualify that. There are times when I do a neuropsychological evaluation and I am then asked not to produce a report.
Whoa. Well, but you won't let yourself be limited in how you do it and how you... Would you, if someone told you don't write a report, you'd say, I got to write a report. This is how I do my neuropsychological evaluation. This is how I document it. Would you do that, or would you do what they asked you to do?
No, if I will conduct the evaluation as I see fit. If I am then asked not to produce a report, I will honor that request.
And you know that the report serves some pretty important functions in this system, correct?
I do.
Those reports, one, are going to be weighed and considered by the very people that picked you out and hired you, right?
Yes.
They're also going to be considered by the other side, which in every single criminal case you've ever handled has been the prosecution, correct?
Yes.
And the prosecution is going to make decisions about it. The judge, this court, maybe even this jury are all going to rely upon that report in some way, don't you think?
Probably.
So to not generate a report is to deprive the other members of the system that information. Fair?
Fair.
All right, and that's, the reason I ask is, and we'll get to what happened here in this case, but that's exactly what you did in a case called People versus Wood out in, I think it was Illinois. Do you remember that? You testified in that case, and you did not generate a report. Do you remember that?
Objection, relevance.
Your Honor.
Why don't you approach?
Yeah, yes, that's better. Doctor, I'll be candid, I don't remember the exact question. Do you remember it? Well,
I don't remember the exact question. I think it had to do with why I didn't produce a report.
Yeah, let me just, if I've already asked this particular question, forgive me, but what I want to get to is this. Look, you've said that you think generating reports are important, and you've described for us or agreed to why they're important in the system, correct?
Yes.
And you also agreed that you would withhold writing such an important report if you were asked by the people that hired you to not generate a report. Fair?
True.
And in fact, you did that in another, I think it was a murder case, People versus Wood, correct?
Right.
Now,
Can I add something to that?
on redirect, Mr. King can follow up on all of this stuff. Is that fair?
Sure.
There was something else I wanted to ask you about, though. So in terms of conducting this neuropsychological evaluation, you described for us through Mr. King how broadly that was defined, just go out and do a neuropsychological evaluation. One of the things that you think is important is to interview other family members about the person you're doing the neuropsychological evaluation on. True?
Yes.
And you think it's important to do that to obtain as much information from as many sources as possible, correct?
True.
And you want to get input from individuals and significant others who know the defendant very well, correct?
Yes.
And you did not do that in this case, correct?
True.
And you didn't do it in this case not because you didn't want to, right?
True.
You asked them to let you interview them, and they did not. Fair?
True.
To be clear, being denied access to information you asked for did not cause you to say, that's it, I don't want to play anymore, right?
True.
In fact, even in this particular case, you said you conducted 2 evaluations, and we've talked about the dates. You remember that?
Yes.
There are subjects that you inquired about with the defendant in January of 2015 that you did not inquire about in April of 2013. Is that fair?
Yes.
And the specific reason that you inquired of those areas of the defendant 2 weeks before the trial started was because Mr. King told you to. Fair?
He asked me to.
And you did it.
I did.
And then wrote it in your report.
True.
In terms of this particular, we'll take these in order. The first time you meet with the defendant is April, is it 8th, sir, of 2013?
I think it's 18th.
18th, thank you, April 18th. And before you do any testing, you sit down and you go through with him a bunch of questions, don't you?
Yes.
Now look, before you did that, before you sat down to ask him questions, had you already gone through the materials that the public defender's office was willing to give you?
Yes.
And if they don't give you the records, you don't know that they exist, correct?
Yes.
I want to go through some of the records that you received here. You talked a little bit about them with Mr. King. You went through really just his transcripts from middle school, high school, University of California, Riverside, and Anschutz, the grad school. Is that fair?
Look, if I refer to my report.
Yes. Absolutely. Every time, you may do it any time you want, as long as you just tell us what you're referring to.
Okay, thank you.
Mr. Brockwood?
Yes, sir?
I think he's ready.
Oh, I'm sorry. Yeah, I'm sorry. Yes, sir.
Is there I think you have a question, there's a question on the table.
There was. It was about, and I'm looking, I can't remember what pages. I'm looking at the records you reviewed for your very first evaluation, the records you reviewed before you sat down with the defendant. Do you remember that?
Yes.
And I went through the academic ones, and it looks like you reviewed the transcripts from these things, correct?
Correct.
One of the things that, when it says academic records of James Holmes from the University of Colorado, Denver, one of the things you did not do was you didn't review his assignments that he was turning in between August of 2011 and May of 2012, correct?
True.
One of the things, though, that you did consider were 2 letters that he wrote to college for to get admitted into college. Do you remember that? Now, you don't list them here, but you refer to them elsewhere. Specifically, later on, it's a paragraph that begins, "in a college application form." Do you remember that? And you can, I wish I could tell you which page. Okay.
Yes, I see, page 3.
Okay. So you make reference, in fact, you quote 2 letters that he wrote to colleges to gain admission, correct?
I do.
And you remember what you had told us about that was you considered those letters because you wanted to know what his fluency was, his ability to write, his sort of grasp of English and communicate, that sort of stuff, right?
True.
And you took those 2 samples from, well, do you remember when the letters were submitted? Do you know if they were to grad school or undergrad? That would help. Let's just presume closer in time. Let's say they were submitted. Go ahead.
I'm sorry, they are to UC, or, University of California.
Oh, they were letters he submitted then back in 2006?
Yes.
And that was important to consider to know his fluency and ability to write, all that stuff, communicate, fair?
Yes.
Now, one of the things that exists here in this case in discovery are papers that he wrote and submitted in grad school in the months leading up to this crime. Are you aware of that?
I am.
You were not
Now.
provided those. Oh, hold on. You did not know that before I said it right here?
I did not have them at the time that I evaluated him and wrote the report.
Sorry, the defense
Sorry.
did not provide you with those written materials for you to consider.
True.
There are also, and we've seen them, a cajillion emails from multiple email accounts that span the months leading up to this crime. Were you aware of that?
I am.
Did you review those?
Not prior to my original evaluation.
How about the text messages that he was sending, and there's something called G-chats, Google chats?
No.
Had you been provided all that stuff before your evaluation and then decided, I'm not going to consider it?
Judge, I'm going to object. A lack of foundation. These materials were not available at that time, I don't believe.
All right, the objection is overruled.
Had you been provided those materials, doctor, before your evaluation?
I don't believe so.
Now, you suggested that at some point you did review them all. Is that fair?
Eventually, I reviewed some of those records.
Well, eventually, as in when?
Sometime between my first evaluation and second evaluation. I'm sorry, I can't be more specific.
That's okay, but to be clear, your first evaluation was done in the absence of these materials, fair?
Correct.
And your second evaluation included a sampling of these materials. Is that fair?
Yes.
When you say sampling, because you adopted my word, thank you, how many? And over what period of time? Can you tell us?
I certainly did not review all of those records. I would say maybe a third.
A third?
Of those records.
Did you review his submissions to the mock grant writing proposal class that earned him an A?
No.
There are other things that you might have had the opportunity to review prior to your evaluation of the defendant. And they include videos of him communicating with people right before and right after the event. Are you aware of the existence of those videos? And I'm not talking about Dr. Reed's now. That's way after.
Right. Can you help orient me by telling me who they were to?
They were videos of the defendant. Let's say in the May, June time frame from school in a presentation, and then audio and video of the defendant immediately after the crime and in speaking with the now absent Detective Apple and Special Agent Gumbener.
I have not reviewed the videos prior to the crime.
Is that because you were not provided them, or you have them and you just didn't think them relevant?
I don't know if I was provided with those or not.
Okay. Something else is that you then list on the records that you reviewed before your April 2013 interview with the defendant are records from Doctors Fenton and from Margaret Roth, correct? Do you see that in your report, sir? Right below the academic stuff.
I see Dr. Fenton.
It's the one below
Yes,
Fenton.
I see it. I'm sorry.
Yeah.
Yes.
Okay. You also reviewed records of the defendant from the Arapahoe County Sheriff's Office, correct?
Yes.
From the detention facility, correct?
Yes.
And from Denver Mental Health, correct?
Yes.
The records I do not see listed here, but perhaps you considered them, were the kites that the defendant submitted during his 4 months between his arrest and his trip to Denver Mental Health. Did you have those to review?
Not that I'm aware of.
Those would also be communications of him to someone else right after the crime, correct? As far as you know?
That's my understanding.
All right. Also, something I don't see in there are the 14 pages of handwritten notes by someone named Jonathan Woodcock. You didn't have those to consider.
I don't believe so.
They were not given to you by the defense, fair?
Apparently not.
Because you would, I mean, look, if a psychiatrist had sat down and talked with this guy on July 24th, 4 days after this, you would have wanted to see what that person says, correct?
I would.
And you didn't have it, right?
I don't believe so.
All right, so you sat down with him. You talked about the actually, you know what? I want to reference you to one of the things that you highlighted in your report about one of those essays that the defendant submitted apparently back in 2006 or something like that. You see that passage?
Yes, two of them.
One of the things that he says is, I'm a defender in soccer where I'm determined to stop the other team from scoring. To do this, I must anticipate the other team's tactics. Knowing what needs to be achieved and then pursuing that target is purpose, correct?
Yes.
And that's a passage you picked to include in there, right?
Yes.
You also included, there's a lot of your report, Doctor, and if you think I'm overstating this, you let me know. There's a lot of your report that is you taking things out of other records and other people's reports, putting quotes around them, and then sticking them in there to sort of build a chronology. Is that accurate?
That's accurate.
That's like pages of your report. Is that fair?
It's a few pages.
Okay. And one of the things that you have on there is you have some of the dates that he went and saw Doctors Fenton and then Feinstein, correct? I'm talking now about the April, June-ish 2012 entries, fair?
Yes.
But you have a big jump between April and June, right? You don't put down his meetings with Fenton or Feinstein in May, correct?
True.
When you reviewed those records, one of the things that came up in the discussion with Doctors Fenton and Feinstein was and you put this in your report, is the defendant's hatred of humans, correct?
Yes, it is.
Now, to be clear, you did not follow up on that, right? With him.
Directly with him? No, I did not.
Indirectly with him?
No, I did not.
Okay. And part of that is because you just didn't see that as the purpose you were asked to fulfill by the defense attorneys, correct?
That's true.
All right. And that would mean, too, then, that you didn't review anything about his written word or his thoughts in the notebook prior to interviewing him, right?
That's true.
Judge, I'm going to object. The notebook was not available at that point in time to anyone. And
I think you asked him about that too, if I remember correctly.
I did, and he said it wasn't available.
Okay, well, the objection is overruled. You asked it, Mr. Brockler's on cross-examination, he can ask it too.
There's an interview that was done with Detective Apple and Governor. Just to follow up, did you listen to that interview before you interviewed the defendant? Or right after the crime, where he goes into the details of the bombs in his apartment?
No.
You do ask him, or did you ask him about like what he was doing and what he was reading in that session? Did you do that?
What he was reading at the time that I conducted the evaluation?
Yes, sir. Yeah.
No, not in the first evaluation.
That must have been something you took out of another report where he indicates he's reading science fiction. Does that sound right?
I documented what he told me he had been reading in the second evaluation.
Oh, okay. We'll get to that. We'll get to that. Not in the first, right?
Right.
So the other thing I notice about your report when you're doing this chronology is you jump from roughly July 26th to November 11th, which is what begins this Denver mental health stuff, correct?
Yes.
In between, what you don't document is the reference made in the jail reports to him disassembling a handicap bar in his cell to use as a club. You don't document that. Do you recall that?
I don't recall it.
How about, did you document or do you recall him trying to get behind an electrical plate in his cell using some manufactured tool or something? Do you remember that?
I don't recall that.
Was that not provided to you?
I would think I would recall it if I had read it.
Okay. That would put him right at about the beginning of his one and only love relationship with his girlfriend. Is that fair?
Objection, beyond the scope.
Overruled?
Go ahead, sir.
I think so, more or less. I don't recall exactly the time frame on that.
Forgive me, I didn't even ask you the leading question. Did you know that he'd had a first in his life girlfriend and sexual experience in the months leading up to this crime?
Objection, beyond the scope, relevance.
Overruled?
Go ahead, sir.
I did not know that at the time of the first evaluation.
Okay, now that you know it though, would you agree that this 1.5 years, I've been depressed for 1.5 years, puts him back to the very beginning of that relationship?
I think so.
Okay. There's also a discussion of his psychiatric history. Do you recall that?
Yes.
And again, he restates to you depression for 1.5 years, right?
True.
Interestingly, what you discovered in reviewing all the records leading up to this is that he never tells anyone, mental health professionals included, that he's depressed. Would you agree with that?
I don't recall him expressing depressed mood to mental health professionals.
And you don't recall any of them saying, despite him not saying it, he looks depressed. You don't recall that either.
True, I don't recall that.
Okay. He also says, you ask him for the psychiatric history, you say, why did you go start seeing Dr. Fenton? Or a question like that. Do you see that? April 2012?
Yes.
And what he tells you is, the defendant tells you, I was nervous about speaking, about public speaking, correct?
Right.
He does not ever tell you, because you would have put it in your report, that he went to see them to rid himself of homicidal thoughts, correct?
True.
In fact, he also tells you that, look, at one point, Dr. Feinstein wants to prescribe an antipsychotic, and I didn't do it.
Right.
He says, I didn't do it because I left treatment, right?
Right.
And he says he left treatment, or he didn't do it because his insurance wouldn't cover it, correct?
Right.
He does not tell you that those two doctors offered to treat him continuously for free after that, did he?
He did not.
He talks about a time when he is age 8 and he goes for some sort of treatment or therapy. Do you recall that?
Yes.
Were you provided records from the public defender's office about that treatment? You recall? Salinas family, something, something?
I believe I was eventually provided with those records.
How about prior to your interview of the defendant for this neuropsychological evaluation?
If I didn't document it in my record list, then I didn't.
Okay. And And he tells you that at age 8, he saw a psychiatrist, really a therapist, but a psychiatrist in Claremont, California one time, correct?
Right.
Does that jive with the records that you got from the Salinas family something?
Judge, I'm going to object. May we approach?
Yes. The objection is overruled. Yes.
Again, doctor, forgive me, the delay was limiting for me. Do you remember the last question?
I don't.
If I go by the little hash marks on my paper here, what I think I was asking you about was the Salinas family, whatever the rest of the words were when he was 8 years old. Do you remember that?
Yes.
Okay, and one of the questions that I asked you was if you ever took his statements about that visit, and he described it to you as a one-time visit to a psychiatrist in Claremont, California, and compared it at all with the records that you had been provided from the Salinas family, I'll call it center. Did you do that?
I don't believe so.
One of the things when he's describing that 8-year-old trip that he says to you, first off, he doesn't say to you, I don't remember what that was about, correct?
True.
He doesn't say it was because he hit his sister, right?
He does not.
He doesn't say anything about barricading himself in his room, correct?
True.
What he says to you is, this is a quote, I was screaming, but I wouldn't talk. Correct?
Correct.
All right. No other follow-up on that. Fair?
True.
And you certainly made no efforts to reach out to whether it was Claremont, Salinas, any other place. Fair?
Yes.
Okay. Then he tells you that he attempted suicide at age 13. Do you see that?
Yes.
Did he use the word suicide, parasuicide, or just describe the action and you gave it its conclusion? I ask because it's not in quotes, so. Yes, sir?
Can I look at my notes?
Every time. You just tell us what you're looking at.
Mr. Brockler, from my
Yes,
notes, he gave, as I documented in my report, the quote, I think he alluded to the idea that it was a suicide attempt. He quoted, or he stated, I saw it on my wrists. I don't know if suicide was his term or my term. I don't have it in quotes.
Okay, and you don't have it in your notes as something he said?
But I have suicide attempt underlined.
All right.
And 13-year-old, quote, saw it on wrists, unquote.
Did you ask him, by the way, did you follow up and ask him what you saw on your wrists with?
I didn't.
Okay. What he doesn't tell you, though, is that, hey, everybody knew I did that. He didn't tell you that?
No.
He didn't tell you it was something that he kept from everybody? No?
No.
He didn't tell you that because of that and his family's awareness of it, he was taken to seek additional counseling through someone named Mel Lipsy, right?
He didn't connect the two incidents to me with regard to the seeing of Mel Lipsy.
Well, in part, it's because you have down that he told you it was 3 years later, when he was 16, that they went and saw Mel Lipsy, correct?
Right.
All right, so there's no connection that you were told of, are aware of, or have seen in any document you've been provided that you're aware of between him sawing on his wrists, and I've just used air quotes, and the therapy session with Mel Lipsy, correct?
True.
Okay. When you observe him, you make these observations that he's consistently alert, responsive, and oriented to person, place, and time. Fair?
Yes.
That his speech rate, tone, and volume were within normal limits.
Correct.
That his eye contact and conversational turn-taking were within normal limits. Correct?
Yes.
What you never observed was him having some wide fluctuation of emotional responses, correct?
True.
You never see him make facial expressions like he was crying without making noises, right?
No.
You never see him with his mouth open, gaping wide open, seemingly emotional about something, anything.
No.
And during these topics that you have chosen to ask about it, I presume you picked the ones you thought that were going to be most helpful to you understanding his neuropsychological state, correct?
Yes.
There are 3 areas you absolutely do not go into with him, including you don't ask him about human capital or his beliefs regarding that, correct?
No.
You don't ask him about his views or thoughts on any potential outcome of the case, correct?
No.
You don't ask him or go into any issues of regret, remorse, or anything like that, correct?
No.
Because those were not relevant to your neuropsychological evaluation, correct?
True.
All right. And to be clear, you did ask about those some 20, wait a minute. How many months after April was the January thing you did with him, doctor?
20 months.
20 months. Some 20 months later, when you redid the psychological evaluation, those were the 3 areas you were asked to get into with the defendant by Mr. King. Fair?
True.
And you did it.
I did.
And when he gave you whatever answers he gave you, you did not follow up on them. You just wrote them in your report, correct?
Yes.
Because that's what you were asked to do.
Yes.
All right. Now let's talk about these tests. I heard the detail that you gave through this, and sort of the reason I wanted to ask you about the statements that the defendant had made to you during these different parts of the clinical interview. Is that the right phrase? Clinical interview?
Yes.
That you conducted, was because there'd been a lot of discussion about these validity tests, malingering tests. Do you remember all that?
Yes.
And the words that you and Mr. King used were, hey, he'd passed them. There was like 40 of them. He passed them all, correct?
Yes.
But let's be clear, though, about what the malingering and validity tests do. Those tests test his effort on those tests, correct?
Yes.
They are meant to determine whether he's malingering on those tests, correct?
Yes.
And what they don't do for us is they don't give us some sort of guarantee that the defendant is being honest or accurate or forthcoming with us in our face-to-face interviews with him, correct?
True.
One of the tests that you did not give was one you talked about called the SIRS-2. Do you remember that?
Yes.
You described that as an incredibly sensitive, skilled test at determining whether or not someone was feigning psychiatric symptoms. Do you remember that?
Judge,
Yes.
may we approach?
Yes. You may proceed based on the discussion we had at the bench.
Thank you, Judge. Doctor, the last thing that we had talked about was my description based on what I thought you had said about the SIRS-2 being this very sensitive test for malingering psychiatric symptoms. Do you recall that?
Yes.
And one of the things that you had written at a prior time in a book chapter was that on a different case where you hadn't administered it was even in cases where you don't necessarily think it's completely appropriate, you think it ought to be given. Fair?
I said something to that extent.
Yeah, and in this particular case, you did not administer the SIRS-2 in April of 2013. Fair?
True.
By the time it's ultimately administered to the defendant in July of 2014, you'd agree with me that the defendant has been exposed to a lot of psychological and psychiatric testing. Fair?
Yes.
Not just yours, correct?
Right.
But Dr. Gray's, right?
Right.
Dr. Manguso, yes?
Right.
Dr. Metzner, yes?
Yes.
Dr. Gurr?
Right.
And in addition to all the tests associated with all of those, you had a concern about the SIRS being given when someone had had the opportunity to sit in and listen to sort of a detailed discussion about its uses and how it works. Is that fair?
You're referring to the hearing, right?
Yes, sir?
Yes.
And yet that happened. Even before July of 2014, the defendant was able to sit and hear this discussion about the SIRS-2, correct?
He did.
And that caused you concern about whether or not that might actually impact the validity of it.
I did. It did.
Okay. There's the bunch of tests that you referred to that you administered to the defendant back in 2013. Here's words that I see for almost every single thing, and you stop me if I'm misstating this. For auditory, average range, intact. Fair? Under attention, sir. Sorry.
Yes.
And when we talk average, what we've heard before, and I think you were present here in the courtroom with Dr. Manguso, was that that's not average for the planet Earth. That's average normed to guys like the defendant, right? In many cases, white men with 16 to 17 years of education. Is that fair?
Yes, depending on the specific test and how that test is normed, yes, it may be age, gender, education, or it may just be age, or it may be education and age, but yes, those are the factors.
And so in many of these cases where we see that the defendant is performing at the average, above average, or even slightly below average range, in these cases where we're not talking about someone who's post-undergraduate degree, would you let us know that as we go through them?
Sure.
Okay. On the visual stuff, and I don't want to go through every test, but I'm reading the words that I see in your paragraphs. Within normal limits, average range, average range, average range. Sound right?
Yes.
Auditory verbal, I see low average range, intact, average range, intact, high average range, and then something where it says 100% accuracy on the forced choice recognition subtest of the CVLT2. Is that just a validity thing too, to show that he's just putting forth effort?
Yes.
Got it. Visual nonverbal, superior range, average range. Does that sound right?
Yes.
I'm boring myself here by going through this. Let me just ask you for the 2000, no offense to the work product, I just know that we've gone through this with Mr. King. All right. But is it fair to say that by the end of the 2013 testing, what you've concluded is, look, this guy is either average or intact, and you describe that term for us in terms of all these things that you tested. Fair?
Yes.
And then one of the things that you talked about was testing the executive functions, reasoning and executive functions, right?
Yes.
And those are our highest order of what? Brain stuff. Yep. Right? Thinking.
That's one way to put it, yes.
Yeah. What words would you use? Highest order what?
They are high order human cognitive functions.
Human cognitive functions, great. And he is doing very well in that, right?
Yes.
In fact, you say his performance reflected a preserved capacity for formulating alternative solutions to novel problems and shifting cognitive set in response to changing task demands. Is that fair?
I did.
That's a lot of words, but it says he's doing real well, correct?
It does.
And those executive functions control things like your ability to plan, right?
Yes.
To problem solve, right?
Yes.
To deliberate on issues and figure out how to achieve them.
Yes.
And in fact, it also talks about your ability to shift to a changing environment, kind of shift on the fly, as we heard with Dr. Manguso. You'd agree with that?
Yes.
There's other stuff that you did with him, though, that we didn't get into details on. There's something called the IGT. What's the IGT test?
The IGT?
Yeah. Did I say it wrong?
I thought you said DT. The IGT.
Yes, sir.
Yes. That's an acronym for the Iowa Gambling Task.
Okay, and what's important about that is it measures decision-making involving cost-benefit analysis and direct feedback regarding decision outcomes, correct?
Yes.
And he scored in the high average range, right?
He did.
And that's just 9 months after the crimes that were committed here, fair?
Yes.
Now, you also did social cognition and emotional intelligence back in April of 2013. Is that true?
Yes.
But not in January of 2015, fair?
Right.
One of the things that you check for, and you've sort of told us about this, is you check to see if he is able to discern in others, either by appearance or by sound, their emotional state, correct?
Yes.
And there's nothing in his testing here that would indicate he lacked the ability to appreciate when someone was frightened, correct?
That's true.
And really, your report doesn't really even come to any conclusions other than to tell us how he did on the tests. You'd agree with that, the April 2013. Correct?
Correct.
Okay. So in between April, by the way, you give your report over to Mr. King, and then do you think that's it at that point for you on this case in terms of the neuropsychological testing?
I probably didn't think about it in that manner, but I did think that I've completed my job in this case. I may be asked to consult at some point in the future. That would be not an unusual expectation, but yes, that's what I thought at the time.
But to be clear, you made no plans to do that important second round of testing that Mr. King asked you about, fair?
Not at that time, no.
So when you left after this testing, you thought, I've done my job, I've done what I've been asked, that's it, fair?
Fair.
Now you are contacted again by Mr. King or the defense, it doesn't have to be Mr. King, anyone from the defense team, to again do another set of evaluations. Do you recall that?
I recall having a conversation about that idea, yes.
When was that conversation?
Sometime in the fall of 2014.
Sometime in the fall in 2014. And then what you end up doing is scheduling time to do this 2 weeks before jury selection starts in this case. Is that fair?
Yes.
In fact, you don't even issue your report until after we're already in jury selection, correct?
I'm not necessarily aware of that, but if that's the timing of it, I accept it.
How about this? You issued your report to the defense on January 31st, 2015.
Correct.
And by then, by the time of that testing that you reported on January 31st, from January 5th and 6th, the defendant had undergone even more psychological testing than he had when we were talking about July 2014, correct? Well, he had the SIRS 2 from Dr. Gray, fair?
Yes.
And whatever additional follow-up MMPI-2 and PAI, correct?
Okay, I misunderstood the question, but yes,
And he also had a full-on interview, psychiatric interview that we watched for 22 hours with Dr. Reed, correct?
Right.
And there's no reason to think he wasn't completely aware of the issues at hand regarding his mental health when you sit down with him on January 5th, 2015, right?
True.
Now, by the time you sit down, I'm sorry, Your Honor, if I could have a moment.
Yes.
Well, here's what I was looking for. You were actually given, at least in your report, you described being given the exact same instructions by the defense to conduct an objective assessment of interval change. This is new, interval change with respect to the neuropsychological status. Is that fair?
Yes.
All right. So you set out by doing some of the same tests that you did before, but not all of them.
Correct.
And one of the ones we know you didn't do is social cognition, right?
Right.
You had some additional records to review. Is that fair?
I did.
And those records do not seem to include anything from a Jonathan Woodcock, correct?
Correct.
And they don't include some of the other stuff we've talked about, emails, texts, G-chats, none of that stuff?
Right.
So is it fair to say if you didn't include them, you sure didn't consider them?
True.
Does that mean you weren't provided them?
No.
Were you provided them?
I was provided some of them.
How about the notebook?
I was provided with the notebook.
Did you review that prior to your second interview of the defendant?
I did.
And did you end up inquiring of him about that?
No.
I'll be honest, I'm looking at your records reviewed here on page 3. I don't see the notebook. Is it on there?
It is not on there.
Okay. Just a mistake though, right? I mean, you did review it. You would have put it on there. It just slipped through the cracks, fair?
It is. It wasn't something that I was going to document in my report, but I was aware of it and I had reviewed it.
Okay, thank you. Once again, then, we go through a series of questions that you asked the defendant, correct?
Yes.
And this is where you ask him about the books that he's reading, right?
Yes.
Why is that important to you?
Because I was interested in how he was spending his time.
And he tells you he's reading some books called The Best of Enemies, Trouble in Mind, and American Assassin. Is that fair?
Correct.
You make some more behavioral observations of him, don't you?
Yes.
And those include almost the same things you observed before back in April of 2013, true?
Essentially.
Including his eye contact and conversational turn-taking were within normal limits.
Right.
All right. And then we get into the testing that you did with him, right?
Yes.
This testing is significant on your testimony because what you've said is, look, the difference in his full-scale IQ and some of the subtests that we'll talk about, that means something to me about his potential mental health. Fair?
Yes.
Well, let's talk about that test. One of the things that you did when you wrote your report was you said his test results in April 2013 was 123, full scale, and in January of 2015, it was 116. Is that right?
Right.
And when you wrote your report, I should ask you this. Forgive me, I'm going to back up. Do you do it like the other psychologists, psychiatrists, and use a computer system or software to do all the special numbers and stuff? To score it and stuff?
Well, in some tests in which there are computer programs to score, most of the neuropsychological tests, you have to score by hand. You can then enter those scores that you have scored by hand into a computer program that generates a nice, clean report that of data that you've already calculated.
Is it that software then that calculates the practice effect?
Yes.
And is that what you use to help calculate your practice effect?
Yes.
Now, in this particular case, what you know about that software is that the practice effect is time limited on that software, isn't it?
It is.
And in fact, it doesn't allow you to use a formula earlier than 8 days, correct?
Right.
Nor later than 82 days, correct?
Right.
And when we're talking practice effect, we're talking about the ability of someone to perform better on a test that they have recently seen before, correctly?
Yes.
That was a horrible word, correct?
Yes.
Thank you. And this software that calculates this does not take into consideration day 83 and beyond, correct?
That's right.
Tell us, how many days after that first WACE-4, that first IQ test, did you administer the second IQ test?
Well, it's 20 months, so that's approximately 600 days.
600 days.
Yes.
And that software does not calculate for that, does it?
That program does not specifically calculate for that.
But you included that calculation in your report, didn't you?
I did.
That's an error, isn't it?
I think it's reasonable for someone to interpret that as an error. I don't agree that it's an error because of what we know about the duration of practice effects on the Wechsler Adult Intelligence Scale and the Wechsler Memory Scale.
And I want to be clear that the software itself makes a distinction between how it calculates the results at 8 days and 82 days and in between, correct?
Yes.
It's fair for us to conclude then that if someone were to take that test 7 times 82 later, that practice effect would even be more diminished than it was at 82 days, correct?
I'm not sure I understand the question. So if you take it repeatedly 7 times?
No, sir, I'm sorry. I use 7 times as a multiplier by 82. What I should have said is someone that retakes a test 600 days later, not 82, the max by the software. We would expect that the practice effect would even be more diminished 600 days later than 82 days later, right?
That's reasonable.
So, and because that's reasonable, it's also reasonable for us to conclude that you putting in the data from day 82 was not an accurate representation of the practice effect at day 600 for that guy, right?
That's a reasonable conclusion.
I want to talk to you about that difference too, because that really seems to be, in fact, it looks like his decrease, frankly, his statistically significant decrease in his neuropsychological testing is really in this full-scale IQ and the subtests. Fair?
Yes.
I mean, other areas he goes up a little, he goes down a little bit. In terms of statistical significance, something that you relied upon in giving your opinion about it being part of that schizophrenia spectrum disorder. Do you remember that?
Yes.
This is really the big piece of evidence for you, isn't it?
It is.
Okay, let's talk about the full-scale IQ testing. The biggest piece of that in terms of changing it from 123 to 116, raw scores, was the PRI, right?
It was.
And the PRI is comprised of 3 tests, isn't it?
Yes.
And those 3 tests include block design,
Yes.
matrix reasoning, and visual puzzles.
Correct.
Those tests are not all scored the same, are they?
No. Well, they're scored. They're.
I meant it's too vague. Forgive me. I'll ask you a better question. Some of those tests are scored based on accuracy alone, like matrix reasoning.
Right.
The other 2 tests are based on a combination of time and accuracy. Fair?
Yes. Yes. Sorry.
That's okay. That's okay. The 2 tests that he had the biggest fluctuations in, if at all, were the ones related to time, correct?
Correct.
In fact, he showed virtually no change in just the accuracy of the matrix reasoning. Correct?
Just 1 point.
The way that these things get scored is based on a cutoff of time, isn't it?
Yes.
So there are a number of, let's take block
Design.
Block design, thank you. Let's take block design. How many block designs are there? If I had 15 or more, is that too big?
Is it okay if I-
Please check. I want to be right, please.
The block design subtest is comprised of 14 items.
14 items. And there's time limits on each of those, right?
Yes.
And again, just for the record, you're looking at something. What is it?
This is the protocol for the administration of the block design subtest.
Is it the actual one that the defendant did? Or is that just like an instruction sheet?
This is the one he did.
Okay. Now, one of the things in terms of scoring that is the time limits change depending upon how complicated the puzzle is. Fair?
True.
And if you go over the time limit by 1 second, do you get any points?
No.
How many points do you get? And just give us a sampling. How many points do you get if you make it within the time limit?
If you make it within the time limit, well, for some of the items, if you make it within time limit, you get it's just a maximum of 4 points.
And some of them, you get bonus points for being super fast, right?
True.
And if you fall below the cutoff for super fast, you get less points, correct?
Right.
What's the maximum amount of time that you can get for any one of the puzzles?
Maximum amount of time is 2 minutes.
2 minutes. How many points do you get if you complete that puzzle within 2 minutes?
4 points.
How many points do you get if you complete it within 2 minutes and 1 second?
None.
Is it accurate to say that someone could take that test twice over 20 months, get every single puzzle exactly right both times, but they're slower by a couple seconds here and there, and it drastically changes their score?
That is possible.
Now let's talk about what was the third test, sir? It was the visual puzzles.
Right.
Now, is visual puzzles scored the same way or different?
It is scored differently.
Does it involve time?
Yes.
Can you tell us how time works with the scoring on the visual puzzles?
Time on the visual puzzles, there's not a gradient of time that determines score. So there isn't a, say, on the items from the block design, the more difficult items where it can be 4 points, 5 points, 6 points, 7 points. That's not the case on visual puzzles. Visual puzzles is all or nothing. You have a cutoff time. If you get it right within that cutoff time, you get the point. If you don't get it right within the cutoff time, you don't get the point.
What kind of cutoff time are we talking about?
30 seconds.
Fair to say again that someone who on April of 2013 were getting these things 100% correct at 29 seconds would get the point, and 20 months later getting them at 31 seconds would not get the point.
That's
Fair?
true.
Those two tests, if you slowed down by a couple seconds on a handful of these items, could throw off your PRI score pretty significantly.
Object to throw off the PRI score. This score would be accurate still.
Overruled. I understood the question. Did you understand the question, Doctor?
I think so.
That's right, isn't it?
It could change it, yes.
And if that PRI is changed enough because of those handful of seconds here and there on the different puzzles, that could impact your full-scale IQ, correct?
Yes.
Let's talk about some things that might impact the speed, the psychomotor speed with which someone might do these tests, okay?
Okay.
At the time the defendant takes this battery of tests in January of 2015, he has been incarcerated in relative isolation for 899 days. Is that correct?
I believe you.
Okay. Thank you. I should have said a bigger number, but I think it is 899. The other thing that we know about psychomotor speed is that it can be impacted by depression, correct?
True.
And this guy's depressed, right?
He is. He was particularly depressed when I saw him in 2013.
Still depressed in 2015, right?
I think he was still depressed. He reported being significantly less depressed to me in 2015 relative to 2013, but he still reported depression.
Not only that, but stress. My gosh, stress can impact how someone performs on any test, couldn't it?
It can.
And in this particular case, you administered these time-sensitive tests 2 weeks before jury selection was to begin on a case that might result in a death sentence for him, correct?
True.
Can I have a moment, Your Honor?
You can.
Doctor, one other area I wanted to get into with you, and I should have done it when we were talking about the malingering. You remember on your PowerPoint slide up here, you had all those validity malingering tests, correct?
Yes.
And at the bottom, you had listed both his performance on the August 2013 MMPI-2 and PAI, as well as the they did it again in July 2014 MMPI-2 and PAI, correct?
Right.
And you thought the outcomes of those things were significant, right?
Yes.
Okay, now one of the things though we've already talked about is those malingering validity tests don't guarantee us honesty, accuracy, or forthcoming answers from the defendant. Do you agree with that?
Asked and answered, Your Honor.
Overruled.
Yes? You agree?
Yes.
Now, you know that the MMPI-2 is made up of 567 questions, correct?
Yes.
And those questions include topic areas like that touch on hallucinations, yes?
Yes.
And both visual and audio, right?
Yes.
Whether or not someone's feeling suicidal, correct?
Yes.
Objection, this is beyond the scope of direct examination.
Would counsel approach, please? Members of the jury, rather than keep you waiting, let's go ahead and take a break. It's about time for the afternoon break anyhow. And one of you suggested it, and I think it's a good suggestion. So I'm going to go along with the suggestion, but I'm making it sound like it's my idea. So please make sure you keep all my admonishments in mind during the break. Enjoy the break, and we'll see you back here in about 20 minutes or so, all right? Thank you. The record should reflect that the jury has exited the courtroom. Let's go ahead and take our afternoon break, and then I'll chat with counsel after the break. The court will be in recess. Thank you.
Please rise.
Inside our 7 News newsroom as we get midway through the afternoon. We're in our afternoon recess here, the last day of the week. Remember that tomorrow is the holiday for July 4th, so there is no court tomorrow. But certainly it's been a bit of a slow, dragging day in the courtroom. With you heard District Attorney Brockler earlier even joking about that, calling it boring himself. But his focus obviously has been to assault and undermine the impression of validity in these tests, specifically Dr. Hanlon's test, and of course Dr. Hanlon still on the stand now as we take this recess and will return to the stand when it is all said and done. However, probably not selling it very well because I just said it was dragging, but there are a couple of moments that our staff here has picked to replay for you during this recess. Andrew has picked very kindly for us to watch some of the important stuff from this cross-examination. And so, Andrew, if you'll hit that now, we'll play that and talk to you if there's still more time remaining at the end of the break.
Make reference. In fact, you quote 2 letters that he wrote to colleges to gain admission, correct?
I do.
And you remember what you had told us about that was you considered those letters because you wanted to know what his fluency was, his ability to write, his sort of grasp of English and communicate, that sort of stuff, right?
True.
And you took those 2 samples from, well, do you remember when the letters were submitted? Do you know if they were to grad school or undergrad? That would help. Let's just presume closer in time. Let's say they were submitted.
I'm sorry. They are to UC, or, University of California.
Oh, they were letters he submitted then back in 2006?
Yes.
And that was important to consider to know his fluency and ability to write, all that stuff, communicate, fair?
Yes.
Now, one of the things that exists here in this case in discovery are papers that he wrote and submitted in grad school in the months leading up to this crime. Are you aware of that?
I am.
You were not provided those. Oh, hold on. You did not know that before I said it right here?
I did not have them at the time that I evaluated him and wrote the report.
Sorry, the defense did not provide you with those written materials for you to consider.
True.
There are also, and we've seen them, a cajillion emails from multiple email accounts that span the months leading up to this crime. Were you aware of that?
I am.
Did you review those?
Not prior to my original evaluation.
How about the text messages that he was sending, and there's something called G-chats, Google chats?
No.
Had you been provided all that stuff before your evaluation and then decided, I'm not going to consider it?
Judge, I'm going to object. A lack of foundation. These materials were not available at that time, I don't believe.
All right, the objection is overruled.
Had you been provided those materials, doctor, before your evaluation?
I don't believe so.
Now, you suggested that at some point you did review them all. Is that fair?
Eventually, I reviewed some of those records.
Well, eventually, as in when?
Sometime between my first evaluation and second evaluation. I'm sorry, I can't be more specific.
That's okay, but to be clear, your first evaluation was done in the absence of these materials, fair?
Correct.
And your second evaluation included a sampling of these materials, is that fair?
Yes.
When you say sampling, because you adopted my word, thank you, how many? And over what period of time? Can you tell us?
I certainly did not review all of those records. I would say maybe a third.
A third?
Of those records.
Did you review his submissions to the mock grant writing proposal class that earned him an A?
No.
There are other things that you might have had the opportunity to review prior to your evaluation of the defendant. And they include videos of him communicating with people right before and right after the event. Are you aware of the existence of those videos? And I'm not talking about Dr. Reed's now. That's way after.
Right. Can you help orient me by telling me who they were to?
They were videos of the defendant. Let's say in the May, June time frame from school in a presentation, and then audio and video of the defendant immediately after the crime and in speaking with the now absent Detective Apple and Special Agent Gumbener.
I have not reviewed the videos prior to the crime.
Is that because you were not provided them, or you have them and you just didn't think them relevant?
I don't know if I was provided with those or not.
Okay. Something else is that you then list on the records that you reviewed before your April 2013 interview with the defendant are records from Doctors Fenton and from Margaret Roth, correct? Do you see that in your report, sir? Right below the academic stuff.
I see Dr. Fenton.
It's the one below
Yes,
Fenton.
I see it. I'm sorry.
Yeah.
Yes.
Okay. You also reviewed records of the defendant from the Arapahoe County Sheriff's Office, correct?
Yes.
From the detention facility, correct?
Yes.
And from Denver Mental Health, correct?
Yes.
The records I do not see listed here, but perhaps you considered them were the kites that the defendant submitted during his 4 months between his arrest and his trip to Denver Mental Health. Did you have those to review?
Not that I'm aware of.
Those would also be communications of him to someone else right after the crime, correct? As far as you know?
That's my understanding.
All right. Also, something I don't see in there are the 14 pages of handwritten notes by someone named Jonathan Woodcock. You didn't have those to consider.
I don't believe so.
They were not given to you by the defense, fair?
Apparently not.
Because you would, I mean, look, if a psychiatrist had sat down and talked with this guy on July 24th, 4 days after this, you would have wanted to see what that person says, correct?
I would.
And you didn't have it, right?
I don't believe so.
All right, so you sat down with him. You talked about the actually, you know what? I want to reference you to one of the things that you highlighted in your report about one of those essays that the defendant submitted apparently back in 2006 or something like that. You see that passage?
Yes, two of them.
One of the things that he says is, I'm a defender in soccer where I'm determined to stop the other team from scoring. To do this, I must anticipate the other team's tactics, knowing what needs to be achieved and then pursuing that target is purpose, correct?
Yes.
And that's a passage you picked to include in there, right?
Yes.
You also included, there's a lot of your report, Doctor, and if you think I'm overstating this, you let me know. There's a lot of your report that is you taking things out of other records and other people's reports, putting quotes around them, and then sticking them in there to sort of build a chronology. Is that accurate?
That's accurate.
That's like pages of your report. Is that fair?
It's a few pages.
Okay. And one of the things that you have on there is you have some of the dates that he went and saw Doctors Fenton and then Feinstein, correct? I'm talking now about the April, June-ish 2012 entries, fair?
Yes.
But you have a big jump between April and June, right? You don't put down his meetings with Fenton or Feinstein in May, correct?
True.
When you reviewed those records, one of the things that came up in the discussion with Doctors Fenton and Feinstein was and you put this in your report, is the defendant's hatred of humans, correct?
Yes, it is.
Now, to be clear, you did not follow up on that, right? With him.
Directly with him? No, I did not.
Indirectly with him?
No, I did not.
Okay. And part of that is because you just didn't see that as the purpose you were asked to fulfill by the defense attorneys, correct?
That's true.
All right. And that would mean, too, then, that you didn't review anything about his written word or his thoughts in the notebook prior to interviewing him, right?
That's true.
Judge, I'm going to object. The notebook was not available at that point in time to anyone. And
I think you asked him about that too, if I remember correctly.
I did, and he said it wasn't available.
Okay, well, the objection is overruled. You asked it, Mr. Brockler's on cross-examination, he can ask it too.
There's an interview that was done with Detective Apple and Governor. Just to follow up, did you listen to that interview before you interviewed the defendant? Or right after the crime, where he goes into the details of the bombs in his apartment?
No.
You do ask him, or did you ask him about like what he was doing and what he was reading in that session? Did you do that?
What he was reading at the time that I conducted the evaluation?
Yes, sir. Yeah.
No, not in the first evaluation.
That must have been something you took out of another report where he indicates he's reading science fiction. Does that sound right?
I documented what he told me he had been reading in the second evaluation.
Oh, okay. We'll get to that. We'll get to that. Not in the first, right?
Right.
So the other thing I notice about your report when you're doing this chronology is you jump from roughly July 26th to November 11th, which is what begins this Denver mental health stuff, correct?
Yes.
In between, what you don't document is the reference made in the jail reports to him disassembling a handicap bar in his cell to use as a club. You don't document that. Do you recall that?
I don't recall it.
How about, did you document or do you recall him trying to get behind an electrical plate in his cell using some manufactured tool or something? Do you remember that?
I don't recall that.
Was that not provided to you?
I would think I would recall it if I had read it.
Okay. Then finally you start talking with him and you start going through things like demographics, correct?
Yes.
And you start going through his medical history with him, right?
Yes.
And one of the things that comes out in his medical history is he says to you that he has been depressed for the past 1.5 years, correct?
Yes.
And that would date back to about October of 2011. And take a moment to do the math, I had to.
Yes.
Right? That would put him right at about the beginning of his one and only love relationship with his girlfriend. Is that fair?
Objection beyond the scope.
Overruled?
Go ahead, sir.
I think so, more or less. I don't recall exactly the time frame on that.
Forgive me, I didn't even ask you the leading question. Did you know that he'd had a first in his life girlfriend and sexual experience in the months leading up to this crime?
Objection beyond the scope. Relevance.
Overruled?
Go ahead, sir.
I did not know that at the time of the first evaluation.
So you hear there that what he did and did not know at the time of the first evaluation, just for a moment, and we do plan to give you more context during the course of this recess. We plan to play as much as we can of the other doctors' conclusions, that is, the doctors who were actually hired to make conclusions of sanity or insanity under Colorado law using the tests that Dr. Hanlon and Dr. Manguso did. So there were 2 sanity tests. The first where the appointed expert, appointed doctor in charge was Dr. Metzner, and then Dr. Reed, who was the one with the 22 hours of video that we saw earlier, and then the defense had their own expert, and they'll have one more come later at the end of their case. He mentioned yesterday that they thought they would call Dr. Gurr on July 7th, give her at least 2 days to do her testimony and cross-examination. And so in the end, we'll have 4 doctors, but let's just remember that Dr. Manguso, Dr. Hanlon, their work, their tests, and the repeat cycles of tests, I guess is the right way to describe it, where they don't quite repeat each other's work, but they do similar projects and similar tests to get similar assessments and judgments over a period of time. Those were relied upon by all 4 of the doctors who are making sanity judgments in this case. So let's play now, as much as we can, Andrew, of the sound from the doctors who did make judgments of sane or insane under the law and what they had to say about that.
In this particular case, doctor, tell us what conclusion you came to and why.
My conclusion is that he meets the criteria for something called schizotypal personality, SCHIZOTYPAL, personality, and may well meet the criteria for something called delusional disorder. I was aware as I did that he comes close to meeting criteria for some other similar disorders, but the one I think is most applicable and the one for which he does meet the criteria, in my opinion, is schizotypal personality. Within one portion of the way one diagnoses schizotypal personality, there are 9 things to consider, and the person needs to have 5 in order to pass that particular hurdle getting to the diagnosis. And let me point out that the diagnoses are not rote cookbook things. They involve clinical judgment and clinical wrestling sometimes, just as we've been talking about whether such and such is a delusion or not. One of the things that he has, in my opinion, is odd beliefs or magical thinking that influence his behavior and are inconsistent with cultural norms. Part of that odd belief or magical thinking, in my view, would be the thinking that if he kills someone, he gets something from that. Another is unusual perceptual experiences, including bodily illusions. We've talked about Mr. Holmes describing seeing flickers or shadows. There are points in the notebook in which he describes, and he described to me, wondering if his nose is a certain way, wondering if some other body parts are working or not working, that I think are likely to be illusions about his body. And certainly the other perceptual experience would be the shadows or the flickers, assuming that they're as he's describing them. A third one is odd thinking and speech, such as, but not necessarily limited to, vagueness, circumstantiality that's wandering around before you come back to the point, speaking in metaphors, over-elaborating a stereotyped speech. The way he has talked with me and with some other people it reflects an odd way of speaking, and I believe reflects an odd way of thinking as well. The fourth one, suspiciousness or paranoid thinking. I think that's present to at least some extent at some times, and we've already talked about, and I'm talking about before the shootings, we've already talked about him thinking that Dr. Fenton's box had a particular significance, or Dr. Feinstein's cast had a particular significance for him. The fifth one, sixth one on the list, but the fifth one that he has, in my opinion, inappropriate or constricted, limited affect. Affect means your facial expression or your emotions as they come through your face. We see in Mr. Holmes a somewhat flattened or blunted affect. Some affects I've simply not seen. significant anger, significant sadness, things like that. I've seen a little humor, but mostly his face doesn't change much as he talks with us, or to anyone that I know of. Another one, I think it would be number 5, maybe whichever number it is. Odd, eccentric, or peculiar appearance or behavior. The way he behaves with people, I believe, is a bit odd, and I would put a check mark there. Some people wouldn't. They would say he's not particularly eccentric. He doesn't wear green clothes all the time or something like that. If we think about his dyeing his hair red, I don't think that's a big deal in this particular context. The next one, lack of close friends or confidants other than close family. He has some friends, or has had some friends. They're not that close, and when they get close, he has difficulty with that. He has had some close friends, but there's an overall lack of them and difficulty with those interactions. And finally, the last one on the list is excessive social anxiety that doesn't diminish with familiarity, and tends to be associated with paranoid fears rather than negative judgments about himself. That may or may not be present, since when he becomes more familiar with people, the anxiety tends to decrease. It's a little hard to tell. He was with me for a fair amount of time, and the anxiety may have decreased a little bit. I'm not sure whether that one applies to him or not, particularly because if it's there, well, let me go back on that. Tending to be associated with paranoid fears rather than negative judgments about oneself. It may be there, it may not. Any way you cut it, I believe there are at least 5 of those 9 things that are clearly present in Mr. Holmes. Now, there's another part of the diagnosis, and that is that he doesn't meet, in order to make the diagnosis, he cannot meet criteria for certain more serious illnesses, such as schizophrenia. If he is diagnosed accurately with schizophrenia, then, in my book, he doesn't have schizotypal personality. Maybe he had it before and it became schizophrenia. The issue there is, does he meet the initial criteria for schizophrenia? I believe he does not meet those, or did not prior to the shootings, so I would leave him here. I'm aware that some other people believe he does meet those criteria. I don't have an enormous argument with him, except that, and maybe this is going too far with your question, except that I don't believe he had a significant psychotic break prior to the shootings. That is a significant and lasting break with reality.
So those were Dr. Reed's clinical conclusions. Of course, Dr. Reed is the one who spent 22 hours with the gunman on the videotape that we saw several weeks ago when the prosecution was presenting their case. Of course, he came up also with what Mr. Brockler has described as the forensic decision, the forensic opinion of sanity, which is really what I mean when I say legal insanity or legal insanity. And of course, Dr. Reed said that he believes the gunman was legally sane at the time that the shooting occurred, July 20th, 2012. He said there in his clinical diagnosis, which is that much longer list of criteria from the DSM-5 manual, that he believes the gunman meets the criteria for schizotypal personality disorder. Other doctors for the defense specifically have said that they believe he meets the criteria of schizophrenia in its full-blown form. But let's keep that separate, that list of criteria we just heard separate from the list of criteria, really a 2-point decision process that comes with legal sanity or insanity. Let's pull that up on the screen now. Specifically, this page is from the Colorado Supreme Court's model instructions for jurors, but it includes the very important passage, this point 1 and point 2, about what it means to decide if a defendant is legally insane under the eyes of the law, not under a clinical diagnosis, but under the eyes of the law, whether they can be held accountable, that is, found guilty of a crime like murder. And the first issue was he, in this case he, so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. So that is fundamental item number one. Number two, and this is an or statement, either one of these, if the answer is yes, the jury is to find the defendant in any case where this question comes up. The jury is to find the defendant not guilty by reason of insanity. That is what's called an affirmative defense, meaning, in this case, he did it, but he wasn't in control because of either A or B or both on this list. And that number two item is that he, in this case Holmes, suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an essential element of the crime charged. What does a culpable mental state mean? We've heard that discussed in court during that hearings session last week. And I'll take a moment as we wait for court to resume again this afternoon to try to talk about what that means. Culpable mental state means essentially intent, in a word. If you can form intent, logical, reasonable intent, and reasonable is something that comes up over and over again in the law, but this idea of a reasonable person, a reasonable intent, and that's what this culpable mental state means. Apparently, we heard the other day, culpable mental state, if I recall right, is not actually a word that's defined in the law, but it's defined in practice and by practice. And then, of course, when we talk about diseased or defective of mind or condition of mind, that means, in my understanding, that a clinical diagnosis can play into it, but a legal forensic opinion, I'm going to use George Brockler's word there, the forensic opinion doesn't necessarily factor all of the weights of various kinds of diseases. So basically, that is to say, it's not guilty by reason of schizophrenia doesn't exist under Colorado law. Not guilty by reason of schizotypal personality disorder is not a Colorado thing. It's not a Colorado law. So as you read through this, is not to confuse mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives, and kindred evil conditions. What is a kindred evil condition? That one confuses me, but let's focus on moral obliquity, mental depravity, passion growing out of anger. Do those factors apply to this case? That's going to be up for the jury to decide, and then they're going to have to decide they have to be careful not to overlap that with the opinion of intent or
back on the record, this is the people of the state of Colorado versus James Eagan
sounds like
Holmes.
The court is back, and
case
we'll
number
send
12
you back
CR
there full screen
1522.
and talk to you again.
The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. Mr. Brockler, how in depth are you intending to get into the area that we spoke about at the bench right before the test, and specifically the MMPI 2?
Your Honor, my intention was to do as I had been doing right before we approached, which was to get into some of the general subject matter areas that the MMPI 2 gets into, and then to ask the witness, frankly, if he had reviewed the specific answers to those questions, and then compared them between the first test, the second test, or either of the tests, and any other statements he'd made to either himself or to any other mental health professional.
Okay. All right, Mr. King.
Judge, and that's the problem, Judge, and that's why I keep objecting to beyond the scope. This expert witness, the testimony of this expert witness is limited. That didn't mean that that's the only work that he did on this case for us. Now, he did review the data on the MMPI and the data on the PAI, and he has consulted with us about that, and he has indicated to us whether he thought that what the results were. I don't know if he's looked at the individual questions or not, or just the scales, but he had other roles in the case other than testifying about the neuropsychological evaluation, in terms of being an advisor to us, in terms of giving us input on various things. I specifically did not go into those areas because they're not relevant to the work that he did and the information that he's imparting to this jury. So I deliberately did not do that. He didn't administer the PAI, he didn't administer the MMPI, he wasn't asked to, and he's not been asked to offer any opinions about those issues. And now we're getting into the particulars of those tests with somebody who has not testified about them, did not perform the test, and we're well beyond the scope of the direct examination, Judge, and it's just irrelevant to the issues that he has testified to before this jury.
All right. I went back and looked at the notes during the break, and Mr. King is right that he didn't go into detail or in depth into this area, but there were a couple of questions related to the MMPI-2. One of the questions had to do with whether Dr. Hanlon is qualified to perform the MMPI-2, and he said he was. And there was a slide which was apparently prepared by Dr. Hanlon that was put up in front of the jury that has the result of the MMPI-2 test that was administered by Dr. Gray. And although he was not asked any specific questions about the test results for that particular test, he was asked questions about the combined scores of the MMPI-2, the PAI, and the SIRS, and pointed out that there were 40 scales and that they indicated that the defendant was not malingering. And for the record, these are validity tests, and there are two categories. There's a category of testing, of validity testing, that is related to the neuropsychological test that Dr. Hanlon has been talking about for the most part. There's another category of validity test that includes the MMPI-2, the PAI, and the SIRS. And that's related more to psychological types of conditions or mental illnesses, and whether there's malingering related to that. And that's what we're talking about here. It's the latter category. And the graph or the slide that was put up during his direct examination showed the jury that the score on the MMPI-2 was 8 out of 8. It showed the jury that there are 8 validity scales in the MMPI-2, and that in August of 2013, the defendant scored an 8, and that in July of 2014, the defendant scored an 8, and that both of those tests were done through Dr. Gray. All of that came out on direct examination, and then at some point at the end of the direct examination, Mr. King asked a question about Dr. Hanlon's opinion, and the way he answered the question was to say something along the lines of, based on the testing that I administered and based on everything on the testing done by Dr. Gray, my conclusion is, and then he gave the conclusion in terms of malingering, and he didn't specify it or limit it, to the SIRS. He said, based on the testing I did and based on the testing done by Dr. Gray, here's my conclusion. This is part of his materials. It's one of the slides that he prepared and presumably that he has relied on. So I think it's fair if you open that door for the prosecution to ask questions. So Mr. Brockler is not intending to go too much in depth, but I think what he indicated in terms of the questions that he's intending to ask, I think that type of questioning is appropriate given the direct examination. So the objection is overruled.
Is my understanding correctly that Mr. Brockler is limited in scope then to dealing with the issues of malingering that were in the MMPI, as those were the only scales that were shown? That was the only issue about the MMPI that this doctor testified about, or that there was any evidence about at all, was malingering scales. We're not going to be getting into all of the other scales. My understanding of the question that counsel asked was, what are the various domains of the MMPI? which includes psychoticism and all kinds of other things. There are 40 scales, some odd scales, and so, what the court is saying is that I showed an exhibit that had the scores from the validity profile, and so I'm assuming that the court is limiting to Mr. Brockler to discussion of the MMPI with regard to that domain.
I'm allowing Mr. Brockler to inquire into the areas that he mentioned a moment ago when I asked him how in-depth he's looking to go into this area. I think, given the direct examination, I think the door has been open to those areas that he talked about. If he asks a question beyond that you want to object to, then you can object.
Okay, so hallucinations are out of the question then.
The areas that he mentioned is what I'm allowing. So if there is something beyond that you think is beyond that, you should object, and then I'll rule on the objection. All right? Anything else, Mr. Brockler, at this time before I bring the jury in?
Just to clarify that, because I think my last question was about hallucinations, and then I clarified audio and visual, and then I may have asked one more thing, and then Mr. King approached. I just want to make sure I don't do anything different than what I told the court.
I was referring to the comment you made after the break when I asked you how in-depth are you intending to go into, and you mentioned the things that you mentioned. Those are appropriate. Those go to what makes up the test in general, what type of test it is, whether there was any information, whether he reviewed the answers provided by the defendant to that test or to those tests, because apparently it was administered twice, whether he compared the answers in the test to other information or other materials. I think all those things go to the test results that have been shown to the jury. I think it's fair game. The jury has been shown and told the information that I mentioned, and I think it's fair then to have opposing counsel inquire into the areas that were mentioned a moment ago after the break by Mr. Brockler. If there's something beyond that, then there can be an objection, and I'll rule on the objection.
Well, I'm sorry, Your Honor, but I'm confused because the court just said that I opened the door with regard to the issue of malingering. And so now we're going to get into what are the various domains of the test. Did you examine the data for the whole test? Is there inconsistencies between the results of the test and other information in the record? I mean,
I don't think I said that you opened the door to the issue of malingering. I think you may have said that. What I said is you opened the door to the issue of the test results. You showed the jury the test results were 8 out of 8 in August and 8 out of 8 in July of the following year. He's entitled now to go into what the test is made of, what kinds of questions and categories are in the test, and to challenge the reliability of the score. He showed a perfect score, and he said there was 40 scales out of 40 scales in the MMPI-2, the PAI, and the SIRS. I think opposing counsel then is entitled to question that and to question the information provided in response to those tests. In other words, the significance of the scores. What do these scores mean? I think he's entitled to ask questions along those lines. You can't show the jury the test scores and then prevent opposing counsel from going into the significance of the test score, or perhaps things that may call into question the reliability of the test scores. This witness included this information in his materials, apparently relied on it, among other things, in forming his opinions. And he included it specifically in the slide that was put up on the screen that was shown to the jury during direct examination. I think opposing counsel now is entitled to ask questions about that and what he knows about that. And I don't know what he's going to say. Maybe he's going to say he didn't read the answers and he doesn't know anything about that. Mr. Brockler said at the bench that that's what he anticipates. And maybe that's as far as it goes. But I think he's entitled to do that. He included it in the materials, his materials that he relied on. And I think opposing counsel is entitled to inquire into those materials. So
well, I persist in my objection.
I understand.
We shouldn't be going beyond the things I actually showed and talked about, because anything beyond that is beyond the scope. And for the record, I would anticipate that his answer would be, I'm relying on the report and the expertise of Dr. Gray. I didn't do these tests. I didn't analyze these tests. Dr. Gray did. This is what Dr. Gray said.
All right, so be it. The record has been made and I have ruled. Let's bring the jury in, please. Thank you.
But you have to
Please be seated, everyone. Welcome back, members of the jury. Mr. Brockler, I think you were about to finish your cross-examination. Dr. Hanlon, I remind you that you're still under oath, okay? Yes. All right, thank you. You may proceed.
Thank you, Your Honor. Doctor, we were starting to talk about the kinds of questions in general that get asked in the MMPI 2. You remember that?
Yes.
Let me back up a little bit and lay a little more groundwork for that with you. And that is, one, you are super familiar with this test, correct?
I'm very familiar with the test, yes.
Administered this thing 1,000 times? Less?
I've certainly administered the MMPI to several hundred times.
Several hundred times. Chose not to do it in this case, correct?
True.
Left that for whoever would come after you, fair?
Yes.
But for your January 15th, 2015 report and opinions, you indicate under records reviewed 2 reports authored by Dr. Thomas Gray from the Colorado Mental Health Institute at Pueblo, fair?
Yes.
And his reports make specific and detailed reference to the defendant's performance on the MMPI-2 and the PAI, correct?
Yes.
So where we were was talking about that this test, with these validity questions and scales that you've talked about to the jury, has 527 questions, fair?
It actually has 567 questions.
And
567 questions.
I've even said that number before and I screwed up. Thank you, 567. And those areas that we already talked about included hallucinations, both visual and...
Your Honor, beyond the scope.
Overruled. Included hallucinations, both visual and audio. You've already talked about that. But there's other areas it gets... Is that true, by the way? Because you shook your head. I don't want to misstate something.
I'm not sure. When did I talk about that?
I thought right before the break, but that could have all been in my head.
I don't think so.
Okay.
I don't think I did.
The general questions that are asked in the MMPI-2, do they include questions asking about whether someone is experiencing things like visual hallucinations?
Yes.
And audio hallucinations?
Yes.
And other potentially psychiatrically significant things, correct?
Yes.
Including things about whether they feel that they've conducted themselves in a certain way here, there, or everywhere. Fair? The way their interactions with people is what I'm getting at.
Yes.
Commenting on their physical health and specific conditions. Fair?
Yes.
And a bunch of other things, right?
Yes.
Okay. Those questions are asked in a specific order, aren't they?
Yes.
That order never changes, correct?
True.
So the test that the defendant took in July of 2014 was identical in terms of the questions, the true-false questions that were asked of him when he took it in August of 2013, correct?
They should have been.
All right. Now, you did not go through the individual true-false answers to those questions we've described. Is that fair?
I did not.
And in not doing that, what you don't have the ability to do is to see whether or not his answers to those questions are inconsistent with statements that he gave you about similar topics. Fair?
Objection, relevance, beyond the scope.
Overruled. Go ahead, sir.
Yes, given that I have not reviewed his answers to specific questions, I cannot relate them to specific answers to questions that I asked.
And you can't see whether or not those questions are inconsistent with any of the other many statements that you've seen in the reports that you considered for formulating your opinion.
Objection, relevance, beyond the scope.
Overruled. Go ahead, sir.
True.
In fact, you can't even tell us whether or not his individual answers from August of 2013 are inconsistent with any areas or questions from the July 2014 test, correct?
Objection, relevance, beyond the scope.
Overruled.
I cannot.
And there isn't some, I mean, when we talk about these validity malingering scales, they're largely internal with the test, correct?
They are.
So one thing his performance on the passing, using a term I think you used, the malingering validity scales on MMPI-2 from August of 2013 and July of 2014, that doesn't even tell us if the statements that he agreed to or disagreed with, true, false, are consistent with any of the things we just talked about, right?
Objection. Asked and answered. Beyond the scope. Irrelevant.
Overruled.
Go ahead, sir. Is that true?
No, the validity scales simply tell us that he produced valid profiles on both of those occasions.
Now, one of the things that we did during the break, and I appreciate you doing this, was we pulled out those sheets that we were talking about for that, the PRI 3 subtest. Do you remember that?
Yes.
We talked about the two that were impacted by time. Isn't that right?
Yes.
We looked at actually the defendant's performance on the two block design tests, correct?
Right.
And we looked at his actual performance as you graded it on the visual puzzles part. Is that correct?
Yes.
And those were the two that made up the biggest difference in the PRI, correct?
That's right.
And that big change is what made the biggest change in the overall full-scale IQ, correct?
Yes.
All right, and when we looked at them, what we discovered was this. For the visual puzzles, he missed more. He got them all within the time he was supposed to, correct? No time issues, right?
Yes, except one item.
Except one item. And did you tell me that when we were up there looking? I thought you'd said none.
I think at first I said no, and then I said yes, one item.
Thank you. But really what the decrease was because out of these 26 or 27?
26 items.
26 items, even though he got them within the time with the exception of that one. He missed like 5 puzzles. Is that fair?
That's correct.
On the other one, the block design one, he got them 100% accurate, didn't he?
Yes.
Just like he did in April of 2013, right?
Yes.
The difference is on 2 puzzles out of 14, on 2, he was slower than he had been before, correct?
On 2, he was significantly slower. On 1, he was a little bit slower.
But not enough to make the huge point difference on the,
going
off of that scoring thing you showed me.
It was a point difference. On the other 2, he lost 3 points each.
So those 2 tests make up the bulk of the difference in his score. And those 2 tests, forgive me. Those 2 puzzles make up the bulk of the difference in his score off of the block design test.
Yes.
And he never went overtime on any of those puzzles, regardless of how complex they became, correct?
True.
And so he always got points for every one of the puzzles, no matter when he took the tests, right?
True.
So that full-scale IQ, it would be accurate to say that that thing shows this statistically significant drop in large part because of the way he answered 5 separate 2 blocks, 5 puzzles, 5 separate, I'm going to say questions. I know it's not a question, but do you know what I'm saying? 5 separate items. Fair? I'm sorry, 7 separate items.
Yes, and yeah, that is to a large part. He did also lose points from the other 2, from the working memory index and the processing speed index, not the magnitude of loss that he lost from the perceptual reasoning index, but there were, I just don't want the court to understand that it was exclusively related to those 2 subtests. There were other subtests.
And that's why I've tried to make my questions about the bulk of or the biggest part of, because I get there's other things going on with the many tests that you've put up there, some higher, some lower. I get all that. Okay. But at the end of the day, the biggest mover in terms of decrease in full-scale IQ is because of the way he answered 7 tasks on these 2 tests 20 months after he did them before. Is that fair?
That is fair.
2 weeks before trial.
Correct.
After 900 days in isolation. Fair?
I believe so.
Sorry,
I believe so.
$8.99. Thank you. I do want to talk to you, though, about one other test that was put up there, and you talked a little bit about it, and that was the Wisconsin card sorting test. He improved on that quite a bit despite those 20 months and those 899 days, correct?
He improved. I gave it to him the first time in April 13.
Yes, sir.
Then Dr. Manguso administered it to him then again in August of 14.
Yep.
There he made significant improvement.
Right.
Then when he came back and saw me again, he scored about the same when he saw me as he did when he saw Dr. Manguso.
Got it, thank you. And still a big jump from that first time.
From the first time, yes.
And that's that Wisconsin sorting test that is a huge indicator of executive function, correct?
Correct.
Did you do that IGT thing again with him the second time?
I don't believe so, but let me just check. I did not.
So the only test we have of his ability really, well, not the only test, but one of the primary tests to help us know whether or not intellectually he can anticipate consequences in that cost-benefit analysis was the one you did back in April 2013. Is that fair?
That's the only test that is of that specific paradigm of cost-benefit analysis, yes.
And again, he did well on that one.
He did.
Finally, Doctor, you would agree, as you sat here yesterday with Dr. Manguso, that whatever testing you reviewed, whatever testing you performed, there's no indication to you that the defendant lacks the intellectual ability to form the capacity to know right from wrong based on societal standards of morality, correct?
That's true.
And there's nothing else, same question, that you've come across in your testing or testing that you've reviewed that tells you that this defendant lacks the intellectual ability to form the capacity to, I guess, have the intent to murder after deliberation and considerable planning.
True.
Fair? Is that right?
True.
May I have a moment, Your Honor?
You may.
Nothing further, Your Honor. Thank you.
All right, Mr. King, do you have any redirect?
I do, thank you. Doctor, Mr. Brockler asked you some questions at the beginning about how you approached your examination and the things that you included in your report and the things that you didn't include in your report and the statements that Mr. Holmes made to you. Do any of those things make your test results somehow invalid?
No.
Do they affect your test results at all?
No.
Do they change Mr. Holmes' mental status or ability to think?
No.
You were asked about generating reports, and you were asked about a case, some other case, called People versus Wood, where you didn't write a report because a lawyer asked you not to write a report. Do you remember that?
Yes.
You wanted to add something, and Mr. Brockler said, no, you can't. But Mr. King can ask you about it. So I'm going to ask you about it. What did you want to add about People versus Wood, some other case?
What I wanted to add was, and I could be wrong, but I thought that I generated an initial report in that case, but then I didn't generate a second report because I was asked to go back and conduct a sanity evaluation of Mr. Wood. And I did not produce a report of his sanity because I testified that, in my opinion, he did not meet criteria for insanity in the state of Illinois.
Did you generate a case in this report? A report in this case?
I did.
Did I instruct you not to generate a report in this case?
No.
Did I tell you what to put in your report or what not to put in your report?
No.
Did you just do what you thought you do normally pursuant to your protocol?
I did.
Does the fact that you didn't generate a report in People versus Wood have any effect on this case at all?
I don't think so. I don't see how.
You were asked about interviewing other people, and let me just ask you a general question. As a matter of course, do you want as much information as you can get? Do you ever know what piece of information is going to be important or not, or do you generally willing to look at anything and incorporate that into your opinions?
Yes, I'm willing to look at anything that is relevant to the case.
Mr. Brockler asked you whether you would want to interview other people that knew the defendant in the case and whether or not that was something that you would want to do. And you said yes, right?
I did.
Is that necessary to conduct a valid neuropsychological evaluation?
No.
When you get a referral from a physician who says, I want to find out what this brain tumor has done to my client's ability to cognate, do you need to do interviews with his parents and with people that know him in order to sit down and administer these tests and get a valid result about what his cognition is?
No.
You were asked about letters. You did review some letters to determine his fluency. What's the importance of that? To determine whether he can read and write and speak in a normal way?
I'm assuming I'm not sure what you're assuming.
You pointed out some letters that were written in order to get into undergraduate school.
Okay. Yes, my interest was in his writing style, his ability to formulate verbal concepts, his ability to construct grammatically complex or at least grammatically accurate sentence structure. That's what I was interested in.
Okay. And did you get the information that you needed from the materials that you reviewed?
Yes.
Is it necessary for you then to review emails that he sent, to review kites that he sent to the folks in the jail, to review all kinds of other information to determine whether all of a sudden he's lost the ability to read and write?
No.
Would there be any value in doing that, practically speaking, in terms of the validity of your neuropsychological test results?
No, not given the fact that I objectively tested his ability for reading and reading comprehension and visual language functions.
And did they determine that he still knew how to read and write and was fluent?
Yes.
Do you think you would have found anything in the jail kites that indicated that he wasn't fluent?
I don't think so. I'm not sure what a jail kite is.
You were asked about video presentations that he gave in graduate school. You didn't review any visual presentations, did you?
I did not.
Does that affect the testing that you did in any way?
No.
Do you need to review visual presentations or videotape of a defendant or any patient in order to do a neuropsychological exam of them?
No.
Does the fact that you didn't review videotape of Mr. Holmes giving a presentation or being interviewed by the police mean that his cognition is any different than what you've testified to today?
No.
You wrote in your report a certain chronology, right?
Yes.
Is that something that you do as a matter of course when you give a clinical interview?
In terms of how I document, if I understand the question, how I document my review of records that I review, I list them in chronologic order. That seems to make sense to me, and it seems to make sense to the reader.
Okay. And did you also at some point put in your report a history of Mr. Holmes? The information that you gained from him about his life and what had happened to him through the course of your clinical interview.
Through my clinical interview, yes.
What's the purpose of doing that?
Well, one of the purposes is to determine his ability to recall information, autobiographical information from his remote past, his childhood, his development, his relationship, his education, his vocational history, etc. That is certainly one of the primary reasons for that. Also, to assess whether he is reporting that he had learning difficulties at an early age, or if he was abused by someone during childhood or adolescence. All those kinds of factors.
So are you trying to find things that might affect your testing?
Yes, exactly.
Is the purpose of the interview or the statements that you write in your report to do some kind of full-blown examination of Mr. Holmes' sanity, or compare the validity of the statements that he made to different people?
No.
You were asked about the notebook. You've now reviewed the notebook, right?
I have seen the notebook.
Is there anything in the notebook that would affect in any way the validity of your neuropsychological testing that you administered either in 2013 or 2015?
No.
Completely irrelevant?
Essentially, to me, yes.
And then finally we got to the testing, the actual testing. You were asked about the SIRS, and there was asked about some concern you might have had that Mr. Holmes had heard about the SIRS during a hearing.
Yes.
Is that right?
That's correct.
Is there any indication from the SIRS that test was invalid in any way?
No.
Did the SIRS indicate virtually 100% that Mr. Holmes was not lying about his psychotic symptoms?
Overruled?
No, I'm sorry. His SIRS profile revealed no evidence whatsoever of psychiatric symptom exaggeration or malingering.
You're saying none, zero.
Correct.
When Dr. Gray administered the SIRS, was there also zero indication of any malingering?
Yes.
Have you reviewed the reports of the psychiatrists who evaluated Mr. Holmes in this case, now at this point?
Yes.
Have each and every single one of them indicated that there's no indication at all that Mr. Holmes is malingering psychotic symptoms?
Yes, each one documented that.
Now, you were asked about the practice effect and this software program that you used to help calculate the practice effect. Is that a fair statement?
Yes.
And you were asked about the fact that there was day 0 to day 82, and then that some 600 days later is when you administered the second test, correct?
Right.
Does the practice effect stop after 82 days?
Of course not.
Does the manual for the test that you gave indicate right in it that the practice effect will continue to be in effect for between 1 and 2 years?
Yes, the manual of the Wexler Adult Intelligence Scale warns the examiner that practice effects should be taken into consideration and that are likely present up until 2 years, particularly for the PRI.
And that was what you were dealing with, right?
Right.
That's what these questions are about, right?
Right.
And your testing was between 1 and 2 years, right?
Right.
Is there any indication that the practice effect just disappeared after 82 days?
No, that's ridiculous. There is no reason to expect that practice effect is going to disappear after 82 days.
Did you use the only program available to calculate the practice effect?
I use the only computerized program that is available to assess practice effect.
Is that the computer program that's produced by the same people that make the test and suggested that you use?
Yes.
Ma'am, may I please have slide 8? Now, you tell me, if we have a full scale IQ of 123, and then within that 1 to 2 year period, the test is given again, the practice effect should mean that his IQ should go up, right?
Yes.
It should be like a 128 the second time he takes the test, right?
That would be the prediction, yes.
The prediction is, based on the practice effect, that he should have a higher score because he's taken the test before.
Exactly.
But in reality, he got a lower score. Is that right?
Yes.
So despite the practice effect, he still had a significant drop.
Exactly.
If we eliminate the practice effect altogether and don't even think about it, and just look at the raw numbers, 123, 116, is that still a statistically significant change in a man in his early 20s?
It is.
Can that be explained by anything else that you're aware of?
Not that I am aware of, and not that I have taken into consideration. That is a decline. That is a decline that represents abnormality, significant abnormality in someone in their mid-20s.
Would it be folly to suggest otherwise?
Yes.
Now, you were asked about these 2 tests that involve timing and resulted in some of this decline in the second set of testing. Is that right?
Yes.
The 2 tests that compose part of the PRI, right?
That's correct.
And the first one was called the visual puzzles test. Is that right?
Yes.
And before the break, Mr. Brockler asked you, isn't it true that if you don't get all the tests within a certain period, if you go beyond a certain time limit, you get 0 as a score? And is that how the test works? That's what his question was, right?
That was his question.
And your answer was, correct me if I'm wrong, yes, that's how the test works.
That is how the test works, yes.
But is that what happened when Mr. Holmes took the test? Was he beyond those time limits and got a 0 for a score?
Oh, he was.
That's me.
No, Mr. Holmes was not penalized by going beyond time limits, except on one item. All the other items that he failed were due to wrong responses or inaccuracy.
So Mr. Brockler's contention that it was due to him missing the time limits is just wrong, right?
That is, yes, that is inaccurate.
He didn't miss the time limits. He just got the puzzles wrong.
Exactly.
The same puzzles he got right in April of 2013.
That's correct.
Does sitting in jail make you mentally slower such that it would account for that kind of a difference?
Not in my opinion.
Does depression account for that kind of significant drop in IQ?
No, not generally, and certainly, in my opinion, not in this case, because Mr. Holmes reported that he was significantly more depressed when I evaluated him in 2013. When I evaluated him in 2015, he reported minimal depression.
Right. In 2013, did you ask him, can you rate your depression on 1 out of 10 or something like that?
Yes.
What did he rate himself?
8 out of 10.
What did he rate himself in January 2015?
I believe on the day of my testing, I believe it was 2 out of 10.
So if being depressed makes you slower, he should have been slower on the first test than the second, right?
Correct.
Overruled. He's following up on the last answer.
The other test that was pointed out to you was the block design test. Is that right?
Yes.
Now, in the block design test, you also get a 0 if you go beyond the time limit, right?
That's correct.
Did Mr. Holmes ever go beyond the time limit and get zeros on that?
No.
What the scoring does on this test is it gives you different scores based upon how long it takes you to solve the puzzle, right?
That's correct.
So if you solve it in a certain amount of time, you get a higher score, right? A shorter period of time.
Exactly.
A little bit longer, you get a little lower score, right?
Right.
A little bit longer, you get a lower score, right?
Right.
A little bit longer, you get a lower score, right?
Right.
And then if you pass the deadline, you get a 0, right?
Correct.
Mr. Holmes got no zeros, right?
He did not.
But he did have a significant decline in the speed with which he could solve these puzzles. Is that correct?
He was significantly slower on many of them, yes.
And that's why he scored lower, right?
Yes.
Isn't that the point of the whole test?
It is.
The speed?
Right. It is the speed with which you can analyze spatial relationships and construct those same patterns accurately.
Is it not true, Doctor, that one of the chief cognitive effects of schizophrenia is that it slows down the speed, the ability of people to think quickly? Isn't that one of the most profound cognitive effects of schizophrenia?
Sustained.
Is that, or is that not, one of the cardinal, most profound effects of schizophrenia on cognition?
Neuropsychologically, speed of information processing is one of the most consistently found cognitive deficits in schizophrenia spectrum disorders, not just schizophrenia.
So the fact that he got a lower score because he was slower indicates, is that significant in any way? Is that some kind of mistake in the test? Is that an erroneous score?
I don't believe so. I believe it's a reflection of pathology.
And that pathology is psychopathology, right?
Correct.
Did anything that Mr. Brockler just said to you this afternoon, anything, affect in any way the validity of the neuropsychological testing that you did?
No.
Is anything that Mr. Brockler said this afternoon affect in any way Mr. Holmes' cognition and the fact that he's had a dramatic drop in IQ over the past 2 years?
No.
I just asked you a question about psychopathology. That means the underlying psychiatric illness, right?
Yes.
I have no more questions, Your Honor. Thank you.
Do you have any recross, Mr. Brockler?
So, Doctor, I'm interested in clarifying some of the things that you got out here with Mr. King that you agreed to. when you were talking about the practice effect and you relied, it looks like exclusively on that software for coming up with the number that you reported in your report to us. Is that fair for the practice effect?
I did rely on the software as I reported as I put in the report.
And in between the yells and stuff, what I lost was that number based on a presumption that it was no more than 82 days after that guy took the test again. Is that fair? That's what the software says, right?
That's what the software says, yes.
So when you suggest, hey, jury, it doesn't matter, there was still a practice effect to be intended, it's not the same practice effect that you just testified to at 128, is it?
Well, it may not be. However, in my field, we know from multiple empirical studies that practice effects on the Wechsler Adult Intelligence Scale exist for much, much longer than 82 days, which is then why many neuropsychologists throughout the country use that same program that I used with intervals much longer than 82 days. In fact, the authors and the publishers provide case examples that are up to a year or longer in the book that they published that goes with the WAIS-4.
Thank you, Doctor. You're not telling us that the defendant's practice effect some 600 days later would be as accurate as it would be at 82 days later. You're not telling us that, right?
It probably would not be.
So what you're telling us is you used an inaccurate tool in your report, fair? It was either accurate or it wasn't, Doctor.
I don't believe it was inaccurate. I think it is an applicable tool to use. The cutoff is different, but given what we know from the research in practice effects, it is the practice effects go much longer. The other thing is you can completely eliminate practice effects completely, and you still have a significant change.
Did you understand my question?
I believe so.
My question was, you used an inaccurate tool in your report, fair?
I don't believe so.
Do you believe that the practice effect would have revealed a IQ score, a full-scale IQ score of 128 600 days later, just as it did 82 days later, unchanged?
In a normal person without any psychopathology or any neuropathology, that is certainly possible.
That's not what I asked you, Doctor. Look, you testify. There's a hand formula you could use, right?
There is.
And if practice effect, as you've testified to previously, is based on the length of time for in between tests, doesn't just common sense indicate that 82 days later is going to be different than 600 days later?
Well, there are, and I understand that line of reasoning. However, there are other factors to take into consideration, because with people with much higher level of intelligence, practice effects endure for a much longer period of time.
I just want you to tell us, Doctor, that you think that his performance on that WAIS-4 would be the same 600 days later that it would be 82 days later. Just tell us that.
Object to the form of the question is argumentative.
Overruled. Go ahead.
I don't know that it would be exactly the same, but it would be increased.
Are there any other tools that you use that were software driven and limited in the way that we've described here?
I'm not sure I understand the question.
Oh,
for scoring, you mean?
Yeah, that's right. I mean, are there any other software things that we should be aware of where it cuts off at a certain level and it doesn't factor in certain things? Or, I mean, anything else you relied upon other than your own work that would have given us an answer that is less than accurate like this one?
No.
I'm confused about something that you said, and that is you told Mr. King it wasn't important for you to be able to talk to the defendant's parents or other people that were close to him to do the job you were told to do. Do you remember that?
Yes.
I swear, I thought you said on cross, You asked him to let you talk to them so that you could factor it into your analysis because you thought it was important. Did you change your mind, or did I mishear you?
I did ask him, but the question that he asked me is not speaking to them. Did that affect the validity of my test results? I believe that was the exchange.
Yeah. Oh, I don't know, Doctor, was it?
That's my recollection.
Do you remember testifying in a case called Missouri versus Driscoll? Bless you. Do you remember that?
I remember the case.
Yeah, it's a death penalty case from Missouri. Do you remember that?
Yes, it's a horrific case.
Yep, and you were asked to conduct a neuropsychological evaluation, correct?
Yes.
And one of the things that took place during your testimony was an exchange where you were asked about things you did beyond reviewing the records you were provided by the public defender's office. Do you remember that?
Yes.
And your answers were this, and you tell me if you agree with this. Well, I talked to Gloria, Mr. Driscoll's mother, and Amanda, a friend, and then I also talked to 2 of his cousins. Do you remember saying that? Words to that effect?
I don't remember the cousins, but I remember the other 2.
If you'd like to see the transcript, I have a copy of it for you.
It's okay.
Question: why do you review records and talk to witnesses in performing a neuropsychological evaluation? Answer: to try to obtain as much information from as many sources as possible. Do you recall saying that?
That sounds like me.
You also go on to say it's also important to get input from individuals, significant others who know the defendant very well. Do you recall that?
I believe I said that.
Follow-up question. And that provides you, like when you talk to witnesses, that would provide you with insight into that person's behavior at times other than when you actually evaluate them. Answer from you, true. Fair?
Yes.
That did not happen here, correct?
Correct.
Because you weren't permitted to do it, correct?
True.
You were asked, too, about the questions that we went into and about whether or not they had an impact. Doctor, you don't just ask questions for fun, do you?
I do not.
You ask questions with a purpose in mind, correct?
Yes.
And Mr. King said you ask questions to find out if there's something that's going to impact the testing that you're about to do, correct? Well, why do you
I guess he did. I
well,
don't recall that specifically, but I believe you.
I'll go big and broad. Sorry to interrupt you. Why do you ask the questions you ask?
To obtain information that is that I think is relevant to my understanding of development, education, and how they may impact neuropsychological status.
Okay. Why did you ask questions about the defendant's drug and alcohol use?
To determine if he had a history of drug and alcohol abuse that might affect his cognitive status.
And he told you of none, right?
I believe so.
You need to look at your report.
I think he said he might have smoked marijuana a couple times.
But that's not something that's going to, in the past, too, way in the past, right?
Right.
That's not something that's going to impact your testing here, right?
No.
In fact, he even told you that he smoked the occasional cigar once a month in the past.
I believe he did. I believe he did.
Not going to impact the testing, correct?
I don't think so.
One of the things that you did not echo back to Mr. King was when he asked you if the defendant was lying about his psychiatric symptoms based on his performance on these validity scales and these other tests. Do you remember that?
Judge, objection, may we approach?
Yes.
May I inquire, Judge? I'm sorry.
Yes, you
Sorry.
may proceed based on the discussion that we had at the bench.
Yes, sir.
The objection is sustained.
Yes, sir. One of the other things that you were asked by Mr. King was whether or not any of the emails, texts, other writings closer to the time of the crime were relevant to your consideration in this neuropsychological set of evaluations. Do you recall that?
Yes.
And you had said they were not. Do you remember that?
Yes.
And so that we're clear, what was important were the two things he generated back in 2006, 6 years prior to this crime. That's what you're saying.
Those two things were important.
And not the things in between, correct?
Not the emails and the texts.
Nor any of his papers that he wrote to his graduate professors, correct?
I would have preferred to have read those, some of those documents, but I don't believe I'd had access to them.
Weren't given them.
I don't believe so.
And then you talked about the notebook too, and how that seemed to have zero impact on your neuropsychological assessment. Fair?
Yes.
One of the things, though, that's contained in that notebook is a series of pages that lay out in pretty good detail planning for the murder of people in the Century 16 Theater. You'd agree with that, correct?
Yes.
I mean, I don't know if you could call that the like a Wisconsin card sorting test, but there's a lot of problems identified in that notebook. Fair?
Yes.
And ways to work around those problems. Yes?
Yes.
He considers the pros and the cons of not only whether to attack an airport or to conduct serial killing, but also which theater within Century 16 is the best to maximize casualties, correct?
I believe so.
These all feel a lot like what you've described as executive functions, don't they?
They certainly...
To the characterization of the question is feel like.
Overruled.
Go ahead, Doctor.
They are certainly reflecting strategic planning.
Can I have a moment, Your Honor?
You can. All right, the jury appears to have some questions for you, Dr. Hanlon, so I'm going to ask you to please give us a moment, okay?
Certainly.
All right, thank you. Members of the jury, this is probably going to take a few minutes, maybe 5 minutes. Would you prefer to stay in the courtroom and have me turn on the static noise, or would you rather go out? You're okay with me doing that? Okay, feel free to talk to each other, just not about the case, okay? All right. Okay, would counsel please approach? All right, Doctor, the jury has submitted some questions that, based on the rules of evidence and other applicable rules of law, I have found are appropriate. The first question reads as follows. Why, if you stated that talking to families of the patient is so important for clinical interview, would you not stand by your belief and tell the defense that it was something you needed to do?
Well, I do think that interviewing what are often referred to as collaterals, family members, friends, et cetera, I do think there is important information to be gained from that. I requested to be able to contact family members and interview them. I was told that
You can't get into hearsay, so.
Okay.
Which would be what somebody said to you.
Okay. As a result of being told that I would not be allowed to do that, I chose to proceed and conduct the evaluation that I had agreed to do, despite the fact that I was not able to interview family members. It was not optimal, it was not ideal for me, but I capitulated to that situation.
The next question is, you stated that much of the information and reports available regarding Mr. Holmes was not relevant to performing an accurate neuropsychological test. Why review any data rather than only the data provided by the defense?
If I understand the question, I think it's a good question. I reviewed, I was provided with a massive amount of data, and I chose to review data that I thought was relevant to the questions that were being asked of me. I often conduct clinical neuropsychological evaluations of patients with various types of brain disorders with minimal information, and that is just the nature of that kind of situation. There often just is very little information, very little history available, particularly on inpatients. Again, I proceeded with the evaluation. I'm not sure I'm answering the question at this point, but I conducted the evaluation to the best of my ability and tried to do an objective determination of his neuropsychological status, incorporating the information that was made available to me that I thought was relevant.
The next question is, are any sections of the neuropsychological test graded on a subjective basis? If so, what sections, and how do you subjectively grade those sections?
No, good question. No, neuropsychological testing is, there is no subjective scoring or subjective analysis of scores. The scores are what they are. The scores are objective, meaning that the examinee performed, responded in a certain way. They answered a question with certain words, they responded motorically, they responded after some visual analysis, and they make a choice. Then those choices then generate a raw score. That raw score then is converted into what's called a scaled score or a standard score, which is based on a normative sample of people that are typically from the same age group, often from the same gender, and in many cases from the same educational level. So that is the objectivity. There really isn't a subjective element to the scoring. There is some subjectivity that comes to interpretation of the objective scores.
The next question is, would slowing down a bit purposefully on the block design or visual puzzles test be a sort of malingering which could affect results if a person understood how the tests worked?
Again, insightful question. There is a remote possibility of that. However, that would then require, if there is no evidence of that similar kind of slowing down on any of the other speeded tests that were done, and there were a multitude of other speeded tests that were given, and he didn't slow down on any of them. In fact, he got faster on many of them. So that kind of selectivity in terms of I'm going to slow down on this, but I'm not going to slow down on this, I'm actually going to go faster on this, it doesn't, it's not consistent with, it's not suggestive of intentional misrepresentation.
The next question is, if you know, and if you can answer this question in other words, can lack of intellectual stimulation as incarceration in isolation cause a nonverbal decrease in scores?
Lack of intellectual stimulation. Lack of intellectual stimulation. My understanding of, and there is a body of research on this topic. It's not a very broad or deep body of research, but it exists. The effect of isolation is more likely to cause emotional changes than it is to cause intellectual changes, particularly on people who are already vulnerable or predisposed to have some mental disturbance. I suppose there's the remote possibility that you could, if you then become depressed due to social isolation, that could then have a secondary effect on intellectual functioning, but it would primarily be the effect on emotion, mood.
The next question, again, if you know, can going from actual hands-on experiment to only reading cause a decline in nonverbal scores?
Okay, so if I understand the question, I'm just going to infer what I understand this to be, going from doing hands-on experiments in a research lab in a neuroscience program to spending one's time in a jail cell reading. That's my interpretation of the question. And I'm sorry, and then what was the final point of it?
The question is, can going from actual hands-on experiment to only reading cause a decline in nonverbal scores?
I do not believe so.
And the last question is also, going from playing many video games to none cause a decline in spatial scores, SPATIAL?
Good question. I don't, in my opinion, no, based on the difference between video game engagement and the kind of test structure that is involved in intelligence testing. I don't think so. I think it would be more likely to affect attention.
Any follow-up questions based on those questions, Mr. King?
Yes, Your Honor.
All right.
The first question you were asked, I think, was about talking to family. And I think the question was, if you thought it was so important, why didn't you refuse to do the evaluation? If you thought that it was so important to talk to Mr. Holmes' family, that it would invalidate your neuropsychological testing in any way, would you have conducted the testing or would you have refused to do it?
If I thought there was any remote possibility that me not having the opportunity to speak to family members would somehow, and I don't know how that could possibly happen, invalidate test performance in a neuropsychological evaluation, then yes, I would have refused to do it.
Was that the case here?
That was not the case here.
Have you subsequently reviewed reports from Drs. Gurr, Metzner, and Reed, psychiatrists who all did interview Mr. Holmes' parents?
Yes.
Was there anything contained in those interviews which would have affected your neuropsychological testing or results in any way?
No.
You were asked, why did you not review any data other than was provided to you by the defense, I believe. Did all of the data you received come from the defense? Did Mr. Brockler provide you with any information?
Not that I'm aware of.
Did the court provide you with any information?
No.
Did you go out and conduct your own investigation?
No.
Did all of the information you received come from me in my office?
Yes.
Did we provide you, you said a massive amount of information. Did we provide you with such a massive amount of information that it would have taken many, many months to even read all of it?
Yes.
Do you at some point have to make a decision about whether or not there's any value in reading every possible piece of information or finding out every possible fact about the case before you can conduct neuropsychological testing? Does there have to be some prioritization going on there?
Yes.
Now, you said that in some circumstances you conduct neuropsychological testing with virtually no background information. Is that right?
Yes, that is relatively common with clinical patients.
And does that invalidate the test or the results of the test in any way?
Not at all.
We asked about subjective grading of these tests. Do you have any ability to subjectively change or manipulate the scores on the test, or is the test a true objective measure?
The tests are true objective measures, and the scores are not subjectively changed in any way.
You asked about if someone were to deliberately slow down on one of the tests, could that affect it? And I think you said there was a remote possibility. Do you see any indication based upon Mr. Holmes' performance on the test and based upon all of the validity profiles that were conducted by you and Dr. Manguso, that he did anything but offer an optimal, put his best effort into all of these tests?
Yes, in answer to, I interpreted that as kind of a hypothetical question. Maybe I shouldn't have, but there is no question in my mind that given the multitude of measures, tests to assess his effort, to assess the validity of his responsivity, there is no question whatsoever that the tests I did are valid and accurate. I also believe the tests that Dr. Manguso did are valid and accurate.
You were asked about whether the lack of intellectual stimulation from being in jail, for example, could result in someone having a decline in IQ. And I believe you said that the answer was no. Is that right?
I do not believe that is going to directly change IQ.
So being isolated doesn't make your brain work worse, does it?
No, it's not going to change intellectual functioning.
Well, you did say it might affect someone's emotions in terms of being depressed, and being depressed may have somewhat of a possible effect. Is that fair to say?
Right.
If that was the case, would his scores have increased then, because he was less depressed, significantly less depressed during the second testing than the first testing?
Right.
Overruled. You were asked if moving from doing experiments to just reading would result in a decline in IQ. Anything about doing experiments to reading that would make you unable to reduce your IQ?
No, I think I said no.
Okay. And playing video games, is that the same?
Correct.
Thank you. I don't have any other questions.
Mr. Bruckler, do you have any follow-up questions?
I do, Your Honor. Thank you. A couple things. First off, I just want to clarify the information that you were provided is limited by who hired you, correct?
Yes.
And so what they choose to give you or choose not to give you limits the things that you're allowed to consider. Fair?
True.
And that includes access to the parents, right?
Yes.
And what I don't want to do is walk out of here with the idea that I'd love to talk to the parents, but it's no big deal if I don't, because that's not what you said in a death penalty case in Missouri, is it?
It's not.
It's important, right?
It is preferred.
And important.
And it can be important. I've certainly talked to family members that turned out to not be very important, but it is preferable to have the opportunity.
And you can't know till you do it, right?
True.
And so what Mr. King then asked you is, well, hey, didn't you well after the fact get an opportunity to review reports by psychiatrists who may have reached out to the parents? Do you recall that?
Yes.
They're not neuropsychologists, are they?
No, they're not.
And they talked to them well after you had the opportunity to do your first set of testing on the defendant, right?
Yes.
A couple other things. Look, this question about can you malinger on the block test, it's interesting, isn't it? It's an interesting question. You'd agree with that?
It's an interesting question.
If somebody knew that they could still get all of the puzzles right, block designs right, but if they just counted to 30 in their head the second time around before they answered, they could change their score on that test, couldn't they?
I suppose if someone was that experienced with the test and knew what the time parameters were, I guess an experienced neuropsychologist could do that.
Well, they don't have to know the time hacks. They could just say, hey, I'm just going to take longer to answer the questions, right?
They could, but then at times they would be going beyond the cutoff, because there are some 30-second cutoffs.
So if it was someone smart, let's say, who knew about stuff like the test, right?
Again, if they knew what the administration structure was of the test, they could probably do that.
And frankly, if they hypothetically had taken the test, 20 months earlier, and that information had been provided to someone that they had access to, that might give them that kind of information, wouldn't it?
Then that would be a significant practice effect.
Yep. And in the opposite direction, right?
Right.
The other thing I wanted to ask you about was this idea that, do you remember on redirect or direct? I can't remember. Mr. King said, hey, do you see how this guy's verbal scores are going up? Couldn't that be attributable to the fact that he just reads all day in jail? Do you remember that?
Yes, vaguely.
Well, did you testify that reading all day in jail could increase his verbal scores on some of the neuropsychological testing you did?
I believe I did.
And I just want to make sure I got this right. If he focuses his time and attention on the task of reading, your opinion is it could increase his verbal score. But if he loses out on all of the other mental stimulation that he had had prior to committing this crime, that it would have no impact, up or down, on his brain. Is that fair?
Objection to increase his verbal score. There was no increase.
Overruled.
Go ahead. You've already testified to that, doctor, but did you understand my question?
I think I did. Well, I think what you're getting at, and I am too technical about it, but we're talking about the difference between what's called crystallized intelligence and fluid intelligence. Crystallized intelligence is knowledge-based. It's what we acquire from reading, study, etc., verbal-based. That's called crystallized. Fluid intelligence involves constructional abilities and perceptual functions. In my opinion, not engaging in constructional tasks is not going to have a major impact on performance on something like block design because it's a novel task.
Doctor, you talked about the normative factors on some of these tests to include age, gender in some cases, ethnicity in some cases, education in some cases. You agree with all that?
Yes.
These are attempts by these test makers who you follow the rules and get the answers and plug them in and the computer tells you what the answer is, correct?
In some tests.
Yeah, and these are the things that they tried to make normative so that they take into consideration these factors. Fair?
Yes.
Is there any test that you administered that allows you to take into consideration whether somebody is free and, let's say, in their first year of neuroscience versus 900 days later after having been in isolation, 2 weeks from starting a death penalty trial? Is there any normative way to compare those two?
No.
So the test presupposes that the defendant, having taken this test back in, let's say, January of 2012, they score that the same way as January of 2015. Correct?
They're scored the same.
Nothing further, Your Honor.
All right, may Dr. Hanlon be released from his subpoena? Is there any objection? Is there any objection to that?
No, sir.
All right, doctor, thank you.
Okay, thank you, sir.
All right, members of the jury, it's 7 minutes till 5, so we're going to go ahead and stop for the day. Since we're about to start a long weekend, you know what's coming, right? That's right. I'm sorry I have to do this, but these are extremely important. You know that already. And I know you know these by heart, but I sleep better at night when I give them to you. So I need to give them to you. I'm hoping that we will have the case to you for deliberations at some point during the week of July 13. So we're making progress, but it is important that you continue to abide by all my admonishments. They are all extremely important, and I ask that you not take the attitude of who cares if we violate one time, or the attitude of nobody's going to find out. Please avoid taking either attitude. That would be problematic. We rely on you. We took our time selecting a jury, and we selected you because we are confident that you can handle this and you can do this. I know these are difficult things that I'm asking of you, but I have all the confidence in the world that you can do this. And I want to go through all the admonishments again. Number one, please do not discuss any aspect of the case with each other through any means. You're free to talk to one another, and I encourage you to be friendly with each other, but you cannot talk about the case or anything related to the proceedings or any part of your service as a juror in this case. Number two, in addition to not being able to discuss the case with each other, you may not communicate about the case with anyone else through any means. And you may not communicate about any other case like this one with anyone else through any means. That includes your spouse or significant other. All you can tell people is that you're a juror in a trial in Arapahoe County that is expected to end in August of this year. Number three, you may not have any contact or communications with any jurors who have been dismissed. And that includes in person, by telephone, by text. electronic means, through any means. Number 4, please do not talk to any witnesses, parties, or attorneys about anything, whether related to the case or not. Number 5, to make sure that witnesses, parties, and attorneys do not talk to you, it is imperative that you wear your juror badge whenever you're on the courthouse premises and that it is visible to everyone around you. Your juror badge will also reduce the risk that people will talk about the case in your presence. If you hear anyone talking about the case, please remove yourself from that location. And in the event that despite your best efforts, you hear something about the case from anyone, regardless of what role that person has, if any, in the case, or whether they're just a member of the public, whoever that person is, please let my staff know that you need to talk to me. All you have to tell my staff is you need to talk to me. Don't go into any details about what it's about, or what it is that you need to talk to me about. And I will bring you in here and I will talk to you in private. Number 6, please do not talk to any members of the media about anything. Number 7, you must not read, view, or listen to any news or media reports that may refer to the case. Because there is media coverage of the trial, I ask that you be particularly vigilant while listening to the radio, watching TV, reading the newspaper, and using the internet or any electronic device. I think the best thing to do is to try to avoid news reports or try to avoid listening to the radio or watching the news at times that you know news reports are going to come on. I think that's just the safest way to go. There are going to be times when there are media reports about things that you've seen here in the courtroom, but there are also going to be times when there may be media reports about things that the lawyers and I are talking about outside your presence. The reason we're talking about those things outside your presence is because you're not allowed to hear about them. That's by law. And you should not speculate about those things. You should not infer anything from those things. And you also should not acquire any information about any of those proceedings. But you're also not allowed to receive media information about the case, even if it's about proceedings that you may have been present for. You just cannot receive any information about the case from any media source. Number 8, you cannot visit any locations that are mentioned in the case or conduct your own investigation outside the courtroom. That includes looking terms up. That includes using references from outside the courtroom, including encyclopedias or legal books or treatises of a scientific nature or religious books. You just cannot refer to any source outside the courtroom, any outside source. We want to make sure that you make all decisions in this case based only on the evidence presented in the courtroom and the instructions of law that I give you, which is my next admonishment, and that is your verdicts in the trial must be based solely on the evidence presented in the courtroom and the instructions of law that I give you. I've said this in different ways in the past, and I mean the same thing. All your decisions in this trial have to be based on the evidence presented in the courtroom and the instructions of law that I give you. Number 10, you cannot start forming any opinions about the case until I tell you that you can start deliberating. You must keep an open mind throughout the trial. Sometimes in our culture, we get used to thinking about things in terms of which side is ahead or which side is behind, or, oh, this side just went ahead or went behind. You have to avoid the temptation to think along those lines. You have to keep an open mind throughout the trial, and you have to be mindful that the defendant in a criminal case is presumed innocent, and that presumption of innocence stays with him and must be given effect by the jury throughout the trial. Number 11, neither sympathy for nor prejudice against the prosecution or the defendant may affect any of your decisions in this case. And number 12, and finally, remember that the attorneys have a job to do. They are required to make objections. Please don't hold it against them when they make objections, or if they ask for a bench conference, they're doing their job. That's what they're supposed to do. Similarly, please don't read anything into my rulings in terms of me being for one side or the other. You should not even keep track of how many objections I'm sustaining for one side versus the other, or overruling against one side versus the other. I'm neutral in these proceedings, and I'm simply doing my best to apply the rules of law, including the applicable rules of evidence. So that's all I'm doing, and that's all you should infer from my rulings. Does everybody understand all those admonishments? Yes, and I know you know them by heart, and I know you're smiling at me like, yes, you've given it to us a bunch of times, we get it. Please have a great 4th of July weekend, get some rest, and then I'll see you back here at the usual time on Monday morning. Actually, not at the usual time, I know. I was just testing you. 9 o'clock Monday morning. You should be here about 8:45. Thank you. All right. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. In terms of scheduling, Mr. King, I know that you've fallen behind of what you anticipated in terms of how many witnesses you were going to be able to call today. When are you thinking now you might be resting?
Well, I think now we're bleeding into Thursday of next week.
Okay. All right.
I don't know that for sure, but based upon the way it went today, I think that's probably more accurate.
Okay. And some of it depends on how long Dr. Gurr takes as well. And given that the estimates have been off on the by being too short, it might be that we go into most of Thursday. I mean, if the estimate with respect to Dr. Gurr ends up being short as well, as it has been with respect to other experts, then we might go into most of Thursday, which means that the prosecution may be calling their rebuttal witness on Friday possibly instead of Thursday. So
Yeah, at this point, Your Honor, we just don't know how long any rebuttal case we might have. I don't anticipate it going longer than next week, but again, these things are all fluid.
I understand. And we may not be able to do closing arguments on the 13th. It may be the 14th, and that's fine. Or we may be able to keep the 13th. So, but, you know, some issues have come up. There will be some other issues that are going to come up. It's just part of the process, and we'll deal with them the best we can, and we're making the best estimates that we can and trying to predict the best we can about how long things are going to take, but that's always a difficult proposition, as everyone knows. So my goal is still to see if we can finish with the defense's case by Wednesday, to see if the prosecution can present its rebuttal case on Thursday, and perhaps into Friday, and to be able to do closing arguments on Monday. That's still my goal, but it may be Tuesday before we get to closings.
And Your Honor, assuming that we get done next week with what we need to do in order for closings to take place Monday, just so that we can inform people in case they ask, was Your Honor planning on them closing starting in the morning, first thing, sometime later in the afternoon, just so we know?
9 o'clock, unless, again, something changes. For example, if your rebuttal case takes until the end of the day on Friday, then I'm probably going to need some time on Monday to talk to you about instructions. And that may mean that we have to wait until Tuesday for closings. Or it's possible that we have an instructions conference on Friday afternoon because we have a little time to do it. And we just need an hour on Monday morning to finalize things, and then we can start at 9 or 10 or something like that. So my goal, again, is to start closings at 9 on Monday, but everyone has to be flexible. If we start at 9, my plan is to give the jury the instructions and sample verdict forms, read those, go through those and read them. That's gonna take about a half hour, maybe 40, 45 minutes. Maybe take a break at that point, start with the prosecution's closing argument, have the prosecution make its closing argument in the morning, take a lunch break, have lunch brought in for the jurors to save some time, and then do the defense's closing in the afternoon and the prosecution's rebuttal close after that with a break in between the two. So we would probably have to take multiple breaks throughout, just given that each side is gonna have 2 hours for closing arguments. That's the plan. But it depends on how much we get done next week, obviously.
Thank you for that information, Your Honor.
Okay. In terms of the instructions, the draft instructions, my staff will distribute those to you. This is the latest draft. And two things that I want to point out about this draft, and we'll have arguments later, so I'm not looking for argument right now, but I'm just giving you a heads up. Number one, I've included lesser included offenses, the 2 lesser included offenses for each charged crime that Ms. Nelson asked for, except for the possession or control of an incendiary device, an explosive or incendiary device. That one doesn't have, there are no requested lesser included offenses, but I was persuaded by what she said, and so I've included those. And the other thing is that, as you know, the verdict forms have different parts. Part A asks the jury to decide guilty or not guilty, and if guilty, then to choose whether guilty of the charged offense or one of the lesser included offenses. Part B would ask the question about insanity, and essentially it would be, if you found the defendant not guilty, did you find them not guilty solely because of the insanity defense? The way the instructions in the verdict forms read right now, the jury would not get to that part B of any verdict form unless they first find the defendant not guilty of all 165 charges and all of the lesser included offenses. And that's different than the draft that I gave you earlier, and that draft was wrong. There's a statute on point in Colorado. There's a Colorado Court of Appeals case, and there's a Colorado Supreme Court case. So, and the reason is you want to avoid a situation where the jury might find someone guilty of a count and not guilty by reason of insanity of another count. And in that case, one count would dictate that he be sentenced, for example, to prison, and the other one would dictate that he be sentenced to the mental health hospital. And so in order for the jury to answer the question about insanity, the jury first has to find that the defendant is not guilty of all the counts and all the lesser included offenses. So take a look at the instructions, take a look at the verdict forms. By the way, this is consistent with the model instruction, and if you remember, I had deviated from it when in the first draft, and I think I asked Mr. Orman about it at that time, and he said, yes, Your Honor, I think it's right the way you've done it. And he kept bothering me about why the model instruction would be wrong. And the model instruction is not wrong. The model instruction is right. And again, there's a statute that's right on point that says this is exactly how we do it. And there is a case from the Colorado Court of Appeals and a case from the Colorado Supreme Court. I'll take argument later when we have the next conference, but
I hate to ask the court of something the court would normally ask me, and just so I can go look it up, do you happen to remember what the citation is of that statute?
I remember the case is Bielicki, Bielicki. Actually, I have it on my desk. Ms. Gerling, can you get it? It's on a piece of paper on my desk, and it's got my handwriting, and it's in blue marker. Thank you. I'll give you the statute and I'll give you the cases as well. Hold on just a second. And let me clarify, this does not change the burden of proof. The burden of proof applies with respect to each count, including the sanity element. This is simply related to the verdict forms. And what the case law says is that if the jury finds the defendant guilty of even one count or a lesser included offense, We don't care what the reason is for the finding of not guilty on any other count. And that's why the jury in that situation doesn't even get to the question about insanity. All we care about at that point is that they have found him not guilty of those counts. Again, because we don't want a situation where you have one guilty verdict where the court has to sentence him, for example, to prison, and another one, a not guilty by reason of insanity verdict, where the court has to send him to the Department of Human Service, commit him to the Department of Human Services. The case is People versus Bielecki, Bielecki. It's cited at 964 Pacific 2nd at 598. That's a Colorado Court of Appeals case from 1998. And then People versus Collins, 752 Pacific 2nd, 93. That's a Colorado Supreme Court case from 1998. And the statute is section 16-8-105.5 subsection 3. Okay. Is there anything else at this time before we adjourn? Anything on behalf of the people?
Your Honor had indicated that you would be willing to email us copies of...
Yes, my staff will do that right after we end today. Anything on behalf of the defense?
Your Honor, may I approach with a member of the prosecution, please?
Yes. by the way, before I forget, and we'll get to you, Ms. Nelson, in just a moment, P-TR-1258, I said I would defer ruling on it, and this was from the profile from the Northwestern website. Does anybody have that? Are you still seeking its admission, Mr. Bruckler? It sounded like you got what you needed from it.
I think that's right, Your Honor. I mean, I'd always like a visual reminder of it, but I think I got out what I needed to.
Okay, given that, I'm going to deny the request to admit. So if you want to mark it as a trial court exhibit, you can, but I think it would be cumulative at this point. I'll give it back to you. I didn't want to forget to do that. Thank you. All right. Ms. Nelson.
Sorry, this is a bit awkward, Your Honor. As I began to explain at the bench, and I'll just repeat what I said.
Actually, hold on just a second. Can we take a 5-minute break? Yeah. Let me take a 5-minute break and come back and take it up, okay? Thank you. All right, we'll take a 5-minute break and then we'll start again. Sorry. The court will be in recess for 5 minutes. Thank you.
So they have us hanging on a wire, hanging on a string, waiting for what exactly Ms. Nelson has to bring up with the court. And we're going to use this brief intermission, this 5-minute break, to talk to our legal analyst, Rick Kornfeld, who is on the line, I believe, ready to tell us, answer a couple questions for us as we make our way through this to find out what Ms. Nelson does have to say. But Rick, let's talk about Dr. Hanlon today. The prosecution on cross-examination and then recross, and then after the jury questions, they held him and asked him tough questions about why he didn't have or meet with, or why did he reach his decisions without talking to the parents, without considering the notebook. And I want to ask for your opinion on this topic, on this subject. Is this going to be an effective strategy for discrediting Dr. Hanlon?
Well, it's a common strategy, impeachment by omission. Basically, you didn't do this, you didn't do this, you didn't do this, you didn't do this. Wouldn't it have been important for you to do that, et cetera, et cetera, et cetera. That's a very common mode of cross-examination. And if he did all the things that they complained about today, they would have found other things that he didn't do. So that can be effective, but sometimes you run the risk of protesting a little bit too much. You also run the risk of really signaling the jury that you don't like his testimony. And so you're trying to shoot as many holes in it as possible, and in the process, you're running the very high risk of highlighting it. A juror could say to himself or herself, "My God, this must be really important because Brockler is really taking off after this guy." So it's a risky strategy. It can be effective if, in fact, in their rebuttal case or through other witnesses, they get experts to say, "This guy should have done X, Y, and Z. He didn't do it here, therefore that undermines the credibility of his conclusions."
And when we talk about, or when we heard him talk about, Dr. Hanlon talk about these tests, and he was cross-examined, of course, about the things that you're discussing there, Rick, but he attested to the fact that these tests are true objective measures. And I wrote that quote down so that we could use it later today in writing our stories, but true objective measures. If he's testifying that these things, his assessments didn't require this, is Brockler's strategy going to be undermined?
It's going to be undermined for sure if the jury believes the doctor and finds this doctor to be credible. A true objective measure, I took note of that also. Is there such a thing in this world as a true objective measure? That's kind of an interesting comment, but I am sure that he would not be using that term if that were not a term of art in his particular field. So the doctor wrapped his arms around these tests as being, sort of the standard, the gold standard, because they are the true objective measure. And so what Brockler is left doing is, number one, poking holes in the thoroughness of the true objective measure in order to argue later on that it's not a true measure, let alone an objective one. And number two, does he have a witness in his pocket who will say these tests are not the true objective measure, or this methodology employed by the doctor was deficient under our standards in this profession? He didn't do that today. Just because George Brockler says, well, didn't you do this or shouldn't you have done that, that doesn't make it so. But he's doing what good lawyers do, and that is, you can ask people about what they did, and you can ask people about what they didn't do. And sometimes what they didn't do, again, impeachment by omission, can be equally, if not more effective than impeachment by commission, attacking what they actually did.
Philosophical kind of sounding statement. Let me ask you for a little bit more legal 101, specifically today on this idea of out of scope, this objection that we heard over and over again today. And today there certainly felt like there were a lot of ongoing objections. And, well, many of them, the ones that we could hear without bench conferences anyway, involved out of scope. So let's start with explaining to us and our viewers what exactly that means.
Okay, so on cross-examination, you are allowed to question the witness about the topics that he or she testified to on direct. So those are sort of your guardrails on either side of your questions. If you start going into other topics on cross-examination, it's beyond the scope of the direct examination, and therefore you're not allowed to ask on cross. You can call the witness later on direct in your own case, but you kind of can't just go into other areas. And then when you have redirect is only supposed to be within the scope of the direct. So of the cross. So the cross then becomes the guardrails for the redirect, and then the redirect becomes the guardrails for the recross, if there is a recross. So it's supposed to be a narrowing of topics, not an expansion of topics, and that's what that objection means.
So now that you've defined that for us, thank you, but let's talk about why strategically both sides would continue to repeat the same objection to the point where it seemed like Dan King was asking that objection or making that objection for nearly every question that Mr. Brockler asked.
Well, because Dan King thought that the questions that George Brockler were asking were questions that were not proper cross-examination questions. I mean, there are rules, and the rules are you get to ask on cross what they talk about on direct. If you want to call this doctor back, if you wanted to call this doctor in your case in chief, you should have, but that train has left the station. Now, could Brockler call him back in his rebuttal case? Yeah, that's theoretically possible. So Dan King is trying to hold George Brockler to the rules of procedure and vice versa. And in terms of the sort of incessant objections, everyone gets annoyed with objections, but don't forget, and we've talked about this before, it is your obligation as a lawyer to make contemporaneous objections when you believe you have a good faith basis for doing so. Now, what you tell trial practice students are just because you can object doesn't mean you should object. Everything you do in a courtroom you are supposed to do for a reason and for a purpose. But in defense of the defense, when you have a client who the state is trying to put to death, and every single thing is going to be scrutinized to and including your own performance as a lawyer, if there is a negative verdict, then you are going to err on the side of caution, and you are going to make the record every single time you believe that you need to. Because, again, if you don't make the objection contemporaneously, you lose it, and no lawyer wants to be questioning what they did or what they didn't do in any case, let alone in a death penalty case. So the stakes are higher, and therefore this attention to every single little objection. There may be objections that in another case they wouldn't have lodged, but in a death penalty case, you're going to make those objections, and you don't care You don't care, and you cannot afford to care if you're upsetting the jury, because your first obligation is to the client and to saving the client's life.
All right, Rick, well, thank you. Now, if we can, and I'll remind you and our viewers that we are waiting to go back into the courtroom. The camera is currently still on the Colorado Courts logo, the seal that we see when the camera is turned off at the court's side. But we're expecting the courtroom to reconvene. Ms. Nelson had something to say to the court. She started to say, this is awkward or this is embarrassing, and then the judge suggested a 5-minute break. So what is this going to be? We don't know yet, but we'll keep talking to you, Rick, if you can stick with us for a minute. Let's talk about scheduling, because that was the latest thing. That was the way that they ended the day prior to this little recess. But specifically, they talked about maybe stretching into Thursday or Friday. Oh, you know what, Rick? We'll come back to this question because court is resuming, and so we're going to flip the switch and return you to the courtroom for whatever it is the defense had to say.
Holmes, case number 12 CR 1522. The records reflect that Mr. Holmes is present with his attorneys, and the prosecutors are present as well. Mr. Orman?
Before we start on that other matter, I have a proposed court exhibit C-TR-82, which was the exhibit originally proffered as People's Exhibit 1258, if I may have that entered into the record.
Yes.
And one other question is, the jury's supposed to be here around 9 o'clock Monday morning. Do you want us here around that time, or do you want us here at the normal time?
9 o'clock, unless there's something that we need to talk about that you can tell me ahead of time, but it doesn't sound like there's anything, so you should get here at 9, please.
Thank you, Your
All right. And you can approach with that. And then would counsel please approach again? Thank you.
Ladies and gentlemen, we are sticking with this court signal through these bench conferences because the defense has something to say to the court, and we don't know yet what that's going to be. Ms. Nelson stood up earlier, said it was something awkward or embarrassing, and so we're going to stick with this to the end before we wrap up and review the schedule plans that were revealed by the defense and the prosecution just a few moments ago. We'll stay with you and, if possible, interrupt again as we wait for these bench conferences to be completed, and whatever motion or statement needs to be made, we'll have that get made. Ladies and gentlemen, this is the disembodied voice of Phil Tenser once again as we wait for these bench conferences and whatever announcement or motion or question the defense has for Judge Carlos Samore. Just wanted to review some of the items of scheduling that we heard a few minutes ago. Specifically, that the defense believes they are a little bit behind now. Things have been, as you know, going slowly. We've seen... Gosh, I always wonder what they're doing when they're up there, and especially when they're handing things around, what they're looking at or what they're seeing. Excuse me. The Dan King saying that he believes they could be pushing into Thursday of next week before they wrap up their case. We know that the prosecution does have interest in advancing at least one rebuttal witness, that Dr. Resnick, who they've referenced earlier in the case. The judge needs, he said, at least an hour for a hearing to discuss jury instructions. If everything works out, that could happen Friday afternoon, and the judge would get to keep his schedule of 9 a.m. Monday, July 13th, getting into closing arguments. If that's not the case, if that's not accurate, if there's a delay for any reason, it looks like we would have those closings on Tuesday. At this time, we are still planning everything for Monday the 13th to begin at 9 a.m. And I should mention, we're also beginning next Monday. There is no court tomorrow because it's the 3rd of July and it's the day off in honor of the 4th. But court will be resuming a half hour late on Monday to make way for a juror who has a job interview situation, and that, the judge has said, is going to start at 9 a.m. on Monday, and again at 9 a.m. the following Monday is the plan for closings. Following that, by the afternoon on the 13th, the jury could be in the deliberation room. We're expecting only about 2 hours per side for the closings, with a recess in between. That should add up in much the same way that it did during the opening statements. The jury will then have to receive these instructions, a list of, I believe it's up to 24 by now, or at least 23, and they'll have to be given those instructions. So the process itself is going to be longer than 4 hours when you add in the recess and the instructions on either end. Probably closer to 5.5 or 6 hours. But by Monday afternoon of the 13th, or the afternoon of Tuesday the 14th at the latest, we'll be seeing the jury, we'll be waiting for the jury's decision from the verdict room. Our fingers are crossed that this bench conference could be ending soon, and the defense will be making whatever statement they had, and in the meantime we'll turn the microphone off and wait with you for just a moment longer. Good afternoon, good evening once again. Phil here with Anika and Andrew. We are still hanging on a wire waiting for the defense to tell us what this awkward thing is, or explain what was going on earlier, why these long bench conferences. So don't think your eyes are fooling you. We are still live. We are still watching the courtroom camera. We are still waiting for this final statement or thought or motion from the defense, whatever it may be, before we wrap up the day and head home. Interesting to try to think about which attorneys are involved. Certainly it's of note that George Brockler is not up there. The district attorney is not up there in this conference, in this conversation. So trying in my own head to put into context, well, if Mr. Orman is up there, what were his specialties? His specialties have involved, in this case, testimony from the police and agents involved. Could there be something to do with an upcoming witness, some delay or problem that we're waiting to hear about? That is certainly a possibility, judging by the specialties of the attorneys involved in this conversation. What does that mean for us and the schedule that we were discussing earlier, that the court was discussing earlier? We're not really sure. I should also add, I just received a message. Our 7 News legal analyst who was helping us out and who we were going to talk to about the frequency of scheduling changes like the ones that may occur. It's an outside possibility at this point, but he has just informed me that he does have to leave for a scheduled appointment this evening. So we're going to wish him a happy 4th of July weekend and talk to him and his colleagues again next week. And Rick, if you're still able to hear us, we say thank you to you, and all of our viewers do as well, and have a happy 4th. Meanwhile, Andrew, Anika, and I are here waiting with you, glued to the screens, trying to find out exactly what's going on at the bench. We don't have any insights, and certainly if we turned up the microphone, we'd only have the same white noise that would wash over us when we turn it on for the streamer that you guys at home are watching. So we're keeping the sound down in our own headphones as well, and that's why I'm babbling aimlessly to fill the time. Make sure that you know we are live. We are waiting for whatever this awkward thought or statement might be. And we'll turn the microphone off again and rejoin you in a few minutes if this continues. Good evening, folks. Phil, Andrew, and Anika still here with you as we wait for this statement, announcement, motion, question from the defense, whatever it may be that they have us all hanging on here waiting for. We do appreciate all of you who are sticking with us. Wanted to say that since this is taking so long, we do have a chance, an opportunity to open the floor to you in the chat rooms for your questions. Anika, Andrew, and I can try our best to answer them. Anything that you might have about the course of this case so far, about the defense's progress, about the schedule, anything that you might have in mind, and we'll keep the microphone open for a few moments to try to respond to you verbally as we continue to keep this bench hearing up on your screens and the microphones muted so that you're not hearing that terrible white noise washing over your speakers. So do let us know if you have any questions about this trial. Again, we have tried to interpret what it might mean based on which attorneys are up at the bench. And, it appears they're coming back right now. Let's see what they have to say.
Is there anything else?
No, Your Honor. Thank you.
Anything from the defense?
Your Honor.
Okay. Thank you, folks. Have a good weekend. The court will be in recess. Thank you, everyone.
All right.
Well, there's four of us here, Marshall, Anika, Andrew, and myself, and none of us know quite what happened. Did you notice anything? No, none of us. So whatever this was, whatever this awkward thing was, apparently it was a private matter, and barring some kind of document release, which wouldn't happen until next week because of the holiday weekend, I think we just kept you around for a very disappointing ending to this week, this 42nd day of the Aurora movie theater shooting trial, and I guess I have to say that who knew? We'll obviously check with our sources and see if they can tell us what happened, but at this point, I don't know what to say. I don't know what we were waiting around for or why it was done in public court, but there it is. It's done, and the week is over. We're going into a holiday weekend now. July 4th, July 3rd and 4th, obviously, coming up. So tomorrow, the 3rd, no court in celebration of the 4th. Monday, a 9 a.m. start, so do keep that in mind. We're going to be turning our links on, our stream on a little bit later so that we don't record all of that blank space. But we'll be back to join you next week on Monday, and it may turn out to be the very last week of testimony in this long, extended trial. And closings to follow the week after that, either July 14th or, July 13th or the 14th at the outside. And so with that and our condolences for having stuck around only to be disappointed, we'll wish you a very happy and safe July 4th weekend. Do enjoy it, celebrate the nation, celebrate your families and friends, and we'll rejoin you again on Monday, but not at 8:30. We're going to start at 9 on Monday. So, we'll start at 8:50 on Monday. So we have 10 minutes to warm up to a 9 o'clock start. So 8:50 Monday morning is when we'll have our streams active and a recap to play for you. So good night, enjoy the weekend, enjoy the 4th, and we'll see you on Monday.